Good morning, everyone. Welcome to the Thursday, April 10th, 2025 meeting of the California Coastal Commission here in beautiful Santa Barbara, California. I'd like to ask Ms. Miller to please call the roll.
Commissioner Bochco. Here. Commissioner Eckerly.
Here.
Commissioner Escalante.
Here.
Commissioner Harmon.
Here.
Commissioner Hart.
Present.
Commissioner Kelly.
Here.
Commissioner Kounalakis. Commissioner Lowenberg.
Here.
Commissioner Nadoff.
Here.
Commissioner Turnbull Sanders.
Here.
Commissioner Kounalakis.
Present.
Commissioner Uranga.
Presente.
Commissioner Williams.
Here.
Commissioner Wilson.
Present.
Chair Cummings.
Here.
You have a quorum.
Okay. I'd like to turn it over to our AV staff to provide us the virtual meeting procedures.
All right. Good morning. This Coastal Commission meeting is occurring both in person and through Zoom. This meeting is also being webcast and can be viewed online at cal-span.org. If you have access to the internet and wish to watch or listen to the meeting only and not speak on an item, we recommend use the CalSpan website. Those who wish to address the Commission today can do so in person through the Zoom platform or by phone. Speaker request forms may be found on the Commission's webpage. Paper forms and a scannable QR code for paperless submittal are available on the Commission staff table just outside the meeting room. For those on Zoom, we have posted virtual hearing procedures on the Commission's agenda webpage, which is a guide on providing comments via Zoom or by phone. We will not be having a general public comment period today. Those speaking on a specific agenda item that is not general public comment are typically allowed 2 minutes to speak at the discretion of the chair. We will accept a request to speak on an item up until the chair opens the hearing on that particular item. If you have access to the internet, please go to the Commission's webpage and click on a link to fill out a speaker request. If you do not have internet access or prefer to testify by phone, please call the Commission staff at 562-477-9089. Again, that number is 562-477-9089. Staff will provide you with a telephone call-in number and instructions for how to participate and provide testimony by phone. We will manage speakers coming in and out of the meeting through a meeting organizer. When it is your time to address the Commission, the organizer will invite you to turn on your video and microphone or provide instructions on how to unmute yourself on the phone. Chair Cummings, that concludes virtual hearing procedures.
Thank you very much. I'd like to ask our counsel to report out a closed session.
Thank you, Chair Cummings. At the end of the day yesterday, the Commission met in closed session. It received litigation information and advice regarding the following cases: Grossman versus Coastal Commission, Space Exploration Technologies Corporation versus Coastal Commission, City of Fort Bragg versus Mendocino Railway, and City of Marina et al. Versus Coastal Commission. That concludes my report.
Thank you very much. I'd like to ask if there's any changes to the agenda for today.
Yes, and good morning, Chair Cummings and Commissioners. I will now go over those changes to the agenda. First, item 10, that's the County of Santa Barbara LCP amendment for the SB 423 Streamlined Ministerial Approval Process Ordinance. That item is moved to consent. Item 10B, the City of Malibu LCP amendment for the Natural Disaster Rebuild provisions is moved to consent. Item 14A, the City of San Buenaventura Public Works CDP application, moved to consent. Item 15A, the application by Via Escondido Holdings LLC and Mountains Recreation and Conservation Authority, or MRCA, is postponed. And item 18A, the CDP application by the applicant named Jabour, is moved to consent. That concludes our changes to today's agenda. I would also note that there is no general public comment today to allow for the large number of expected public speakers for our enforcement item this morning. The Commission will be taking general public comment tomorrow morning as usual. So that brings us to item 5, the administrative permits for all districts on the agenda today. We're not aware of any opposition to the 2 administrative permits being reported, and we're asking whether 4 or more commissioners object to the approval of the administrative permits being reported today.
Thank you very much. Is there anybody signed up to speak on these items?
We just have one available for questions.
Okay, are there any commissioners that have ex partes? Seeing none, are there 4 more commissioners who object to the staff's recommendation? Seeing none, commission concurs. And that moves us on item number 6, consent calendar. I'll turn it back to staff.
Thank you. We have no items on consent, but we do have items that are being moved to consent for item 7. And item 7 is for all the applications for all districts on the agenda today that are moved to consent. As mentioned during the agenda changes earlier this morning, there are 4 items that we're recommending be moved to consent calendar, and those are item 10A, the County of Santa Barbara LCP Amendment Time Extension. 10B, the City of Malibu LCP Amendment for Disaster Rebuilds. Item 14A, the City of Ventura CDP application, and item 18A, the Jabour CDP application. I would just like to note that although item 10B, the City of Malibu's LCP amendment, is being processed as a minor amendment, and we are recommending this be moved to consent, this is an important amendment to the City of Malibu's Certified Local Coastal Program, and your staff worked very closely and quickly with city staff to modify their existing regulations and permit procedures to facilitate and help streamline the process for rebuilding structures damaged or destroyed by natural disasters by providing for additional exemptions and waiver processes for development that does not already qualify for a waiver under the governor's recent executive orders. I would also like to point out that the city's proposed changes to its LCP would not in any way supersede or modify any of those provisions of the governor's recent executive orders that exempt certain types of disaster rebuild projects from Coastal Act permitting requirements. And this amendment will simply help the city more efficiently respond to the recent Palisades fire rebuilding effort, as well as future disaster response efforts, while continuing to ensure coastal resource protection. I would like to thank the city for working closely with our staff to make the necessary revisions to the original draft language and to make this a better amendment and ensure a successful outcome. In closing, staff is not aware of any opposition to the items being moved to the consent calendar, and we're recommending that the commission vote and approve this item. I am available for questions.
Thank you very much, and I just want to thank you for the staff for all their hard work with the City of Malibu regarding their LCP amendments. So are there any ex partes? Seeing none. Are there any members of the public online who'd like to speak to us on this item? Are there any members of the public who'd like to speak to us on this item?
Yes, we have 2 people who wish to speak. First, for item 10A, move to consent, we have Susan Kirks on Zoom. Susan Kirks, when you're able to, please unmute yourself. Second. All right, I'm not seeing you being able to move in as a panelist. I'm going to try to unmute you as an attendee. Susan Kirks, you should be able to unmute yourself right now. Oop. Try again. There you go.
Thank you, and I apologize to the commission and staff. This is an error. I am actually signed up to speak on 11A, and this was my error in signing up yesterday. Thank you.
Okay, thank you. We'll call you then. And then in person, we have for item 10B, move to consent, Tyler Eaton.
Thanks, Chair Cummings and members of the commission. My name is Tyler Eaton, Principal Planner with the City of Malibu. Mr. Hudson summed it up really well, and we just wanted to say on behalf of the city, very appreciative for all the hard work you commissioners put in, your staff put in. You all came to our aid in a very expeditious manner. I've seen a lot of familiar faces, and our mayor and our council were very appreciative of the opportunity to speak with you guys and for you all to come and see our city. So it's not the first time you all helped us. Mr. Hudson also and his staff helped us with the Woolsey Fire amendments as well. And we're just appreciative for the continued partnership we have with the commission. And we're available for any questions if you have any. Our city attorney is also online.
Great, thank you so much.
Thank
and
you.
And just want to extend, we're always here to help, and we appreciate the openness to work with you all, and look forward to working with you in the future.
Thank you. There are no more speakers on items moved to consent.
All right. With that, I'll bring it back to the commission, see if there's any questions, comments, or movement of consent.
I'll move consent, Chair.
Second.
So motion by Commissioner Harmon, seconded by Commissioner Kelly. Is there any objection to unanimous approval of the consent agenda? Seeing no objection, consent agenda is approved. With that, we will move on to our item of the day, which is our enforcement item, and I'll turn it over to staff to introduce this item.
Thank you, Chair Cummings and Commissioners. Just give us 1 second to switch seats. Staff is now ready to present agenda items Thursday 8.1, 8.2, and 8.3, which share a single combined staff report, and we're ready to have you announce the matter.
Sorry, give me 1 second.
I should have given him a printed copy. I made one for him, but...
We'll now consider agenda items Thursday's items 8.1, 8.2, and 8.3, which share a single combined staff report, including proposed consent cease and desist order number CCC-25-CD-01, consent restoration order CCC-25-RO-01, and consent administrative penalty number CCC-25-AP3-01. The orders are all proposed to be issued to Sable Offshore Corp regarding properties, various locations along and around the existing Los Flores pipeline, CA-324 and CA-325 within the coastal zone between the Gaviota Coast and the Los Padres National Forest in Santa Barbara County, as well as offshore locations in state waters. Will the alleged violators and/or its representatives identify themselves for the record?
Chair Cummings, before he does, if I could just jump in for one moment. I
Sure.
believe you referred to the orders as consent orders, which may be a force of habit since so many of our orders are consent, but this one is not actually consent, just for the record.
Okay, thank you.
Good morning, Chair Cummings. DJ Moore on behalf of Sable Offshore Corp, outside counsel.
Good morning, Chair. Steve Rush, Vice President of Environmental and Regulatory Affairs for Sable Offshore Corporation.
Yeah, thank you very much. Staff, can you please identify what items are already part of the record?
Yes, thank you, Chair. The record consists of the contents of the staff report and its attachments, the addendum, which we posted yesterday, which contains letters from the public, a letter in support of the staff recommendation from Senator Limon, and a letter from Assembly Member Hart, a letter from Commission staff to Santa Barbara County regarding dispute resolution, a 98-page letter provided by Sable late last Friday evening, as well as a brief staff response, the public documents in the violation file in today's hearing. I would note that also in the record is a response from the county we received late yesterday reiterating their position, but it was too late to put in the addendum.
Thank you so much. And staff would like to ask how long you will need for this presentation.
50 minutes, please.
Okay. There should not have been any ex parte communications, but do any commissioners have any such communications to report? Okay. Seeing none, I will now review the rules for this proceeding. Oh, sorry.
Actually do. I just received the update from the same letter that was referred to by Ms. Hagee from a public comment from Jana Zimmer. And I got a note that said, I cannot get the CCC ex parte to work. If you want to talk about this, call me or something like that from Jana Zimmer, but I did not speak with her.
Through the chair, that letter is part of the administrative record and was posted as a part of the addendum last night.
Okay, thank you. We'll now review the rules for this proceeding. Staff has asked for up to 15 minutes for this presentation, so I'll give the alleged violators the same amount of time. They may also request to reserve some of that time for their own rebuttal. After any presentation by the alleged violator, we will allow 2 minutes for any other party who would like to speak as an interested member of the public, after which the chair may allow the alleged violator to use any reserved rebuttal time to respond to comments from interested persons. Staff then typically responds to the testimony and any new evidence introduced. Anyone who speaks at this hearing may propose questions, either orally or in writing, that they would like the commission to ask of any other party. But it is not appropriate to suggest questions to be asked to yourselves. Commissioners may, but are not required to, ask the proposed questions. And I'll also mention that given the number of people here and the number of items that are on the agenda, there may be a point in time when, after comments become repetitive, that we're going to reduce time such that we have enough time to get through all of our other items that we have on our agenda for today. And so with that, we will now begin with the public hearing with the staff presentation.
Thank you very much, Chair. The matter before you today pertains to several ongoing and extensive Coastal Act violations undertaken by Sable Offshore Corporation, which today in our presentation we will call Sable for short, at various locations along existing crude oil pipelines on the Gaviota coast in Santa Barbara County, as well as in offshore sections of related oil and water pipelines located within state waters offshore. These violations have adversely impacted and continue to impact coastal resources as a result of Sable's refusal to comply with the Coastal Act. We apologize for the number of exhibits that were included in the staff report and addendum, but wanted to make sure that we included all 8,000 pages of Sable's statement of defense, including extensive exhibits, as well as an additional 98-page letter they sent us on Friday. We want to note that their late submittal from Friday is not properly part of the record, since it violates the clear language of the regulations which precludes submittal of defenses after the deadline for doing so. And this lengthy late submittal is precisely the sort of thing our regulations were updated to prevent. However, for completeness, we nevertheless provided an abbreviated response in the addendum and did provide that letter to you. As you know, enforcement staff work very hard to try to resolve all of our cases. We resolve the vast majority of our cases informally at the district level without any penalties and without requiring a hearing before you. In the remaining cases that are elevated to our headquarters unit for more formal action, we still bring the vast majority of these cases to you in the form of consent orders. As we will discuss, Commission staff began working on this issue in September of last year, and since that time have spent an inordinate amount of time trying to resolve this matter consensually. In a very small subset of our cases, we're unable to do so, and we were unable to do so here. Next slide. Next slide, thank you. Go back, please. Thank you. The scale of the work Sable has taken is extensive in both its scale and the resources affected. The work spans across at least 136 different development sites along a 14-mile stretch of coastline. The images in this slide, which were taken less than a week ago on April 4th, help to show the size and scale of the project. Because of the sheer scale of the work Sable conducted, these activities could amount to hundreds of violations. But in an attempt to be conservative, we've grouped the number of violations into 4 violation categories. Sable undertook a number of activities which we will discuss further, but they include excavation with heavy equipment, removal of major vegetation, grading and widening of roads, development within and adjacent to wetlands, placement of concrete fill on the seafloor, and a number of other activities, all undertaken without a coastal development permit. The violation is large in scope and significant in impact. Not only did they do work in sensitive habitats and without sufficient environmental protections and during times that sensitive species were at risk, but they also refused to comply with orders issued to them to address those issues. Specifically, Sable has refused to comply with the terms of an executive director cease and desist order issued by Dr. Hucklebridge in February. This order was the second issued to Sable, and it directed Sable to cease all work within the coastal zone and apply for coastal development permits for both work already undertaken as well as any future desired potential development. The order was intended to ensure that any development work approved was done in a protective way, and that it was done in a time and a manner with the least adverse impacts to coastal resources. Instead, they ignored the order and its terms and went ahead with the work they desired without such conditions and oversight, as you will hear. I would like to note that as a framework for today's action, that protection of the coast relies on entities complying with the Coastal Act and working collaboratively with permitting development in a way that protects coastal resources. There is simply no precedent for this kind of direct disregard for legal orders issued under the Coastal Act. The entire coastal regulatory scheme, like many other laws, and in particular environmental laws, depends in large part on the good faith of regulated parties to comply with the law. The legislature, based on the voter initiative, placed a high value on protection of coastal resources and charged the Coastal Commission with implementing permits for development in coastal areas in such a way as to protect those resources. And the vast majority of people and companies in California do just that. They follow the law. Parties who evade that process and those protections, undertaking work even after being informed of the need for protective measures and permits, put our coast at unnecessary risk. This case is an excellent example of why the permits and Coastal Act enforcement are critical. The recommended orders before you today would require Sable to immediately cease any further development, to obtain Coastal Act authorization for the development already occurred and for any future proposed development, restore areas that were already impacted by the unpermitted development, and to pay an administrative penalty under Section 308(21.3) of the Coastal Act. The presentation today will be given by Stephanie Cook, an attorney in our enforcement team, Alex Halperin, our Deputy General Counsel, and Cassidy Teufel, who's the Director of the Commission's Energy Division. First, I'll turn it over to Ms. Cook.
Thank you, Lisa. Good morning, Chair and members of the Commission. Next slide, please. Throughout our presentation, we will show you several images like the one you see on this slide, showing the unpermitted development undertaken. Well, at least I got a notice. I'm glad you're all listening so closely. So, as I was saying, throughout our presentation, we will show you several images like the one on the screen today. And these images will show you unpermitted development undertaken by Sable that amounts to a total of 9 separate violations. Sable dug dozens of excavation pits, such as this one, at their many work sites. This specific pit is on a steep slope with little to no resource protective measures. The activities undertaken arguably amount to a full rebuild of certain sections of pipe, not just minor measures, as they will say to you today. The excavations total over 3.7 acres, not including access roads or staging and stockpile areas that were created, and removed about 72,000 cubic yards of soil. Work on over 12 sites within Gaviota State Park has yet to begin. That work would excavate an estimated 14,000 square foot of ESHA and require grading up to 3 miles of access roads within sensitive habitat and across scenic ridgelines within the state park. In addition to the details as to the scope of unpermitted development Sable has undertaken, you will also hear us talk about the exhaustive resources that staff have spent to resolve these violations. We've repeatedly directed Sable to apply for coastal development permits, both for after-the-fact work already taken, regardless if completed, as well as any future planned work. However, Commission staff have been continually met with Sable's continued refusal to comply with the Coastal Act. Next slide, please. Here you can see on this slide the Santinez unit. It's an oil and gas production facility currently owned and operated by Sable. The unit is made up of 3 offshore platforms, Hondo, Harmony, and Heritage, and you can see those platforms circled in yellow on this slide. These platforms are embedded in the seafloor and each support up to several dozen individual oil wells that extend out from the platform and extract oil and natural gas from below ground deposits. That oil and gas is then transported from the offshore platform back to the shore to the Los Flores Canyon processing facility, which you'll see circled in green on this slide. You can also see an offshore portion of the pipeline, which is in blue. This offshore pipeline travels through state waters before ending at the processing facility near El Capitan State Beach. After initial processing at the Los Flores Canyon facility, the oil is transported by pipeline to refineries outside of the coastal zone. And I'll note that this transport pipeline transits along the Gaviota coast, parallel to Highway 101, and referred to as Line 324. Importantly, I also want to note that Line 324 is the same pipeline that ruptured in 2015, as we'll discuss later in this presentation. Next slide, please. I also want to quickly give a brief overview of some of the flora and fauna in this area to further demonstrate why these violations are important. Based on information from Sable, there's at least 136 work sites, 58 of which are in federal designated critical habitat, and 13 are in close proximity to 4 creeks that support the Southern California steelhead, which you can see on this slide. You can also see other protected species that exist in the area, including the red-legged frog, which is listed as threatened under the Federal Endangered Species Act, as well as the dusky-footed muskrat and the southwestern pond turtle, both listed as California species of special concern. It's important to note that none of these species had been recognized with protective designations when the pipeline was originally permitted, meaning that impacts to them were not considered and mitigation measures were not provided for their lost or damaged habitat. Next slide, please. Next, I want to highlight some of the sensitive vegetation onshore at the sites where Sable undertook unpermitted development as well. This area contains several types of vegetation, including lemonade berry scrub, coastal live oak, red willow, and coastal sage scrub, as you see here. All of these make up environmentally sensitive habitat areas. Next slide, please. You can see on this map the location of the habitats for the Gaviota tar plant, a plant that is listed as endangered under the Federal Endangered Species Act, as well as critical habitat for the red-legged frog and the southern steelhead, which we just saw. While it's hard to see on this map, it's kind of tiny, but all of the dots along the pipeline are work sites, and you can see they're all located within and around these critical habitat areas. Next slide, please. Again, the scale of this project is very large. This slide shows a map depicting the route of the pipeline in purple, with the coastal zone boundary in blue and a dark blue color above. And hopefully it gives some perspective as to the extent of the pipeline. For scale, it's kind of tiny on here, but you could see Refugio Beach is down to the right and Gaviota's to the left. Those small yellow dots represent significant oil pipeline corrosion spots, which Sable will refer to as anomalies. As we mentioned, there are approximately 136 of these locations, and the small blue dots also represent sites where large shutoff valves were installed along approximately 14 miles of the Gaviota coastline. Although initial estimates based on limited information provided by Sable indicate that nearly 4 acres and 70,000 cubic yards of soil have been excavated as part of its campaign to rebuild the pipeline, the unpermitted grading, trenching, wetlands, fill, and other unpermitted development goes well beyond these numbers. This is in part due to additional excavation for access routes and staging and stockpile areas. Sable has also undertaken work which extends well beyond the coastal zone, though we're only discussing the sites within the coastal zone today. Next slide, please. By way of background, we also want to talk about the significance of the history of this specific location, as well as Line 324, as I mentioned previously. This location is the site of the Refugio beach oil spill, which, as many of you know, caused tremendous damage to coastal resources. You can see on this slide the oil spill occurred near Refugio Beach and affected approximately 120 miles of coast. We want to note this spill occurred prior to Sable's ownership, but involved the same.
Did I do that?
If anyone is logged into Zoom on your phone, potentially, please log out.
I got it. I muted.
We're good.
As we were saying, we want to mention that this oil spill did occur on the same pipeline, and I wanted to explain that when the spill occurred, a portion of the corroded pipeline ruptured, which released about 123,000 gallons of oil into the surrounding coastal environment. I'll also note that the pipeline ruptured onshore, then flowed outward toward the coast and onto the beach. Next slide, please. The spill, as many of you know, had a very severe effect on the coast, negatively impacting wildlife and ecosystems and requiring hundreds and millions of dollars of cleanup costs. The spill also prevented access to the coast, resulting in a loss of an estimated 140,000 user beach days or recreation days for the members of the public between Santa Barbara, Ventura, and Los Angeles counties. The impact of the spill was extensive and has taken many years to address. And although it's been over 10 years, implementation of many of the mitigation efforts are only just beginning. As a result of the spill, all production at the Santa Ynez unit was halted in 2015, and the pipelines have remained offline and out of service since that time. Inspections of the line inspections that occurred after the spill revealed that it was riddled with corrosion. Locally, some have referred to this as Swiss cheese, indicating that if it had not ruptured at Refugio, there were at least 100 other locations that would have ruptured. Before going into greater detail as to the enforcement actions that I want to discuss with you today, which lead to the orders we are recommending, Deputy Director of the Commission's Energy Division, Cassidy Teufel, would like to provide some additional background and context.
Thank you, Ms. Cook. As you heard earlier from the Commission's Chief of Enforcement, we've gone to great lengths over the past several months to try to avoid the situation we find ourselves in today. As soon as we learned back in September that Sable was undertaking work on its pipeline, I reached out to Santa Barbara County Energy Division staff to understand the scope of work that was planned and the status of coastal permitting. We have a long and productive history of working and coordinating with county staff on energy matters, keeping each other apprised of upcoming projects and openly discussing policy questions. It was therefore very surprising to be informed that the county was aware Sable's project was underway, and it was to include over 130 individual work sites throughout the coastal zone, as well as the restart of Santa Ynez unit operations, and that no coastal development permit had been issued. Further, neither the county nor Sable had provided any advance notice to commission staff or other state natural resource agency partners. Given the scale and significance of the project, this information was completely shocking. Next slide, please. Over the following months, we tried again and again, a total of 7 separate efforts, to get the county to explain to us why this massive, controversial project with such high potential for coastal resource damage was proceeding without permits. While county staff eventually conveyed to us that it supported Sable's position that the work was authorized nearly 40 years ago through the coastal development permit issued for the initial construction of the pipeline, it has consistently ignored our request to demonstrate where in that 1986 permit the current work campaign is described, analyzed, and authorized. Without help from the county, though, we've thoroughly evaluated the old permit ourselves, reviewing it and its associated environmental documents shown here, and have found no evidence in support of the county and Sable's position. In fact, the more information we've gathered on the scope of the project, the more clear it's become that it couldn't have been contemplated or authorized by the county's 1986 permit. Next slide, please. Considered in total, the project far exceeds the simple repair and maintenance that Sable describes it as, and would be more accurately characterized as a wholesale rebuild and replacement effort. Sable has excavated and reinforced or replaced the line at more than 130 separate locations along its roughly 14-mile length in the coastal zone, in some extended stretches, leaving behind barely any in its original condition. In addition, the type of work being done, which includes permanent removal of the insulating layer on the outside of the line, which was a critical feature of the original design, would have been unheard of in the original permit. Removal of this insulation from so many sections of pipeline, totaling over a mile of the line's total length in the coastal zone, directly conflicts with the line's original design and configuration. While Sable has stated that the current work is the same as work carried out on the line for the past 30 years, for this to be true, the original design and permitting of the line would have had to assume a comprehensive failure of its corrosion protection strategy and a catastrophic simultaneous degradation of the line across its entire length. While it may be the case that individual spot repairs were completed on the line in the past, nothing close to the scale of the current campaign was attempted or carried out. In fact, the current project represents the single largest pipeline rebuild and replacement effort ever pursued along California's coast. Based on information from Sable, it has excavated over 3.7 acres across its work sites in the coastal zone and an estimated 72,000 cubic yards of soil. Considering the additional area of habitat removal and disturbance for access roads and staging areas and stockpile areas for the work sites, the cumulative impact of the work is significantly greater. While much of the work Sable had planned has now been completed, what remains is likely to be some of the most damaging to coastal resources. Next slide, please. For example, the proposed work in Gaviota State Park includes over a dozen sites within designated critical habitat areas and coastal sage scrub and oak woodland ESHA. The excavations alone would remove an estimated 14,000 square feet of ESHA, and development of access roads to these sites could result in the removal of habitat and major vegetation along as much as 3 miles. Much of this area has been untouched since the initial construction of the pipeline in the early 1990s, and it includes some of the state park's most prominent and scenic ridgelines, as shown in this image. The primary reason for all the work Sable is pursuing is that the corrosion prevention strategy integrated into the original pipeline design has spectacularly failed, as shown by the 2015 oil spill and the more than 130 other points of pending rupture within the coastal zone. In fact, the pipeline's originally approved corrosion prevention strategy is now being scrapped entirely. Sable recently submitted a proposal to the Office of the State Fire Marshal called a State Waiver Request to develop and implement a new and different corrosion prevention strategy from what was evaluated originally and approved with that original pipeline. In recent correspondence, the State Fire Marshal has rejected Sable's proposal as inadequate and identified a list of no less than 67 additional measures that would need to be included for it to be effective. Considered cumulatively, these 3 elements, the massive rebuild and replacement effort, the alteration of the pipeline's original design through the intentional removal of insulation, and the development of a new corrosion prevention strategy, amount to significant deviations from what was originally considered and authorized by Santa Barbara County nearly 40 years ago. Therefore, not only does the county's original permit not describe, evaluate, or authorize the current work, it couldn't have, since the type of work Sable is carrying out is fundamentally inconsistent with the original design and operation of the pipeline. Moreover, many of the sensitive coastal resources along the pipeline route, cultural resources, and the federally and state protected species Ms. Cook described earlier, were not identified or considered in the original permit. Now, Ms. Cook will give you a detailed history of the enforcement actions staff has pursued.
Thank you. Next slide, please. So Sable purchased the entire Santa Ynez unit in a purchase agreement that was finalized in February of last year. As early as September 9th of last year, if not before, Sable began undertaking unpermitted development activity at locations onshore along the pipelines. And although staff have received images that could date back as early as June of last year, we've tried to take a relatively conservative approach for purposes of calculating the administrative penalties, which we'll discuss in more length later. But we considered the start date for the violations to be in early September. Again, I know it's hard when we're in this room to think about the massive scale of this project, so we show you a lot of images today that hopefully convey that. But as you can see on this one, there's numerous construction vehicles and other equipment that will be utilized in this massive project. And notably on the left side, you can see the staging of many pieces of pipe replacement section. Next slide, please. When Commission staff first learned of Sable's unpermitted development, we alerted Santa Barbara County Planning and Development staff of these activities through email. And in this email, Commission staff also requested that the county take formal enforcement action. Commission staff noted that they would assume primary enforcement jurisdiction if the county failed to take timely action as provided in the Coastal Act, or if they requested that the Commission take lead on enforcement action. The county responded to say that they would look into the matter, but no further response was received. We'll discuss Sable's defenses later today, including an assertion that the county has jurisdiction of the issue and therefore the Commission's actions are improper, but this is not the case. Staff followed the steps set forth in the Coastal Act, which specifically provide a mechanism for instances when the local government does not or will not take enforcement action. Here, the county declined to act. Next slide, please. Since September of last year, we've had dozens and dozens of communications with Sable. We've issued notice of violation letters, 3 notices of intent to proceed with orders, 2 executive director cease and desist orders, and spent countless hours trying to resolve this case with Sable amicably through a consent order. Yet Sable has refused to work with us and continues to take unpermitted development activities up until through today, which is why we're here today. Next slide, please. It is also important to note that in our early conversations, Sable told staff in 2 separate instances that work had ceased when in fact it had not. In these initial conversations, a common theme began to develop, and which would continue throughout our interactions, to which Sable declined to provide full, accurate information and forced staff to spend extensive resources by displaying a willingness to comply with the Coastal Act while continually taking actions that seemed to indicate otherwise. Next slide, please. In this slide and the following slides, I want to share some images that will provide more context as to the scale of this project and the unpermitted development at issue. As you can see in these images, these pits required extensive excavation, resulting in large stockpiling of fill, as well as vegetation removal and grading in both areas around the pits, as well as for roads for access to the pits. In some instances, the replacement of metal plates and wetlands, which you will see later today, just so that equipment could access these sites. Next slide, please. In this image, you can see another excavated pit with an exposed section of pipe, presumably to be replaced. Next slide. Here's yet another large excavated pit, and in this one you can see waste and debris scattered alongside of the pit itself, and notably this is in a riparian area. Next slide, please. Here you can see yet another large excavated pit work site. Next slide, please. This image in particular gives perspective as to just how deep these excavation sites were and also the extent of vegetation clearance. You can notice in the background of this image extensive vegetation clearing that was done to create this work site. Next slide, please. Here you can see an excavated pit on a steep slope where potential for coastal resource damage and erosion would be considerably high. Next slide, please. Here's another image of that same steep slope, characteristic of similarly sloped areas where Sable excavated without erosion control or other protective measures in place. Next slide, please. This image was taken in October before the rainy season, and you can see there's an umbrella and a canopy placed over the pipe, presumably to protect those sections of pipe, but no protective measures against erosion. Next slide, please. As I mentioned here, you can see a metal plate that has been placed in a wetland area so that it could create a pathway for construction and vehicle traffic. Next slide, please. In this image, you'll see another metal plate placed in a wetland area. Next slide, please. As I mentioned earlier, the executive director issued an order addressing the unpermitted development activities onshore back in November. While it is our understanding that Sable ceased activities onshore during this time, we also understand that they quickly shifted their focus to offshore unpermitted development activities. On September 4th, the Commission's Energy and Ocean Resources staff spoke with Sable over the phone and learned that Sable intended to undertake unpermitted development at offshore locations on the pipeline. In this conversation and several thereafter, Commission staff were clear and direct in informing Sable that the offshore work was located in state waters, therefore in Commission's retained jurisdiction, and would require a permit from the jurisdiction. Sable has claimed that they were unaware that this work needed Coastal Act authorization, as evidenced, but this is clearly not the case, as evidenced in numerous communications during the time. Commission staff worked extensively to try and get Sable to apply for CDPs during this period of time, but were unsuccessful. On November 20th, Commission staff spotted this vessel offshore, which you can see circled in this image, and which I'll talk about more on the next slide. This vessel, which was apparently used to conduct the unpermitted development offshore, was located, as I said, offshore, and you can see on the right side of this slide a route map that shows, using AIS tracking, that the vessel went between the platforms and the shore numerous times that day. And on the left side, you can read another, just further demonstrating the location of the vessel on that day and at that time. Importantly, during this time, Commission staff were still having conversations with Sable about the need to apply for CDP for this work. In December, Commission staff received an email from the State Lands Commission indicating that Sable may have fully undertaken the work offshore, and therefore followed up with Sable with an additional email asking for a status update as to the work. Unfortunately, Commission staff did not receive a response to that email and did not actually hear anything back until January 15th, when Sable's counsel sent an email saying the work had already been completed. Next slide, please. On February 15th, staff sent a notice of violation to Sable addressing the offshore work. The unpermitted development addressed in this letter consisted of placement of burlap bags filled with sand and cement along the seafloor, which you can see in this slide. I share this image to demonstrate both the extent and size of these bags, but also to address the materials contained within. The mixture is extremely problematic because cement can leach toxic substances, negatively affecting water quality. This is the kind of impact that would have been addressed in a full CDP process. It should also be noted that while Sable claimed after the fact that the work was authorized by a permit the Commission issued to Exxon in 1988, staff refutes this claim and finds no indication in that old permit that it pre-authorized future development of this kind that Sable carried out. Next slide, please. On February 14th, Commission staff received a letter from the Environmental Defense Center requesting that staff review the county's determination regarding Sable's onshore activities, which the county had asserted in a February 12th letter. In response, on February 16th, staff provided the county with a letter stating, pursuant to our regulations, the executive director was initiating a formal review process by requesting a copy of any CDP applications submitted by Sable and/or its predecessors for the safety valve installation work on the pipeline, Sable's application for zoning clearance for work along the pipelines, as well as the county's determination on these matters, including the specific grounds for determinations, including permit files and records to which they relied on. On April 7th, staff sent a county a letter stating that the county had failed to submit this documentation supporting its claim that the unpermitted development was authorized by existing permits, and we concluded that no such documentation existed. Next slide, please. On February 14th, only 2 days after the county sent Commission staff this February 12th letter and merely 4 days after the expiration of the November EDCDO, Sable resumed unpermitted development activities onshore. During this time, Commission staff received several reports that Sable had ramped up their development activities, pushing their employees to work through the weekends and into the night to undertake extensive development activities as quickly as possible. Next slide, please. Here you can see an active excavator working through the night hours. This image was taken after the Commission issued their second EDCDO. And we want to note that while Commission staff worked nights and weekends in an attempt to resolve this matter as quickly as possible, so too were the workers on the ground. We'd like to acknowledge that they're also part of this community and working very hard to complete a project that they have been hired to do, and it is unfortunate that Sable is directing them to work without permits. We would also like to point out that Commission staff have continued to receive reports that this work is ongoing through today. In the next few slides, I'll show a few more images that are representative of the work that they have been undertaking since starting back in February. Next slide, please. As mentioned before, the areas where the undevelopment occurred are in critical areas for several reasons. From images that have been shared with the Commission and that we have shown today, it appears that some of this work is in and adjacent to ESHA and riparian areas and has the likelihood to support wildlife species that are rare and particularly sensitive to disturbance. On this slide, you can see a western pond turtle swimming in a pool. The pond turtle is a California species of special concern and candidate for federal protection due to its rarity. This image was provided to Commission staff with accompanying information stating that the turtle was spotted swimming in a pool located directly below an excavator. Next slide, please. This image on the left shows the southern steelhead, which I mentioned earlier today. On the right, you can see the steelhead swimming in the same pool that was on the previous slide, located just under an excavator. Next slide, please. At the start of this presentation, I discussed important plant and animal species located at the sites, and I want to take a moment here to note that in addition to the potential negative effects Sable's work created for those species, the timing of the unpermitted development is particularly problematic, as much of this development has been during bird nesting season, and as well as red-legged frog breeding season and southern steelhead migratory spawning season. You can see on this slide a white-tailed kite and a southwestern willow flycatcher, just two of the types of birds that could have been impacted as a result of Sable's unpermitted development activities. Without appropriate and necessary protective measures in place, including prohibitions on location and timing of development, all of which would have been typically found in the conditions of a normal CDP process, this work has a high potential to adversely impact these habitat areas. Next slide, please. Again, it's difficult to fully appreciate the scale, but another image here can help give some context. Here you can see more extensive construction equipment vehicles and several sections of pipe, again, all readily staged in February, quickly ready to resume operations. Next slide, please. Here you can see an excavator and a generator located on the bank of a creek. Next slide, please. In this image, you can see an excavator parked under an oak tree canopy. Next slide. This image shows a backfilled pit facing downstream with no erosion control measures in place, leaving the potential for rocks or sediment to be carried downstream and further into coastal waters. Next slide, please. Here's another excavator located in several oak trees. Next slide, please. In this image, you can see extensive vegetation removal. Next slide. This image shows another ineffective installation of erosion control measures at a work site. Next slide, please. And here again, you can see extensive damage to vegetation, specifically disturbance of coastal sage scrub habitat. Next slide, please. In this image, which was shared with Commission staff only last week, we can see an active work site. Next slide, please. This slide shows the statutory authority for issuance of cease and desist and restoration orders. The jurisdictional elements for the Commission to issue these orders has been satisfied. Sable undertook development as defined in the Coastal Act, and no coastal development permit was obtained. The unpermitted development is clearly inconsistent with the Coastal Act. If left unaddressed, it'll continue causing resource damage. Next slide, please. I also want to take a moment at this time to acknowledge the important cultural significance of these lands, and yet another critically important reason why coordination with Commission staff on this type of large-scale project is so important. In submitting a CDP application, staff would have directed Sable to include several measures to protect these culturally sensitive areas. Human activity along the Gaviota Coast dates back over 9,000 years. The Santa Barbara coast has become fairly heavily populated between 954 or 1542 AD. By the time of European contact, several Chumash villages had already been established at the mouths of major watersheds along this stretch of coastline. Over 1,000 archaeological and historic sites have been documented on the Gaviota Coast, and due to limited amount of development, many of these sites have retained a high degree of integrity. It is therefore likely that if the Commission had been given the opportunity to review Sable's work, any such permit would likely have contained a suite of elements that are designed to avoid, and if avoidance was not possible, mitigate impacts to cultural sensitive resources, as well as mandate the presence of a cultural monitor to ensure that the work was done in an appropriate manner. Instead, the Commission was deprived of this opportunity to ensure the cultural legacy of these sites was handled with integrity, as is mandated by the LCP in Section 30244 of the Coastal Act. Next slide, please. The Coastal Act authorizes the Commission to impose an administrative penalty for violations of the Coastal Act for up to $11,250 per day, which is intended to encourage rapid resolution of violations. In this case, Sable is in violation of the Coastal Act because they have undertaken development without Coastal Act authorization and further have continued to do so through today. Thus, there is a basis for the administrative penalty here, as described in greater detail in the report. Next slide, please. I realize this slide is small, but this is also located in the staff report for you to refer to, and I want to note that the staff has attempted to assess penalties in a conservative manner. We looked at the number of violations, the type of violations, the severity, and the number of days. We discussed this in length in the staff report and grouped the violations and counted each type of violation as one violation. As you can see in this chart, we evaluated the violations under the criteria in 30820C and proposed some violations get a mid penalty of $7,000 per day and some with a higher penalty of $11,250 per day. Next slide, please. Section 30821 provides for 5 factors in determining the amount of civil liability, which we have covered extensively in our report, but I'll summarize them briefly here. First, these violations clearly impacted coastal resources extensively. Second, the violations are ongoing, and while they can be remedied, they are various, and some may require more extensive remediation efforts than others. Sable continues to decline to provide detailed information as to the full extent of the damage to coastal resources, and therefore it makes it unclear just how extensive those efforts might need to be. Third, as I've mentioned, the timing and location of these activities affect several sensitive plant species and critically listed animal species. Fourth, Sable has cost the state much more than if they had just applied for a CDP as they were required to do. Staff resources have been exhausted thoroughly, as we've discussed here today. Fifth, despite continued communication with Commission staff, Sable undertook unpermitted development at multiple locations with no CDP. They have not remedied these violations. The onshore work continues despite a validly issued cease and desist order, and in sum, these factors weigh heavily towards a moderate to high penalty. Next slide, please. In an attempt to make this resolution as efficient as possible, limiting the cost to the state and increasing the potential for quicker restoration and reduced impacts on resources, staff have recommended a somewhat creative solution. If Sable elects to proceed with a consolidated CDP application, the administrative penalty would be reduced by 10% of the total amount as seen on this slide. If, however, at any point prior to the Commission staff filing the CDP application as complete, Sable takes any steps that would interfere with the processing of a CDP application, including any attempt to delay or avoid submittal of the CDP application, the penalty amount shall not be reduced, and Sable shall be required to pay the remaining penalty amount to bring the full penalty up to $14,987,250. As recommended by staff. Now, Deputy General Counsel for the Commission, Alex Halperin, will explain a few responses to Sable's many arguments.
Thanks. Sable submitted a lengthy statement of defense raising many issues, but a few themes stand out, and I'll be addressing those. Sable's main arguments are, first, that the work Sable is performing on the pipelines is authorized by the original permits for the construction of the pipeline. Second, that the Commission has no authority over the work because of federal preemption. Third, the Commission lacks jurisdiction over the work for various other reasons. And fourth, that the work is actually beneficial and therefore shouldn't be prohibited, and Sable shouldn't be subjected to any sort of enforcement for engaging in that work. And I'll address each of those arguments in turn. Next slide, please. First and probably foremost among Sable's arguments is the argument that the current work was anticipated, analyzed, and authorized excuse me, in the various documents listed on this screen. Next slide. Thanks. You'll notice that all of these documents are from the 1980s. I don't mention that to suggest that old permits aren't valid. Those permits still provide the necessary authorization for the structures that they allowed to be built and that continue to exist today. But the idea that a permit from the 1980s for the construction of a pipeline was intended to authorize the replacement of large portions of that pipeline 40 years later, and all the ancillary earth movement and other work necessary to achieve that, or that it was intended to authorize upgrades to the pipeline based on technologies that didn't even exist when the permit was granted, is an entirely different matter. Commission staff has reviewed all of these documents, and while there are some references to maintenance and even requirements to maintain the integrity of the pipeline to prevent ruptures and spills, that's very different from saying that the work necessary to achieve that, whatever form it may take and for all time into the future, is fully authorized in advance such that it isn't subject to any further review, even as to the methods used. And in fact, none of these documents says that maintenance work was being pre-authorized, nor do they discuss or envision work at the scope and scale of the current project. Even assuming that it would be possible to predict this level of work and approve this far in advance, at a minimum, that would have needed to be made explicit in the permit, yet nowhere in the project descriptions in any of these documents does it say that. Sable argues that such explicit authorization isn't required for work that they characterize as mere maintenance. But at the time the permits were granted, the Commission's repair and maintenance regulations were already in place, establishing limits on repair and maintenance exemption. Moreover, by creating exemptions for repair and maintenance work at all, the Coastal Act makes it clear that maintenance work constitutes development in its own right. Otherwise, it wouldn't need an exemption. And as a result, it therefore needs to be authorized as such, unless it meets the criteria for those exemptions. But again, the permits don't say that they were authorizing future maintenance work. As Lisa noted at the beginning of the hearing, on Friday afternoon, Sable's counsel submitted another 98-page letter, ostensibly responding to the staff report, but mostly re-arguing points that Sable had made in its statement of defense and making arguments that could have been made before, which, as Lisa noted, the Commission's regulations prohibit at this late date, specifically because it makes it impossible to respond effectively. Nevertheless, staff responded as much as time would allow, and in this new letter, Sable emphasized a procedural angle to this pre-authorization argument. Namely, that because much of the work is within the county's permit jurisdiction, and the county confirmed its view that the work was covered by the existing permits, this is really a dispute between the Commission and the county, and moving forward with the proposed enforcement action would usurp the county's delegated permit authority, and you'll hear a lot of these kinds of arguments from Sable today, I expect. It is true that the county and the Commission view the situation differently, and the Commission staff would have preferred to work this out with the county before turning to enforcement. However, on a practical level, the county and Sable did everything in their power to prevent that approach. And as a legal matter, the fact that the county as the permitting entity disagrees with the Commission staff doesn't preclude this action, and I'll address each of those points in slightly greater detail. Next slide, please. So as to the practical point, Commission staff tried to resolve this with the county administratively, but both the county and Sable insisted in the first two letters shown here that the county's action was not an exemption determination, and as such, it was not subject to review by this commission by way of appeal. However, the commission's regulations provide for another means of resolving disagreements between local governments and commission staff over the correct procedural treatment of a project. As Mr. Teufel mentioned earlier, so staff informed the county that we were initiating a review of the county's determination pursuant to section 13569 of the commission's regulations. However, the county essentially refused to engage with commission staff on this, insisting in this last letter that that process was also inapplicable. In fact, despite the numerous requests over the last 3 months, to this day, the county has not provided the information staff requested to allow this process to proceed or identified the specific bases for the conclusions in the county's original February 12th letter regarding where in the 1986 permit the current work is described, analyzed, and authorized. This and commission staff's review of the documents has led us to conclude that no such evidence exists. In the meantime, Sable, fully aware of the disagreement between the commission staff and the county, and of the commission staff's efforts to engage the county through the review process, decided to proceed with its work, leaving the commission staff with no other option other than to commence this formal enforcement hearing. From a legal perspective, the commission has disagreed with local governments before and has proceeded with enforcement even when a local government has declared that work was exempt. One example of this was the 11 Lagunitas matter in 2018, where the city of Laguna Beach insisted that work was exempt, but the commission disagreed and proceeded to issue enforcement orders, which were upheld by the courts. In fact, the commission has to be able to do so. While not suggesting any nefarious intent on the part of the county in this particular case, one can imagine what sort of mischief could occur if local governments could simply issue letters that reinterpret their permits to approve things that were never contemplated, and those interpretations couldn't be reviewed through an appeal or dispute resolution or any other administrative means. A city or county could grant a permit for one thing and then later say that it was intended to prove something totally different, and there would be no way to review that. And the legislature recognized this danger, which is why the Coastal Act explicitly preserves the Commission's enforcement authority even after LCP certification, and even specifically provides for the Commission to take enforcement action when a local government is a party to a violation. Finally, I would just note the hypocrisy of Sable's position in this regard, as they insist that the county's interpretation of its own permit is sacrosanct, but when it comes to the Commission interpreting its permit for the offshore work, Sable doesn't apply the same level of deference. Next slide, please. Another argument that Sable makes is that federal law preempts the Commission's jurisdiction here, and it's true that there is federal law regarding pipeline safety. The Federal Pipeline Safety Act says that the purpose of that law is to protect against, quote, the risks to life and property posed by pipeline transportation and pipeline facilities, unquote. But we aren't asking the Commission to wade into whether the work at issue meets the standards for pipeline safety, or even whether the Commission has authority to decide that question. The limited question before this Commission is whether the work done, even if required by the federal law in order to ensure pipeline safety, is also subject to Coastal Act review. Sable cites nothing in the federal law that precludes state regulation of all work done in order to achieve the federally mandated pipeline safety standards. Another type of preemption is what's known as conflict preemption, and Sable suggests that the permitting process creates a conflict with the federal requirements. But Sable cites no evidence that the Coastal Act's permitting process would conflict with the federal law, and without having even applied for a permit, there's no way they could do so, as they've ensured that they have no evidence for how that permitting process would proceed. And in fact, permit staff have been careful to avoid this conflict and have noted to Sable that permits and permit conditions would address the timing and manner of work to be performed and ensure protection of coastal resources, and would not address the underlying pipeline safety issues. Finally, Sable suggests another form of preemption known as field preemption, and I won't go into details on that, but I'd simply note that none of the case law that they cite supports the idea that federal law results in field preemption over all aspects of pipeline safety, pipeline regulation. Sorry. Next slide, please. Sable also argues that the Commission lacks jurisdiction for a host of other reasons. I'll just mention three here. Most of their arguments are that the Commission has no jurisdiction where the work was pre-authorized, but that's, of course, a derivative argument that depends on the validity of their underlying argument on the merits. Other arguments are about the limitations of the Commission's authority in LCP-certified areas, but the Coastal Act doesn't limit the Commission's ability to impose penalties in certified areas, and the provision of the Act authorizing cease and desist orders provides a clear path for the Commission to assume enforcement jurisdiction when a local government fails to do so, which is what happened here. Sable also discusses several provisions related to the judicial imposition of penalties, which they note don't authorize administrative penalties, but those aren't at issue here, since the penalty we're proposing would only be pursuant to the one provision that does allow for the Commission to issue penalties administratively. Next slide. Finally, Sable argues that the work it's undertaking is making the pipeline safer, that the Commission even supported legislation requiring that sort of work, and that that work is being conducted in a safe manner. And some of that may be true, and the Commission staff has been clear that we support safe pipelines and the rules and legislation related to this. But whether the end result is a safer pipeline is a complete red herring. The question before you is not whether the end product of this work is a good or a bad thing. The question is whether its development that has not been subjected to Coastal Act review and therefore requires that review in order to ensure that it's being performed in a manner consistent with the Coastal Act and the LCP, or at least as consistently as possible. And without that review and oversight, the claims that it's being conducted in a safe manner and environmentally protective manner are simply impossible to assess. With that, I'll turn it back over to Ms. Cook.
Thank you. And I realize we're close to time. This is our last slide. Next slide, please. As we stated in the beginning of this presentation, this case is a prime example as to why permits and Coastal Act enforcement are so important. As we've mentioned, we've conservatively grouped these activities into 9 separate violations, but the scale of this work is so extensive it could amount to hundreds of violations. The potential for coastal resource damage is incredibly high and has been made clear to Sable over and over since September of last year. Protection of the coast relies on entities complying with the Coastal Act and working collaboratively with our permitting staff and permitting development in a way that protects coastal resources. There's no precedent for this kind of direct disregard for legal orders, and it is highly problematic for an entity to flatly refuse to comply with a legal, validly issued order, and to flout the Coastal Act, as Sable has done here. Further, Sable has caused Commission staff to devote considerable resources to this case by continually portraying a willingness to find an agreeable outcome while seemingly simultaneously undertaking efforts that indicate otherwise. They've repeatedly sent us lengthy documents after hours and into the night, late on Friday afternoons, and have continued to provide incomplete and incorrect information. Sable has rejected numerous opportunities to work collaboratively with the Commission and have created this situation we present to you today, which could have easily been avoided. While Sable has repeated the same lengthy defenses, which we address fully in our staff report and as well as in their statement of defense, and again in our response to their amended statement of defense that we received just last Friday, we've shown that these defenses fall short. For the reasons discussed in this presentation and more extensively detailed in our staff report, we recommend that the Commission approve the cease and desist order, restoration order, and administrative penalty order as set forth in the staff report, and the motions can be found beginning on page 16 of the staff report. This concludes our presentation, and we're available for any questions. Thank you. How perfect. I mean, come on.
On it. Wow.
Come on.
All right, well, thank you very much for that presentation. I would now at this time like to invite the violators up to the podium to provide their presentation, and please let me know how much time you will need. Sorry, the alleged violators, sorry. Oh, and you have to press the button at the bottom of the, there you go.
Ready to go?
How much time will you need?
Chair Cummings, probably about 35 minutes.
Okay, so if we can give 35 minutes, and given that the staff took 50 minutes, any remaining time will be allowed for you as a rebuttal. Go ahead.
Great.
Please state your name.
Good morning, Chair Cummings and Commissioners. My name's Steve Rush. I'm Vice President of Regulatory and Governmental Affairs for Sable Offshore Corp. I'm here today with our outside counsel, DJ Moore, as you mentioned earlier, to address the issues your staff has raised in the proposed orders.
Please, hang on for 1 second. Technical difficulties. Go ahead.
Right. Good morning again. Sable and its subsidiaries are the owners of the offshore oil production facilities and onshore facilities of pipelines that are collectively referred to as the Santa Ynez Unit, or SYU. I started my career working on permitting SYU facilities back in 1981 to date me, and again the startup of the onshore facilities back in December of 1993. So I'm very familiar with the history of the assets, the permitting of the assets, and what's happened over time. Our team has also taken a very thoughtful, collaborative, and respectful approach in our business operations. We collectively have decades of experience in successfully working collaboratively with our government agency partners. However, in this instance, Commission staff and Sable fundamentally disagree whether the Coastal Act authorization exists for the work and whether the Commission has the jurisdictions to issue these orders. Those fundamental disagreements have unfortunately prevented a resolution of this matter to date. Next slide. Before diving into the details about Sable's work, it's worth discussing who Sable is. Sable has over 100 California-based employees, of which I'm one of them. And our executive management team has extensive experience operating oil and gas facilities here in Santa Barbara County over several decades. In fact, the same team received the county's first and only Resolution for Good Operator recognition of our outstanding operating performance and has won several other awards for environmental management and conservation. Sable also notes that the work at issue today was performed by over 500 skilled employees and contractors, including local tradesmen and union members. Many of those workers are here today, and I offer a shout out to them and thank them for coming and for their dedication, to safe business operations. We are proud of our good paying, skilled jobs our project has brought to the region, both in connection with our repair and maintenance work and our ongoing operations. Next slide. Sable would now like to make clear what is not before the Commission today. It's not about the 2015 Refugio oil spill. It's not about the restart of the pipeline that is under the exclusive jurisdiction of the Office of the State Fire Marshal, or it's not about the future of oil production or fossil fuel in California, though we expect we'll hear plenty of that from others that are here today. Instead, this hearing is about Sable's routine repair and maintenance work under existing coastal development permits, or CDPs, along an already disturbed, permanently impacted pipeline maintenance corridor. Also before you today is a fundamental legal issue, and we acknowledge that it's not a typical situation for the Commission. The staff report asserts that the Commission has the authority to override a local government. Here it's the County of Santa Barbara. And its longstanding interpretation of CDPs that the county issued in the first instance. But the Coastal Act simply does not give the authority to the Commission, and therefore the proposed orders are improper and unwarranted. First, the staff attacked Sable's safety valve installation work, which was undertaken to comply with a state law that this Commission supported to reduce oil spill risk from pipelines. Sable only undertook this work after the county confirmed no new permits were required. The staff report then turns to Sable's anomaly repair work to repair pipeline defects. There too, the county confirmed that the work is authorized under the pipeline's existing CDPs, as the county consistently has done over the last 30 years, when it has allowed this work without requiring new or amended CDPs. Finally, the staff report focuses on Sable's span remediation work, which is entirely consistent with prior maintenance work under Exxon, prior operator, who undertook on the offshore pipelines for which no new or amended CDP was required. I'd now like to show you a brief video. And then DJ Moore will be speaking.
If we could pause the clock. Thanks.
In the heart of California's coastline, Sable Offshore Corp is working to ensure the safest oil pipelines in California history are brought online to create jobs and provide energy and environmental sustain. In the heart of California's coastline, Sable Offshore Corp is working to ensure the safest oil pipelines in California history are brought online to create jobs and provide energy and environmental sustainability. Over 500 dedicated professionals are diligently revitalizing the Los Flores pipeline system, implementing safety measures that surpass industry standards. As we fly up the coastline, you'll see Sable's active dig sites, where skilled crews are replacing and repairing pipeline sections identified with anomalies. As we continue up the coast, we see the former Sable dig sites outlined only by erosion-controlled wattles, which have been replanted and are already blending seamlessly back into the surrounding terrain, a quiet, visual testament to restoration done right. With a projected initial impact of over $5 million annually in new tax revenue for Santa Barbara County, our commitment extends beyond energy production. It's about fostering community growth, ensuring environmental integrity, upholding the highest safety standards, and making gas more affordable at a time when Californians are worried about making ends meet. Sable Offshore Corp, powering California's future and ensuring responsible and safe local energy production.
Please hold your applause.
Good morning, Commissioners. DJ Moore on behalf of Sable. As you're aware, oil and... Oh, can you please pull up the deck? Sorry. There we go. Next slide, please. As you're aware, oil and gas production in Santa Barbara County is not new. Throughout the 60s, 70s, and 80s, the federal government leased land for offshore oil production platforms in the Santa Barbara Channel. By 1990, there were 23 platforms that had been built. Importantly, onshore pipelines were not what was originally envisioned here. Oil was originally proposed to be taken off and loaded onto tankers in federal waters. At that time, the county and the commission endorsed the use of onshore pipelines as the environmentally superior option to using tankers in the channel. Next slide. Sable owns and operates 3 of the offshore platforms in the channel, as staff informed you earlier, as well as the onshore Los Flores pipeline infrastructure that extends west from the Los Flores Canyon plant along the Gaviota coast on the inland side of the 101 freeway. The pipelines turn north and head out of the coastal zone into the San Ynez Valley and ultimately to San Luis Obispo and then ending in Kern County. Next slide, please. We'd like to focus today on Sable's onshore repair and maintenance work first. And I want to note that Sable has been working collaboratively in real time with a wide range of government departments and agencies, including federal, state, regional, and local entities. I cannot underscore the complexity of the regulatory process involving the SYU. Next slide, please. Sable's onshore work is located entirely within the areas of the county's delegated authority under its certified LCP, and the county confirmed that work is authorized under existing approvals, including the county's previously issued CDPs for the onshore pipelines. The Coastal Commission certified the LCP in 1981, and the county has exercised delegated authority under the Coastal Act since that time. In 1986, the county analyzed this pipeline project in a joint environmental impact report, environmental impact statement prepared by the State Lands Commission and the Bureau of Land Management, what we call the onshore EIR. The county adopted the onshore EIR and multiple approvals, including 2 CDPs for the Los Flores pipelines. Those CDPs were not appealed to the commission at that time. The pipelines were built in the early 1990s and operated until 2015. Next slide, please. The EIR anticipated that ongoing repair work would be required along the pipelines to allow for rapid pipeline repairs and to ensure safety. Accordingly, the EIR confirmed that the pipeline's operational corridor would remain permanently impacted by ongoing work, and it included off-site mitigation requirements to account for those permanent impacts. For the past 30 years, the county has allowed for repair and maintenance work that has involved digging to access the pipeline within the pipeline's permanently impacted corridor without further Coastal Act authorization. The corridor has remained disturbed by ongoing work and inspections during this time. This is by no means pristine habitat, and the EIR found that habitat impacts would be significant and unavoidable because they would be permanent, not just temporary during initial construction. Next slide, please. With that background, we'd now like to begin by focusing on Sable's onshore safety valve and installation work. Next slide, please. In 2015, the state legislature enacted AB 864, which requires pipeline operators to use the best available technology to reduce oil spill volumes in coastal and sensitive resource areas. As staff mentioned, the Commission did support this bill as an important protective measure for coastal resources. Next slide, please. In April 2021, the Office of the State Fire Marshal approved a plan to install 16 above-ground safety valves on the pipelines in compliance with AB 864. 7 would be located in the coastal zone. Safety valves are not a new technology. The pipelines included valves with substantial above-ground infrastructure that were analyzed in the EIR when the pipelines were first built, as shown here. Next slide. In late 2021, the 16 OSFM approved valves were submitted to the county for review with similar above-ground infrastructure. The county determined that minor amendments to the pipeline's original CDPs would be required for those above-ground structures and valves. Ultimately, the County Planning Commission denied the amendments, effectively preventing the operator at that time from complying with AB 864 and forcing Sable's predecessor to file litigation. Sable purchased the pipelines in 2024, settled that litigation with the county, and per that agreement, Sable revised the proposal so that all of the safety valves would instead be installed underground. Next slide, please. Based on that revision, the county confirmed that it did not have any further permit authority or jurisdiction over the valves. Here is the language from that letter. Next slide, please. Based on the county's confirmation, Sable installed the 7 valves in the coastal zone. This work was substantially completed before Sable ever received the Commission staff's September 2024 NOV. With these and other valves installed, we note that along the pipelines, potential oil spill volumes have been decreased by about 50%. Next slide. Installing valves requires excavation, removal of installation around the target pipeline segment, removing the pipeline segment, installing the valve structure itself, welding seams, installing structures for future access, backfilling the sites. Here's a photo looking down into a subterranean valve chamber after it was installed. Next slide, please. Sable's safety valves were installed along the pipeline's already disturbed corridor, where permanent impacts to biological resources were found. The county's biological analyses from 2022 confirmed that impacts would remain within the scope of the impacts in the county's existing approvals, and each valve was specifically located to ensure no additional disturbance to already impacted ESHA or coastal resources would result. Here's a diagram of one of those sites located entirely within a disturbed annual grassland habitat and outside of ESHA. Next slide, please. Based on these facts, the proposed orders related to the valve work are not warranted. The Commission may issue cease and desist orders only where, as relevant here, a local government has declined to act or not acted in a timely manner. Here, the county has not declined to act. It expressly confirmed that no permits were required. Neither is a restoration order appropriate. Each of the valves were specifically located to avoid areas with ESHA or coastal resources, ensuring no ongoing resource damage. Further, while the Commission staff may disagree that the county's valve approval was sufficient authorization under the Coastal Act, to clear up any confusion, Sable has submitted materials to the county to confirm whether a new or amended CDP from the county is required. That is still pending before the county, so proceeding with the orders concerning the valves is not yet ripe. Next slide, please. Now I'd like to turn to Sable's other onshore repair work known as the anomaly repair work. Next slide, please. Anomalies refer to areas where the pipeline has deviated from its original configuration. It's typically detected using a pipeline inspection gadget, also called an inspection pig, depicted here. Federal regulations require pipeline operators to take prompt action to address detected anomalies. As such, pipeline anomaly repairs are a common and routine repair activity along a pipeline. Next slide, please. Because anomaly repairs are not uncommon, the onshore EIR analyzed impacts related to ongoing anomaly repairs throughout the pipeline's lifetime. As part of the EIR's draft oil spill contingency and response plan, the document analyzed the typical process where operators would use pigs to measure corrosion and identify defects for repair. The EIR confirmed that the pipeline segments with anomalies would be excavated and exposed, cleaned and recoated, or removed and replaced. Pipeline anomaly repairs have been conducted along these pipelines numerous times since the pipelines were constructed in the early 1990s. The county has never required a new or amended CDP for anomaly repairs, and the Commission has never asserted that a new or amended CDP should be required. Like safety valves, all anomaly repairs occur along the pipeline's already permanently impacted operational corridor, where any biological or cultural resources would be affected for the project's operational lifetime. Next slide, please. After Sable acquired the pipelines in 2024, its robust inspection work detected over 100 pipeline anomalies in the coastal zone, as staff mentioned, that Sable determined should be repaired to ensure that this is the safest pipeline in California, consistent with requirements under the federal consent decree. This scope and scale of repairs is entirely consistent with what would be expected given the last time that repairs were undertaken on this pipeline. 2/3 of those repairs were the result of more stringent standards imposed by the consent decree than typical federal requirements, underscoring the rigorous additional protections that are being put in place. Repairing anomalies requires substantially the same steps as shown on this slide to installing the safety valves that I mentioned earlier. Next slide, please. And here's a photo of a site where an anomaly repair was conducted in December of 2024. You can see that there is essentially no sign that work occurred and revegetation is fully underway. Sable has consistently worked with biologists throughout this process, including at repair sites, both to avoid potential resource impacts and to restore sites consistent with existing county permit conditions. Next slide, please. Sable had completed approximately 50 of its anomaly repairs before receiving the Commission's September 2024 NOV. Sable had several discussions with Commission staff, stopped working at sites where repairs were ongoing, and complied with Commission staff's informational requests regarding the work. Sable also raised next slide, please. Sable also raised concerns about leaving active repair sites open during this period and exposed while the work was stopped, which posed threats to wildlife and risks of erosion and to pipeline integrity. After numerous discussions with staff, Sable ultimately requested that staff authorize it to backfill the sites to minimize the risk of environmental harm. Staff issued the November 2024 EDCDO in part to allow for this work to occur given the impending rainy season. Next slide, please. Sable complied with the 2024 EDCDO and worked with staff to take these interim environmentally protective measures. Here is an image of one of those interim restored sites where Commission staff approved seed mixes were used to hydroseed the surrounding area. At the same time, Sable prepared and submitted zoning clearance applications regarding the anomaly repair work to the county for its review under its LCP authority to comply with the EDCDO's requirement that an application be filed either with the county or with this commission. Next slide, please. On February 12th of this year, the county confirmed that the anomaly repair work falls within the scope of the pipeline's existing CDPs and that no new CDP is required. Here is the exact language from the county's letter for your review. This confirmation is consistent with how the county has treated all previous anomaly repairs on the pipelines to which the commission has not objected until now. Next slide. Sable resumed work on February 14th, only after receiving this confirmation from the county that no further permits were required and that Sable was authorized to move forward. To be clear, and contrary to claims in the staff report, Sable did not wait for the prior EDCDO to expire before it started work. It started work only after it received confirmation from the county that it was authorized to do so. Staff issued the February 18th EDCDO just days later, and Sable, as staff mentioned, has continued to work as authorized by the county. Next slide, please. We understand that commission staff disagrees with the county's determination. However, the Coastal Act does not afford the commission the authority to override the county's interpretation of its own CDP issued under its delegated LCP authority. The county has interpreted anomaly repairs to fall within the scope of these CDPs for decades, and the commission has never objected. Moreover, the commission lacks appellate jurisdiction here because the county has not issued or denied a CDP application or made any other appealable decision under the Coastal Act. The time to appeal these CDPs passed long ago, and none of this onshore work occurred in the commission's original jurisdiction. Next slide, please. Finally, we note that the anomaly repair work occurred entirely within the pipeline's already disturbed corridor where impacts were found to be permanent. Sable submitted analyses to the county showing that any impacts would fall within the scope of those previously analyzed and approved, and that documentation was also provided to your staff. Next slide, please. Again, based on these facts, the proposed orders are not warranted related to the anomaly repair work. The county has not declined to act here. Commission staff just disagrees with the county's action. Neither is a restoration order appropriate. All work occurred within the pipeline's operational corridor where impacts were found to be ongoing and permanent during the project's lifetime. Next slide, please. Now I'd like to address Sable's offshore repair and maintenance activities known as the span remediation work. Next slide, please. Span remediation work was conducted on the offshore pipelines in state waters pursuant to a state lands lease requirement. This involved the placement of sand to cement bags under small segments of the pipeline to reduce the distance of free spans, which are sections of the pipeline not resting on the seafloor. The staff report alleges that this work was done without authorization. That's not correct from Sable's perspective. The span remediation work was authorized under Sable's existing offshore coastal development permit, approved by this commission and consistent with past maintenance work performed on these offshore pipelines that did not require new Coastal Act authorizations. The work also was reviewed and approved by the State Lands Commission and designed to be low impact, minimizing any potential environmental disturbances and effects to coastal resources. Next slide, please. The foundation of the span remediation work lies in Sable's 1988 Development and Production Plan, or DPP, which is a federal approval issued through the Department of the Interior. The 1988 DPP is the document that served as the project description for Sable's offshore CDP. The DPP explicitly mandates that all pipelines be maintained in good operating condition, adhering to industry standards, which includes the remediation of free spans through the use of sandbagging techniques. Next slide, please. The span remediation work was performed pursuant to an explicit requirement in the Pipeline State Lands Commission lease to conduct annual surveys to identify any signs of bridging or free spans and to take corrective action. The Coastal Commission's offshore CDP explicitly incorporated the State Lands Commission's conditions, just like the DPP I mentioned a moment ago. Thus, the span remediation work was encompassed within the scope of activities authorized by the offshore CDP. Next slide, please. Sable span remediation work is not unprecedented. In 2012, Exxon completed an identical span remediation project on the same offshore pipelines. Coastal Commission staff was informed of this work through submissions to the State Lands Commission at that time. Notably, no new Coastal Act authorization was required and no enforcement action was initiated, underscoring the routine nature of these activities. Consistency is important and nothing new or substantially different was done here. Next slide, please. Importantly, the Bureau of Safety and Environmental Enforcement, or BSEE, approved Sable span remediation work in federal waters without any changes to the DPP, confirming that this work was authorized by the DPP, which, as I mentioned earlier, served as part of the project description for the Commission's CDP in state waters. Next slide, please. The same is true for the State Lands Commission lease. After reviewing Sable's proposal, the Lands Commission approved the span remediation work, allowing Sable to proceed. Next slide, please. The span remediation work was completed over a 3-day period from November 29th to December 1st of last year. Sable used a remotely operated vehicle to place sand to cement bags in identified locations, effectively decreasing span lengths to ensure pipeline stability. The work was completed in 14 locations along a total of only 150 linear feet of the pipelines. Next slide, please. Now let's discuss the environmental impact of this work. The staff report suggests that there were potentially significant impacts. That is not the case. The work disturbed less than 0.07 acres with no sensitive habitat affected. As shown in the CDFW map of benthic habitats here on this slide, there were no hard bottom substrates near the work area. Sable ensured there was no debris left behind, no anchoring was used, further reducing potential impacts. Wildlife monitoring was conducted throughout the process. As demonstrated in reports submitted to the Lands Commission and shared with your staff, there were no safety, health, or environmental accidents or incidents. Next slide, please. Finally, the staff report calls into question whether the sand to cement bags used by Sable leach chemicals and whether sandbags alone would have been more appropriate. But Commission staff have, in previous determinations, concluded that concrete is an appropriate material in the marine environment that does not raise leaching concerns. Next slide, please. With respect to each of Sable's repair and maintenance activities, Sable would just like to note for the record that state and local agencies are preempted by federal law with respect to actions relating to pipeline safety. I will not dive into those issues in detail. We have covered them in our statement of defense. The county has repeatedly acknowledged the preemptive effect on its own authority under its LCP. This preemption ensures that operators can perform necessary repairs under existing approvals. Next slide, please. Finally, we would like to address why no penalties, and certainly not the penalties proposed by staff, are warranted. First, Sable undertook the safety valve installation work only after receiving confirmation from the county that no additional permits were required. This work was completed substantially before the Commission issued its 2024 NOV. Importantly, the valves were installed within the pipeline's already disturbed and permanently impacted corridor. Second, regarding the anomaly repair work, Sable acted in line with the county's longstanding practice of authorizing such work without the need for a new or amended CDP or other Coastal Act authorization. Once the NOV issued, Sable did work closely with Commission staff, halted activities until the county confirmed that Sable was authorized to proceed, and implemented an interim restoration plan to address any immediate environmental concerns that were raised by your staff. Third, the span remediation work was conducted under the existing offshore CDP with State Lands Commission approval. This work was consistent with past practices, including similar efforts by Exxon in 2012. The impacts were minimal, affecting less than 0.07 acres, as I mentioned, and were confined to the already disturbed offshore pipeline corridor. Because each set of activities was authorized, the costs incurred by the state were not necessary. Sable's actions were guided by the existing authorizations and past precedent. Given these factors, imposing penalties is not necessary, and imposing the penalty proposed by staff would be grossly disproportionate to the nature of the impact and the work here. Next slide, please. In conclusion, we reiterate that this type of work has occurred on the pipelines for the past 30 years without new Coastal Act authorization, and that any potential impacts were de minimis because the work occurred in already disturbed areas where impacts were previously determined to be permanent and ongoing. As such, Sable asserts that the proposed orders are not justified. We thank you very much for your time today. We reserve the remaining time for rebuttal.
Thank you. And we'll add an additional 5 minutes to that rebuttal time.
Thank you, Chair.
No problem. Okay, I'd just like to ask really quickly how many people we have signed up to speak today.
We have currently 117 in person, or maybe even a little bit more, maybe 120, and then 6 in Zoom.
Okay. For that reason, I'm going to ask that we take a 5-minute bio break, but please make sure to come back in here in 5 minutes so we can get going, because we're going to have a long public comment period. So we're going to take a 5-minute break. And for commissioners, please do not discuss anything that's been talked about today. Testing. All right, if everyone could take their seats, and if you were in the overflow room, we're going to ask if you could please go back to allow folks to seat themselves where they were seated previously. As was mentioned, we've got about 126 people signed up to speak. And so we're going to ask that, set some ground rules. One, the question here today really is around the development activities that have occurred and whether those were permitted or non-permitted. The other is that we ask that people do not applaud. If you agree with something, you can give a thumbs up, you can wave your hands. We don't want audible confirmation or disagreement. And then lastly, we really ask that try to keep your comments succinct. If people have said what you feel and what you've already said, you can agree with their statements, but we really try to ask people to keep it short so we could get through this, because I think ultimately we want to see it. Everybody here wants to see us take action, right? And so let's try to get through the comments as quickly as possible. And so with that, I want to invite up, if there's any elected officials signed up or here in the room, we will invite you up to speak first. So I'd like to ask Chris and Simone, do we have any elected officials signed up to speak?
Yes, we had 3 people signed up. We have Ethan Bertrand on behalf of Assemblymember Greg Hart, Jordy Scully for Senator Monique Lyman, and Spencer Brandt, the district representative for the county of Santa Barbara.
Okay, so if you can all line up at the podium. We'll give you all, as representatives of elected officials, we'll give you as much time as you need, but please be succinct.
Thank you. Good morning, Mr. Chair and Commissioners. My name is Ethan Bertrand, and I'm here on behalf of Assembly Member Greg Hart. Mr. Hart supports the actions recommended by Commission staff to protect the Central Coast from Sable's unpermitted work and blatant disregard of the Coastal Act and other environmental regulations. Having experienced the devastating impacts of the 2015 Refugio oil spill, along with the destruction caused by the 1969 Santa Barbara oil spill, the residents of Santa Barbara County continue to call for the highest levels of environmental review and safety measures. Local residents are outraged by Sable's ongoing defiance of regulations in place to protect coastal resources. As your staff has stated, this level of defiance is unprecedented. Sable must be held accountable. Assemblymember Greg Hart urges your commission to approve the cease and desist order, the restoration order, and the administrative civil penalty. Assemblymember Hart also asks for your continued attention to the need for thorough environmental review of all aspects of the proposal to repair and restart this corroded pipeline that threatens the Gaviota Coast. Thank you.
Thank you very much.
Jordy Scully and Spencer Brandt.
A little shorter than Ethan. Hello, Chair and Commissioners. My name's Jordy Scully, and I'm speaking here on behalf of Senator Monique Limon. I'm speaking in support of the findings and actions recommended by Commission staff. This is a necessary step to protect the Central Coast from the unpermitted work that Sable is continuing to engage in, disregarding the Coastal Act and other environmental regulations. The Senator, along with the community, share significant concerns about the restart of a problematic pipeline that caused a significant oil spill on our coast 10 years ago. The Senator is supportive of fostering well-paying jobs on the Central Coast. However, she has great concern when any law in our state is not followed and when cease and desist orders are ignored. Sable Offshore Corp has not ceased its restart work, even in response to multiple orders that have been issued. For that reason, the Senator and Assemblymember Hart have written a letter to the Attorney General to ask for assistance with enforcement. Again, the Senator urges your approval of the recommended cease and desist order, restoration order, and administrative civil penalty. The safety of our coast and our residents of our community are the utmost of importance. Thank you for your work on this issue, and we appreciate your continued attention to to the need for environmental review of all aspects of this proposed restart. Thank you.
Thank you. Spencer Brandt.
Good morning, Commissioners. My name is Spencer Brandt. I'd first like to clarify, I'm speaking on behalf of the Isla Vista Community Services District Board of Directors, not on behalf of the county today. I represent the 15,000 students and long-term residents that call the Isla Vista Oceanside Community home. Our community has a median age of about 21 years old, and we represent the next generation, the generation that will be greatest affected by the catastrophic effects of climate change. You're going to hear from many of those residents here today. Our board voted unanimously to adopt a resolution that encourages all state agencies with permitting authority over this pipeline and its construction to use their authority to enforce health, safety, and environmental laws. We're approaching 10 years to the date when this pipeline burst, fouling our beaches, including those in Isla Vista, and disrupting our environment, killing marine life, and disrupting the economy. I support the common sense enforcement action before you today. No one and no company should be above the law. Thank you for taking this action.
Thank you. And just, we don't have any others noted as elected officials, but it's possible that it was missed in a sign up. So if there are any other elected officials or those representing them, please come up now.
Okay, are there any elected officials in the room?
Okay, I don't see any. So I understand that we have
I
a
think we have-
15-minute presentation.
I think one person approaching the podium.
Okay. Please state your name.
Good morning. I'm not sure if I'm fish or fowl. I'm a former state senator for this district and wonder if that qualifies for an opportunity to say a few words. I appreciate that. When you leave the legislature, suddenly people don't answer your calls and you're not as funny as you used to be. But I do appreciate the opportunity.
Please state your name as well.
Yes, my name is Hannah Beth Jackson. I was the state senator for this district from 2012 through 2020 and was the state senator when we had the 2015 pipeline disaster here. Having been elected and having served on the Committee on Natural Resources, I'm very familiar with the responsibilities of the Coastal Commission and the fact that the Coastal Commission is a result of an initiative passed by the people of the state of California back in 1972, demanding that we protect our coast. And it is in that context that I want to thank you for your work and also make a couple observations as to what happened in 2015. When this oil spill occurred, it created a disaster, 122,000 gallons of oil that spread not only in our community, but all the way down the coast into Los Angeles, tar balls appearing on the shore. But its impact on our community was quite decisive. Multi-millions of dollars of economic loss that ended up costing the company that then owned it somewhere around $780 million. That is not an unrealistic expectation. This pipeline is significantly corroded. And so all of these efforts that we've heard about remind me of the expression that you can't put lipstick on a pig. This pipeline is a problem. It is something that the people of this community are very concerned about: quality of life, the loss of wildlife and marine life, and the enormous impacts that it has had on our community. And as someone who had to deal with that, who wrote legislation on this, who is concerned to this very day that we have a legacy to protect here, and you have a responsibility because it's something that the people of this state urged and created back in the 70s. So I just want to thank you for what you're doing. Ask you to follow the recommendations of your staff. I think they're comprehensive. I think the fact that we have a company that has chosen just to ignore those responsibilities is a level of arrogance that we cannot accept. Nobody is above the law, and so I look forward to your response and your actions. Thank you very much.
Thank you. Okay, no, please hold the applause. Thank you. I'd like to ask if there's any groups signed up to speak today.
Yes, we have a group presentation from the Environmental Defense Center. I believe they were given 15 minutes.
Okay, so we'll give...
We have Laura Kropp, Brian Troutwine, and Alex Katz.
And we have a...
Linda Kropp? Sorry.
You wouldn't mind loading our presentation? Awesome. Good morning and welcome to Santa Barbara. We're excited to have you here. I'm Linda Kropp, Chief Counsel of the Environmental Defense Center, appearing today on behalf of Get Oil Out, Santa Barbara County Action Network, Sierra Club, Santa Barbara Channel Keeper, and EDC. We lived through the 2015 spill at Refugio. In fact, some of us were on the beach that very first day, and we witnessed firsthand the harm to wildlife, habitats, cultural resources, public beach access, and fishing. We know that another disaster is not a hypothetical concern, but a real threat. In fact, a recent study by the County of Santa Barbara concluded that another spill from this corroded pipeline is likely every year, a rupture every 4 years, and a spill nearly twice the size of what happened in 2015 along the coast. Next slide, please. In addition to the clients...
Can I pause you for 1 second? I'm sorry. Can you all get the clock up?
Oh.
Thank you. Please proceed.
We're also part of a larger coalition of more than 100 organizations locally as well as statewide that submitted a letter to the governor back in December supporting the Coastal Commission's role in response to Sable's unlawful activities. We are here today to support the recommendations of your staff. And first, I would like to introduce Brian Troutwine, our Senior Analyst and Watershed Program Director.
Good morning, Chair Cummings and Commissioners. I'm Brian Troutwine, a Senior Analyst and Watershed Program Director with the EDC. I will show that the work undertaken by Sable was substantial, the impacts to coastal resources were not de minimis, they were significant, and that there is an ongoing threat. And I'll also explain why restoration must be implemented in a timely manner to prevent further harm. Next slide, please. Sable has undertaken work, unpermitted work, at 138 pipeline repair sites in the coastal zone at approximately 60 to 80 separate excavation sites. Vegetation was cleared, often in excess of 200 linear feet along the pipeline. Trenches around 10 feet deep were excavated and large spoil piles were created. This photo was taken Monday at Arroyo Hondo Preserve. This work site spans several hundred feet and was just one of 3 sites undergoing construction at the preserve. Multiply this by approximately 60 to 80 sites to get a sense of the magnitude. This project has been in operation since before July 14th. And while there was a pause shortly after the first cease and desist order in November, work continued in violation of the second order in February. Construction at some of the sites lasted about 2 months. The extent, nature, and duration of work demonstrates that this is a major construction project. Next slide, please. The impacts are significant. This slide shows major vegetation removal and fill of mapped wetlands. We have to consider the setting to understand the impacts. The Gaviota Coast is a large, undeveloped coastline. The National Park Service found that the Gaviota Coast qualified to be a national seashore due to its scenic, biological, cultural, and recreational values. There are 3 state parks on the Gaviota Coast. It's so special that the county adopted the Gaviota Coast Plan to protect it. Major vegetation removal occurred in freshwater, riverine, and riparian wetlands. which filter pollution, mitigate flooding, and provide habitat. We've lost 91% of our wetlands in California. Work removed coastal sage scrub. Southern California has lost 70 to 90% of its coastal sage scrub. Work impacted native grasslands, and California has less than 1% remaining. Habitats for rare, threatened, and endangered species have been impacted, including critical habitat for the California red-legged frog. Given this, the project is causing very significant impacts. These include short-term impacts, such as impairment of nesting, and longer-term impacts, such as conversion of native vegetation communities. Construction occurred on a popular trail for weeks, degrading recreational experiences. Excavation exposes soil to erosion and sedimentation, which harms our water quality. And there are significant scenic impacts. Night work with bright lights mars our night skies and harms nocturnal wildlife. Next slide, please. Here, the red line is the approximate pipeline location, and the yellow pins are work sites. The green overlay is red-legged frog critical habitat. The blue and green lines are wetlands in the National Wetland Inventory. Some excavations span these wetlands, triggering the Regional Water Board's violation. Next slide, please, and click the video. This video shows work in a mapped wetland, waters of the state, and coastal sage scrub after the second cease and desist order was issued. Next slide, please. The Arroyo Hondo Preserve in the lower map is a treasure of sensitive resources and habitats. The last 271 steelhead from the Santa Monica Mountains were relocated to Arroyo Hondo Creek here to protect them after the Palisades fire, but more work is planned along Arroyo Hondo Creek. In the upper right, you can see Arroyo Quemado Creek. It was excavated during red-legged frog breeding season. Red-legged frogs and southwestern pond turtles dispersed from Arroyo Quemado Creek, but several excavators were operating in this habitat when these species may have been present. Next slide, please. This is the excavator working in Arroyo Quemado Creek, days after the second cease and desist order. This is a county-protected site with restored habitat, endangered species, and public trails. And you can see they're right down in the creek with the excavator. Next slide, please. Now, many of the repair sites are in or next to wetlands. Roads have been improved with culverts, fill, and steel plates across these wetlands, representing unpermitted wetland fill and development in ESHA. Next slide, please, and click the video. Sable excavated in or near oak woodlands and coastal sage in Cañada de las Zorillas, a sensitive area. Next slide, please. And this is an ongoing threat. Although Sable has completed much work in the coastal zone, it has plans to conduct more work, including within the Arroyo Hondo Preserve and Gaviota State Park. State Parks has notified Sable that it needs to apply for a new easement, but in the meantime, Sable has removed riparian, coastal sage, and grasslands for approximately 400 meters in the state park in anticipation of work that has yet to occur. Next slide, please, and click the video. Sable stored heavy equipment at the top of a creek bank overlooking a pool supporting state and federally endangered Southern California steelhead shown on the right of the video, as well as western pond turtles and arroyo chub, all rare species. There is an ongoing threat to coastal resources because Sable has not yet undertaken pipeline repair work in the state park near Gaviota Creek and has more work in Arroyo Hondo, the most sensitive creeks on the Gaviota coast. Next slide, please. Some of the impacts may never fully be mitigated, but habitat restoration is essential. The top site was cleared of coastal sage and not replanted. The lower site is now covered by invasive mustard plants, while the adjacent areas that are undisturbed are mustard-free, demonstrating the long-term impacts. Restoration is also needed to minimize erosion, water quality, visual, and recreation impacts. The longer these sites go without restoration, the more difficult it will be to mitigate impacts. So it is imperative that restoration begin promptly. In conclusion, the project is very substantial, impacts are significant, and ongoing threats remain. Restoration is imperative. And I'll hand it back over to Linda Crop.
Thank you. First, I would like to thank Commission staff for their effort over the last 8 months. They have conducted their investigation with diligence and professionalism. The evidence presented in the staff report and at today's hearing shows an astonishing and persistent pattern of violations of both state law and agency directives. Sable has violated 2 notices of violation, 3 notices of intent, and 2 cease and desist orders from commission staff, and that doesn't even include the notices and orders from other agencies like the Regional Water Quality Control Board, California Department of Fish and Wildlife, Bureau of Land Management, and state parks, just to name a few. Despite all of these orders and directives, Sable continues to refuse to apply for required permits and submit necessary information. It's time for the commission to act. Sable's primary defense is that the county allowed it to perform the work. However, the county's determination is not binding on this commission, which has independent authority to enforce the Coastal Act. In addition, the county's determination is unfounded both legally and factually. Despite numerous requests by the commission staff over several months, the county has refused to provide any evidence to support its finding that Sable's work was authorized by its 1987 permit. One can only surmise this is the case because there is no evidence to support that assertion. On the other hand, there is ample evidence that Sable's recent work was neither authorized nor contemplated in 1987, as staff has gone into great detail to explain. Instead, the replacement of the cathodic protection system with state waivers transforms a measure that was required to prevent an oil spill into a strategy that is reactive and relies on inspections, monitoring, and response, all of which failed in 2015. For example, we know from the investigation following the 2015 spill that the online inspection, or ILI, data was incredibly inaccurate and often undercalled the amount of corrosion on the pipeline. In addition, ILI testing doesn't even detect certain types of corrosion. Similarly, there are issues with hydro testing, and in fact, in this case, under the waivers, the proposed hydro testing pressures for line 324 are too low, and there's not even any requirement for line 325B. Although state waivers are allowed if they result in a pipeline system that is as safe or safer than effective cathodic protection, that doesn't occur here. In fact, Mr. Cooperwitz, a pipeline safety expert with AccuFacts, reviewed the waivers and concluded that in this case, the waivers are not as safe or safer as pipelines that comply with minimum cathodic protection requirements. Because of this deviation from the 1987 permit, Sable should be required to apply for a new or modified coastal development permit, either from the county or from the Coastal Commission. Sable also characterizes the work as mere maintenance and repair. However, as you've heard, this is completely fallacious. Never before in the history of this pipeline has an operator undertook removal of all the insulation or most of the insulation, replacing the cathodic protection system. This is all new and was not contemplated in 1987. In fact, this work changes the fundamental design of the pipeline. Sable also argues that the commission is preempted by federal and state agencies and even the county. As an initial matter, federal and state preemption does not exist here because the Coastal Commission's authority is to protect coastal resources and does not conflict with laws that protect pipeline safety. In fact, we were part of the effort to pass AB 864 requiring best available technology. That law did not exempt or preempt permit authority. It contemplated that operators would apply for permits to implement this new technology. Similarly, with respect to the county, the Coastal Commission does have authority under the Coastal Act to take enforcement action if a local agency, in this case the county, fails to act. And in this case, the county failed to act. We're talking about not just responding, we're talking about taking enforcement action. And the county has failed to act, hence the commission has authority. Finally, Sable claims that the impacts to coastal resources were de minimis. As you have seen from the staff's presentation and Brian Troutwine's presentation, the impacts have been substantial and will continue to be substantial. Accordingly, we urge the commission to approve the requested orders to not only prevent future harm, but also remedy the harm that has occurred, and to impose penalties to both punish and deter violations by Sable. And also, we want to point out, everyone's watching. This issue is known statewide now. If Sable is allowed to violate commission orders and undertake unpermitted action, believe me, this is not going to be the first time you see this. You heard this is unprecedented. Well, now it's precedented. So you need to send a message to others who do business in the state as well. So we support the staff's recommendations. We also hope that the state attorney general will support the commission by seeking an injunction. Clearly that's necessary with a company like this, and impose ongoing stiff penalties. We are in California where laws matter and no one is above the law. And again, we thank you for your attention to this matter, and we urge you to approve the requested orders. And we're available for questions. Thank you.
Thank you very much.
Thank you.
Do we have any other groups signed up?
No, we don't.
I'm going to ask, is there any way we can bring up if there's people who are here in opposition and giving the first 15 minutes of public comment, or actually the second round of public comment, to folks who are in opposition?
Is it opposition both times? Start with opposition?
Yes.
Okay.
For the first 15 minutes.
Okay, I'll do my best to reorganize it really quickly. Let me take it off. Give me a couple minutes.
If it's possible, for the sake of time, if we can just call up a few folks and then we'll try to
Okay,
organize
I have the first few now.
Okay.
All right, the first speakers will be Mai Lindsay, followed by Trent Fontenot, Eric Rochelle, Brandon Itzel, and then Evelyn Lynn.
Okay, if you heard your name called, if you can please line up on the podium.
Good morning. Thank you for the opportunity to speak today.
If you can pull the mic down.
Down, okay.
There you go.
I was tiptoeing, can you tell? My name is Mai Lindsay, and I'm here to share with you why I strongly support Sable, a company that's truly making a meaningful difference. Sable creates stable, well-paying onshore jobs that support the local economy and working families. Sable invests in people. Just look at the team they built. Dedicated, skilled, professional who take pride in their work. Sable also invests in technology, using innovation to safeguard the environment and ensure safety. So I'm asking you today, please support Sable and show that together we can protect our environment and grow our economy. We don't have to choose. We can have both by supporting Sable. Thank you for your time and consideration.
Thank you. And I'll just note, I just want to remind folks, what's before us today is whether the activity was permitted or not permitted. It's not about supporting a company or not, or denying access to the pipeline and the work. It's about whether the activity was permitted or not. And so if we could please be specific on the violations and the alleged violations, that would be really helpful. Thank you.
Good morning, Chairman Cummings and fellow commissioners. My name is Trent Fontenot, and I'm here to express my concerns about jurisdictional overreach that has been increasing over time by the Coastal Commission staff. Despite the Commission itself delegating permitting authority of the Coastal Act to local governments, the actions taken recently by the Coastal Commission staff suggest that they no longer intend to honor those agreements for local governance within the coastal zone. Within the last month, the Coastal Commission lost a lawsuit extremely similar to the issues being discussed here today on the Sable issue. The Commission staff didn't like how San Luis Obispo County managed their LCP, so they tried to unilaterally shut down the clearly permitted access for offshore vehicles at the Oceano Dunes, which resulted in a multi-year lawsuit that ultimately confirmed that it's the counties who manage coastal development permits via the LCP, not the whims of the commission staff. So now the commission staff doesn't like how Santa Barbara County is managing their LCP, when they very clearly said that all of the activities undertaken by Sable was clearly covered by existing permits that the county themselves issued. So instead of learning from that legal defeat, the commission staff intends on doubling down on jurisdictional overreach. How much of our taxpayer dollars are going to be continued to be wasted by the commission staff fighting the very local agencies that they delegated jurisdiction to? This continuing power grab must stop, and stop wasting taxpayer money. Thank you very much.
Please.
Thank you. Again, can we please not applaud? We want to make sure that everybody's voice is heard equally. So,
Eric
next person, please come
Rochelle,
up.
Brandon Itzel, Reed Maxon, Evelyn Lynn, and Ralph Galvin. Eric Rochelle.
Good morning. My name is Eric Rochelle. I'm here to speak on behalf of Sable. I want to start by saying that Sable is, in fact, a reputable corporation that currently employs 100 individuals and 400 mostly unionized contractors. Once restart is approved, an additional 300 jobs will be created. California is the nation's 7th largest oil producer and the nation's 2nd largest oil consumer. We're currently importing more than 3 times the amount of oil that we produce from countries that do not follow the same environmental or health and safety standards that we do. Countries like Ecuador, Colombia, Saudi Arabia, and Iraq. Like it or not, we produce oil in California, we consume oil in California, and it makes more sense to consume a domestically produced product. The work Sable is conducting is authorized by previously approved permits issued by both Santa Barbara County and the Coastal Commission itself. Most of the Sable community lives here. We're your neighbors. We care about the well-being of our community and this coastline just as much as most of all of you do. I respectfully request that you reject this enforcement report and proposed fine. Thank you.
Thank you. Next, Brandon Itzel, Reed Maxon, Evelyn Lynn, Ralph Galvin. If you've heard your name.
Good morning. My name is Evelyn Lynn, and in an effort to keep this moving, I'm just going to go now. I'm here on behalf of Aspen Helicopters. We're based in Oxnard, California. We're an FAA on-demand air carrier. We are based in California. Our employees live in California, and we live in this area, and we feel the daily effects. I'm here to ask your commission to make sure that you follow the rules and you honor the Santa Barbara County stuff and stick within your lane. I say this coming from a federal aviation air carrier, that I am required to follow federal aviation rules, and it's only the stuff that the federal aviation puts out that we have to follow or we have to comply with, which makes us unique. I also am here because we've been supporting Sable for a year now in their efforts to start this onshore product again. If they're not allowed to start their efforts again, this will have huge collateral damage to all of our local businesses and also to our company in particular and all of our local people who live here. As I said, all of our employees are required to live in California. They are all local and they are all affected by what this decision is. Not only do we support Sable, we're also a utility aviation company, and we have responded to all of the major fires using utility aviation aircraft for years all across California, to include all the local fun ones that we know were not fun and that were actually a nightmare, such as the Palisades Fire, the Thomas Fire, and many more. We ask you to please not follow through on these and to consider your role and what your line of operation is and to stay in your lane. Thank you.
Thank you. Please. I'm just going to list off a large group of people. If you're in the overflow room, if you hear your name, please make your way over. If you are in the room, please line up behind the podium in the order as best you can. I'm going to ask you, after you're done speaking, peel off to the right so the person behind you can just come up and speak instead of backing out and coming back in, just for us to save time. Let's go. So I'm going to list off the names: Brandon Itzel, Reed Maxon, Ralph Galvin, Jason Wall, Jose Crespo, Susan Jordan, Maureen Ellenberger, Katie Davis, Donna Will. If you heard your name, please start lining up behind the podium. Next is Brandon Itzel, Reed Maxson, and Ralph Galvin.
Commissioners, good morning. My name is Reed Maxson. I'm a consultant with Sable. I lead a team that specializes in restarting idled facilities. This is a very unique skill set, and this team is the most experienced in the world. We have successfully completed many energy projects together, including refining, offshore production, renewables, and wind. We have a proven strategy that involves methodically testing every inch of pipe, every device, motor, pump, fan, safety device, control system functions. We replace every single failure. The strategy is far more rigorous than any new construction project would ever consider. The testing, the documentation is completed with a higher standard than any regulator requires anywhere in the world, including California. Sable leadership sought out this team to ensure they have a successful restart without incident. I would like to believe if more people understood the care and effort that has gone into making this restart successful and safe, they might get behind us and support this project. The demand for oil and gas is not going away anytime soon. So why not produce it here, where the highest standards for safety and environmental requirements would make this the greenest oil in California by not shipping it in from other countries where these standards are nearly non-existent. Thank you for your time.
Thank you. Next, Brandon Itzel, Ralph Galvin, Jason Wall, Jose Crespo.
Good morning, Chair and Commissioners. My name is Ralph Galvan with Doty Bros. We're a utility construction company, and I'm here to express support for Sable. This project represents a critical opportunity for the region to restore good-paying jobs, union-backed jobs, while reducing the dependence on foreign oil, providing real economic value. At the time when California struggles to afford housing and food, saving money on the pumps matters. Let's be clear, California will continue to need oil for years to come. Even as we transition to cleaner energy, restarting this local infrastructure means fewer emissions from oil shipped from overseas and more energy security here at home. For these reasons, I respectfully urge you to reject the enforcement report and propose fines. Thank you.
Thank you. Still calling for Brandon Itzel, Jason Wall, Jose Crespo, and then we'll move on to Susan Jordan, Maureen Ellenberger, and Katie Davis.
Good morning. My name's Jose Crespo, and I'm here to strongly oppose the enforcement report and penalties against Sable Offshore. Contrary to the Commission staff's framing, this isn't about coastal development, it's about the right to maintain and repair an existing pipeline system. Maintenance and repair work is already fully authorized under existing permits previously granted by both Santa Barbara County and this very Commission. In fact, Santa Barbara County reaffirmed this in February that the repairs were covered under existing permits. The idea stated by the Commission staff that similar repairs have never occurred is blatantly false. Repairs have occurred many times under the existing permits over many years. What we're seeing here is government overreach aimed at shutting down high-skill, high-paying jobs that our communities rely on. Today, I kept hearing the Commission staff use words like repeated, astonishing, and persistent. Well, what I see is the Commission staff's repeated and persistent inconsistencies in the application of rules. Similar repairs have occurred under the existing permits many times before. I'm astonished at their gross violation of county, state, and federal orders which require us to complete these repairs. I'm astonished at their abuse of power in exceeding their authority in attempting to override county and state and federal laws. It's already getting harder and harder to make ends meet in this country, especially in California. I see it every day, parents working multiple jobs, struggling to stay afloat. When governments overreach like this, it doesn't just impact one company, it disrupts an entire web of people. The workers, the local businesses they support, and the families that depend on them. We're not just workers, we're your neighbors. It is deeply troubling to see this unnecessary maintenance characterized as unpermitted development. This kind of regulatory overreach doesn't just cause confusion, it erodes trust in the process and sends a message that following the rules is not enough. We can protect the environment and support working families at the same time. We don't have to choose between them. Sable has followed the rules. They're doing the right thing. Rejecting this enforcement action is about restoring
Thank you.
fairness.
Thank you so much.
Next name, Jason Wall. And then after that, Susan Jordan, Maureen Ellenberger, Katie Davis, Donna Will, Jonathan Ullman, Irene Cook, Bill Woodbridge. Go ahead.
Good morning, Commissioners. My name is Jason Wall, and I'm here on behalf of Doty Brothers representing Sable Offshore. One reason I support Sable is the repair and maintenance work of the Santa Ynez and Las Flores pipeline. It is fully authorized by the prior approval by the coastal development permits for both the Santa Barbara County and the Commission itself in the past. Santa Barbara explicitly confirmed in February 2025 that the anomaly work repaired was authorized by the existing permits. With these similar permits in place, routine maintenance and repair can occur. Events like the 24 sewage spill that had occurred will not occur again with the routine maintenance that we have with the existing permits. If we do not continue with this motto, events like the February 2024 sewage spill will occur time and time again with not just that operator, but any operator in its place, making it more difficult to do the work and be a successful operator, as Sable and the previous owners of the pipeline have expressed. The proposed fine you are considering would be the largest ever for work on a previously disturbed pipeline corridor affecting less than an acre of land. What adverse environmental impacts from this work had resulted from this work? Is there any research that's been delegated out before? This enforcement action creates a troubling atmosphere of regulatory uncertainty that extends beyond this single project. When regulatory goalposts shift unexpectedly, where is the common denominator? It's always changing. There's never a goal. It's always going to be up to whoever is going to be making the decision. Nothing that we can account for. For these reasons, I respectfully request that you reject the enforcement report and the proposed fine. Thank you.
Thank you. Next, Susan Jordan, Maureen Ellenberger, Katie Davis, Donna Will.
Susan Jordan, the Executive Director of the California Coastal Protection Network. To start, I'd like to draw your attention to the letter from Jana Zimmer, a former coastal commissioner, as well as a former land use attorney and chief deputy counsel for land use for the county of Santa Barbara. Jana believes that these so-called repairs do require a CDP. She also states in her letter that your staff should explore all possible steps to revoke the permits Sable and its predecessor, Exxon, received as authorized under the county's LCP-LIP ordinance and Article 2 of the County Code. I know firsthand the damage caused by the 2015 refugee oil spill, not just because, like Linda, I saw the site of the spill firsthand, but I saw it again roughly 2 weeks later, on June 11th, during a field trip with this very commission to Crystal Cove State Park in Orange County, 140 miles away. The beach was littered with tar balls, with feathers and other debris. I knew immediately it was from the spill. I took a sample. That sample was picked up by the California Department of Fish and Wildlife after much insistence by myself, and was confirmed as positive for the oil spill. I'm speaking today on behalf of NRDC and my organization, CCPN, who agree that this is unpermitted development, and we urge the Commission to support the cease and desist order, the restoration order, and levy the administrative penalty. Sable's blatant disregard for the Coastal Act must be stopped right here and right now. Thank you. Please take a look at her letter.
I'm going to call another chunk of names. If you hear your name in the other room, please start making your way over. Maureen Ellenberger, Katie Davis, Donna Will, Jonathan Ullman, Irene Cook, Bill Woodbridge, Melena Seymour, Craig Woodman, Lucy Sexton, Benjamin Butani Goddard. Maureen Ellenberger, go ahead.
Hi, I'm Maureen Ellenberger. I am chair of the Sierra Club Santa Barbara Ventura chapter, and I'm also a member of the Fearless Grandmothers of Santa Barbara. Thank you, commissioners, for being here in Santa Barbara today. It's the site of 2 devastating oil spills that underscore the importance of your work. Next month marks 10 years since the Refugio beach spill of May 19th. We have not forgotten. I stand here in front of you with fire in my heart and with a crucial ask for all of you. Support your enforcement team and take decisive action to stop the restart of this corroded pipeline. I also request consideration of a full coastal development permit process for this effort. Many of us are here today to show you all our unwavering support. Despite intense pressure from political leadership, this commission has not blinked nor bowed down. We urge you to strengthen these orders to prevent Sable's offshore attempt to restart the pipeline along the Gaviota coastline. Have we forgotten 2015? No. Have we forgotten when oil blackened our shores, when wildlife died in agony, when the Refugio oil spill devastated our coast? I know the Coastal Commission hasn't forgotten. You're doing exactly what you've been tasked to do for 50 years. Protect our precious wildlife and California coastal waters and lands. We are at a critical crossroads. In the 1970s, Californians fought to protect our coastal zone. 50 years later, we are still fighting. The California coast shouldn't be for sale. Our waters are not a dumping ground. Our wildlife is not collateral damage, and we should never enable Sable. Thank you.
Thank you, Katie Davis, Donna Will, Jonathan Ullman, Irene Cook.
Hello, I'm Katie Davis, also a longtime volunteer with the Sierra Club, and on behalf of our thousands of local members and supporters. I have never seen so much outrage and passion around an issue as this one. It is something that matters to us here deeply, and we strongly support your staff recommendations. We urge you to stay strong and hold Sable accountable for following the law. The County of Santa Barbara knows that this pipeline and coastal operations are dangerous and risky, and this was a major development. That's why they denied a permit to add safety valves originally. Only after being sued and bullied by Exxon and Sable have they taken this position that they're hands off. And that was alluded to by Sable themselves, that this was a result of litigation and pushing them. Exxon also knows that this pipeline is unsafe to restart and was not workable. That's why they originally proposed building a whole new pipeline rather than restarting the existing one that's prone to corrosion and already caused one major oil spill. They had an EIR in process for that, and they withdrew it. Only after withdrawing the plans for a new pipeline, then Exxon chose to finance a sale to a speculative startup, Sable, rather than take the liability for restart themselves. This is Sable's only asset. It is a heavily indebted company, and if it's shut down due to a spill or another disaster, they're doing this operation in a high fire hazard zone. They're gone, and the residents of California are on the hook. We are on the hook. That last spill cost planes $870 million, and only a fraction of that was covered by insurance. This is Sable's only asset. Sable's seeking a quick profit for themselves while outsourcing all the damage and risk to the rest of us. This is not a risk that California can afford to take. Thank you.
Thank you. Donna Will, Jonathan Ullman, Irene Cook, Bill Woodbridge.
Hello, I'm Donna Will on the board of Get Oil Out. We urge you to adopt your staff's recommendations. These are vitally important on so many levels. 100 years from now, they are going to look back and say, what did we do to protect the coastline? Let's not be the most irresponsible generation in history. Thank you.
Thank you. Jonathan Ullman, Irene Cook, Bill Woodbridge, Milena Seymour.
Chair Cummings, Commissioners, my name is Jonathan Ullman, and I am the director of the Santa Barbara Ventura chapter of the Sierra Club. On behalf of our 12,000 members and supporters in our region, we thank you for continuing to protect the coastal zone. We support items 8.1, 8.2, and 8.3, and ask the Commission to vote to approve the staff recommendation. This majestic section of the California coast has already suffered direly from oil disasters. To make it worse, climate change is now an existential threat to our coast, and no company has a right to pick and choose which laws to follow. We are counting on you and California Attorney General Rob Bonta to stop the unlawful construction work. Lastly, we strongly urge you to require all activities in the coastal zone be subject to a coastal development permit, including restart of the pipeline. We applaud your efforts thus far, and we want you to know that we are 100% behind you. Thank you.
Thank you. I'm calling another group of names: Irene Cook, Bill Woodbridge, Milena Seymour, Craig Woodman, Lucy Sexton, and then Benjamin Butani Godert. Following that group will be a group from a middle school, and I'm going to try to get them out of here before lunch. So, yep. Irene Cook, go ahead.
Irene Cook with the Fearless Grandmothers. The Fearless Grandmothers have attended many meetings about the start of the Santa Ynez unit for several years. In Planning Commission meetings, Board of Supervisors hearings, a state agency town hall, we've spoken to many officials, but the Coastal Commission is the only decision-making body with staff that, without exception, has such strong respect for environmental protection and has given these projects such serious consideration. We're grateful for your diligence in protecting our coast, even in the face of political backlash. We're grateful for your dedicated staff. You're doing the job that voters directed you to do when the Coastal Act was passed years ago. We applaud your courage and determination, and we hope you will continue to defend the coast, this special place, for years to come, for our sacred web of life, for our grandchildren, and for all living creatures. Thank you.
Thank you. Bill Woodbridge, Milena Seymour, Craig Woodman, Lucy Sexton, Benjamin Butani Godert.
Hi, my name is Bill Woodbridge. Thank you very much for being here and giving us this opportunity. With regard to our county's approach to the permit situation, their statements to Sable and their decisions are inept, questionably legal, wrongful, incompetent, and they are certainly not in agreement with a great majority of voters in this county. You have tens of thousands of people in this county who very much support your staff's recommendations, all three of them. Probably millions of people in the state who support your staff's decisions. There are hundreds of them sitting in the overflow room. Yet you have one entity against all of those tens of thousands of people and millions of people in this state who are in agreement with your staff. One entity. It's an irresponsible, lawless, unethical, unscrupulous, greedy corporation that is resisting you. All of these tens of thousands of people are in support of your staff, and we request that you enforce every one of their recommendations on this lawless entity, Sable. Thank you very much. I hope you do the right thing.
Thank you. Milena Seymour, Craig Woodman, Lucy Sexton, Benjamin Butani Godert, and then the middle schoolers. Milena Seymour.
Hello, my name is Milena Seymour. I'm a UCSB undergraduate student affiliated with the Environmental Law Club. I'm here to demonstrate my support of the Coastal Commission's continued actions against Sable Offshore Corp. to prevent further damage to sensitive habitats and hold the violators of the Coastal Act accountable. Items 8.1, 8.2, and 8.3 represent the necessary actions that must be taken against Sable. I support the Commission's decision to hold Sable accountable for their violations, including but not limited to infringement upon environmentally sensitive habitats, improper erosion control mechanisms, unpermitted offshore development using remotely operated vehicles, and inappropriately timed work without consideration of bird nesting and other annual patterns, through a full commission cease and desist order, a restoration order, and an administrative penalty. Thank you for your continued dedication to protecting our coast, and thank you for your tireless work.
Thank you. Craig Woodman, Lucy Sexton, Benjamin Butani Godert, and then our middle school students. We'll start with Noah Lynch, Edie Turbeek, Aaron Finnegan, Jenny Elise Ramirez. So, Craig Woodman, please go ahead.
Good morning. My name's Craig Woodman, and I manage CEQA environmental impact reports and environmental studies in California, Santa Barbara County, for 34 years, including analyzing potential impacts of major oil and gas pipeline projects in the coastal zone of Santa Barbara County. I strongly support items 8.1, 8.2, and 8.3 and ask the Commission to support the staff recommendations. This project needs a new comprehensive environmental review under the California Environmental Quality Act because the environmental studies used to identify potential impacts of the original pipeline were conducted almost 40 years ago, and the types and distributions of environmental resources are not stable over such a long period of time, and environmental regulations change, and mitigation measures designed to reduce or avoid potential impacts get improved. Sable asserts it can rely on permits issued nearly 40 years ago to protect environmental resources from impacts, but as a professional environmental consultant and project manager, I can state this is inaccurate. As the staff report indicates, since the original analyses were conducted in the 80s, many sensitive species have now developed in the area, and several species within the pipeline corridor have now been listed and protected under the Federal Endangered Species Act. Mitigation measures designed decades ago could not protect current species and habitats within the pipeline corridor. And as a professional archaeologist, I can say that there's a high potential for intact archaeological resources to still exist within the pipeline corridor. And I have a strong suspicion that the original surveys, excavations, and analyses.
Thank you.
Anyway, new EIR, please.
Thank you.
Thank you. Lucy Sexton, Benjamin Butani Godert, followed by Noah Lynch, Edie Turbeek, Aaron Finnegan, Jenny Elise Ramirez. Lucy Sexton. I'm not seeing anyone approaching the mic for Lucy. Benjamin Butani Godert.
Thank you. Good morning. My name is Benjamin Butani Godert. I'm a local, active member of the community and proud board member of Santa Barbara Channel Keeper. And I'm here today to add my voice along with the many others in support of items 8.1, 8.2, 8.3, and to ask the commission, of course, to vote to approve staff recommendations. Please act to uphold the mission to protect and enhance our communities for present and future generations. The coastline is something that we all know California is internationally recognized for. It's important for us to protect that. Thank you for doing your job here. We're counting on you and the California Attorney General to stop this flagrantly unlawful construction work, and we also urge you to require all activities in the coastal zone to be subject to coastal development permits, including the restart of this pipeline. Restarting the pipeline is only going to make another spill imminent, and we cannot afford to have another devastating spill or to allow our coasts to suffer any more damage. California and Santa Barbara in particular have been leaders in the environmental efforts, and here we have another opportunity, you, to protect and to continue to show this leadership. Thank you very much for protecting the coastline and our communities from another disastrous spill. We trust you will do the right thing and keep up the good work. Thank you.
Thank you. One last call for Lucy Sexton. And following that will be Noah Lynch, Edie Turbeek, Aaron Finnegan, Jenny Elise Ramirez, Elsie Tollefson, Brooke Burney. Noah Lynch, please go ahead. You can pull it down further. There you go.
My name is Noah Lynch. I'm 12 years old and in 6th grade, and I go to Santa Barbara Middle School. This industry continues to destroy marine wildlife and the possibility to dive, swim, or do any activities in the ocean. I've recently got into surfing, and this oil rig starts extracting oil. Eventually, there will be an oil spill that will destroy the ocean for everyone. In the future, I want to see seals, dolphins, and fish roaming in the ocean without plastic, oil, or remnants of human waste. If this industry continues, the beauty of Santa Barbara will be a myth that people used to dream about. Oil industry is destroying our planet and it's leaving a mess for my generation and future generations to deal with. I just want to change something about how we care for our oceans. I'm here because you can make a difference and hold them accountable, and I hope you do so. We ask you to save our oceans. Thank you.
Thank you. Edie Turbeek, Aaron Finnegan, Jenny Elise Ramirez.
Hi, my name is Edie Turbeek, and I'm speaking against another oil rig. I'm a 12-year-old sixth grader at SBMS. Just think for a moment about the ocean, its striking beauty, and all the resources and joy it brings us. I mean, all of us love the ocean in different ways for different reasons. And think of all the things it gives us: salt, fish, food, those shells we all picked up. And here we are, with people about to hurt it by adding an oil rig. What would one more do for us versus what it would do to the ocean? A large percentage of those things are the reason the oceans are hurting. Do you want your kids, grandkids, or great-grandkids to grow up not knowing what a coral reef is because they don't even exist? Many creatures rely on coral reefs for survival, and oil rigs destroy them. Do you really want that for the oceans, for yourselves? Thank you.
Thank you. Eric Finnegan, Jenny Elise Ramirez, Elsie Tollefson, Brooke Burney, and Amelia Madej. Aaron Finnegan.
Hello, I'm Erin Finnegan. I work at Santa Barbara Middle School. The coastline is an integral part of our school curriculum. Our students spend time in, on, and around our coastline and in the ocean, learning, exploring, playing. During their years in middle school, our students have the unique opportunity to experience and have hands-on learning about all our California coastline from Monterey to Ventura and out to all the Channel Islands. It is this kind of life experience that teaches one to love the environment, and what you love, you want to protect. This is our home, this is our classroom, and this is our livelihood. Another oil spill would be disastrous to our cultural and environmental resources, our wildlife, our community, our livelihood, and our quality of life. It affects all of us, including our local Sable workers. Thank you for continuing to protect the coastal zone through your enforcement actions related to the activities on the Santa Ynez unit. We are counting on you and the California Attorney General to stop the unlawful construction work. I support items 8.1, 8.2, and 8.3, and I ask the Commission to vote to approve staff recommendations. I urge you to require all activities in the coastal zone to be subject to a coastal developmental permit, including the restart of the pipeline. Thank you.
Thank you. Jenny Elise Ramirez, Elsie Tollefson, Brooke Burney, Amelia Madej.
Hi everyone, I am Jenny Elise Ramirez. I am also a staff member at Santa Barbara Middle School here with all of our wonderful children. Just like Aaron said, the ocean is an integral part of our outdoor education program, especially our Friday morning sunrise swims. If anybody has been around Ledbetter, we get about 100 to 150 people out there swimming in the ocean at 7 a.m. We have a lot of students that are passionate about this, hence we have a lot of them here with us to speak on this matter. I support the Coastal Commission in making sure that we do not have more oil spills in our coast. Thank you.
Thank you. Elsie Tollefson, Brooke Burney, Amelia Madej, and Lily Palmer.
Hi, I'm Elsie Tollefson, and I'm a student at Santa Barbara Middle School. I may not know as much about these specific issues as all of you guys, but I do know I grew up in Santa Barbara, walking the beaches, swimming in the oceans, and playing beach volleyball. It's part of the SBMS curriculum. I spend so many of my mornings at the beach playing volleyball or going for early morning swims. They are some of my favorite memories. When I'm swimming, I love to catch the rare glimpse of a fish or see the harbor seals lounging. I can't imagine all of this being taken away because we shouldn't have to grow up in a world where having an oil spill is a constant threat. One oil spill can wipe out an entire ecosystem. It pollutes our beaches, our clean water, and kills off the marine life that calls the ocean home. So I support the staff recommendation. Thank you.
Thank you. Brooke Burney, Amelia Madej, Lily Palmer, Gus Larson.
Hi, my name is Brooke. I am 15 years old. I'm in 9th grade at Santa Barbara Middle School. I've lived on the Santa Barbara coastline my entire life, and the beach is a huge part of who I am. It is where I learn to swim, where I hang out with my friends, and it brings me so much joy. The ocean is very special to me, and I go to the beach at least 3 to 4 times a week. I hate the idea of the ocean being polluted by oil more, and the sea life is essential for so many. These spills threaten so many lives of animals and people. I want future generations to be able to grow up feeling safe in the water, just like I did, and they deserve to swim in a natural environment. I want to do whatever I can to help save the ocean. Thank you for your time. I support the staff recommendation.
Thank you. Amelia Madej, Lily Palmer, Gus Larson, Delilah Ficker.
Hello, my name is Amelia Madej.
Can you pull the mic down to your mouth? There we go. Thank you.
I go to Santa Barbara Middle School. I'm in 6th grade and I'm 12 years old. I've lived in this beautiful town all of my life. I want to talk about why this pipeline is a horrible idea and why we need to stop it. The beach isn't just a place to visit, it's where memories are made. We've all had great days there with family or friends, spending time at this magical place. It's also home to amazing animals like dolphins, seabirds, and fish. It's a place full of life. But a pipeline spill will destroy all of that and more. The water and sand would be covered in toxic oil. The animals could die. The beach would become vacated and unsafe. That's not the kind of future we want. Sable might make money, but we'd be left with the damage on our economy, environment, and stunning coastline. And some things, like memories, animals, and clean oceans, are priceless. Let's protect the beach, the animals, and the memories we will make there. Support the staff recommendation. Say no to the pipeline. Thank you.
Thank you. Lily Palmer, Gus Larson, Delilah Ficker, and Xander Peterson.
Hi everyone, my name is Lily Palmer and I'm a 9th grader at Santa Barbara Middle School. I am speaking in support of the staff recommendation. I have lived in Santa Barbara my whole life and these beaches are so important to me as I'm sure they are to many of you. I grew up a short walk from the beach and have always loved swimming in the ocean, playing beach volleyball, going on beach walks, and sharing time at the beach with friends and family. I would be devastated if our channel was polluted with oil and the beaches covered in tar. They are so vital to Santa Barbara as a community and I hope we are able to help save our ecosystem in the special place that is important to so many. I ask you at Sable, don't think solely of the money made, think about the people, wildlife, and land affected. Thank you.
Thank you. Gus Larson, Delilah Ficker, Xander Peterson, and Story Eaton.
Hello, my name is Gus Larson. I am part of SBMS's 9th grade leadership program. Santa Barbara is a maritime community. It was for your generation, and it will be for our generation, the next generation. And the fact that you are willing to gamble another huge oil spill is disgusting. Your choices today not only affect the economy, but the fishing industry, the boating industry, and most importantly, it affects all of us here today. But it doesn't stop there. It won't affect us today, or for a few months. It'll continually affect our community for years to come. But most importantly, it affects the employees at Sable. I know each and every one of them has a good heart, is hardworking, and has good intentions. And it is completely unethical that these civil employees have to decide between protecting their families and protecting the environment that many of us call home. Don't just think about the money. Think about the fish, the animals. Think about the children who might never get to see the beauty of Santa Barbara. Think about us. Don't enable Sable. Thank you.
Thank you. Delilah Ficker, Xander Peterson, Story Eaton, and Henry Schneider.
Hi, my name is Delilah Ficker, and the ocean means everything to me. I grew up on a sailboat, so it is where I feel most connected to nature and where I've made amazing memories. But putting more oil rigs in the water risks all of that. Spills can destroy ecosystems, hurt wildlife, and ruin coastlines for generations. One spill can wipe out everything we love about the ocean, like sea life, clean beaches, and the magic of just being there. We can't keep trading the beauty in our lives for profit. The ocean isn't a dumping ground, it's a lifeline, and we need to protect it. So many of my passions revolve around the ocean, like scuba diving, beach volleyball, surfing, fishing, sailing, and so much more. We should be protecting the ocean, not endangering it, because I want our generations to have just as special of a connection to the ocean that we have. Don't put this incredible part of our planet at risk and help stop offshore drilling.
Thank you. Xander Peterson, Story Eaton, Henry Schneider, and Maya Lynch.
Hello, I'm Xander Peterson. I've spent my entire life aside the Santa Barbara coastline, and I don't plan on leaving anytime soon. I never thought I'd be speaking in front of so many people, but when something as magical and special as our maritime community is being put on the line, I can't help but speak up. The Santa Barbara coastline is a huge part of who I am, and I think anyone else here can say the same about themselves. The coast has served my community for years and will continue to do so. It's a home, a career, a beauty, and a community. What appalls me is how quickly anyone would put down everything we love about it on the line for some cash. Don't just think about your wallets. Think about Santa Barbara. Don't enable Sable. Thank you.
Thank you. Story Eaton, Henry Schneider, Maya Lynch, and Ronan Castorino.
Hello, my name is Story Eaton, and I am 15 years old. I was born and raised in Santa Barbara, and the ocean has always been a really important part of my life. I'm a surfer and a beach volleyball player who spends at least 5 days a week at the ocean. I usually see seals and dolphins when I go surfing, and if Sable installs another oil rig, many marine animals and their ecosystems will be deeply harmed by the risks that the rig will bring. We have already experienced a massive oil spill off of Refugio in 2015 and seen the consequences that it caused. Let's not repeat our past mistakes. Support the staff recommendation. Thank you for protecting our coastline.
Thank you. Henry Schneider, Maya Lynch, Ronan Castorino, and then Coral Castorino.
Good morning. My name is Henry Schneider. I'm 15 and a 9th grader at Santa Barbara Middle School. I'm here to speak today because the ocean means so much to me. As a surfer, volleyball player, and Santa Barbara resident, the ocean is my playground and a vital part of my community. I want my kids and their kids to experience the beautiful memories of jumping off rocks at Campus Point or walking down Butterfly Beach during the sunset without worrying about tar on their feet. We can't just keep letting these big oil corporations like Sable destroy our amazing ecosystems and coastline. If another oil spill like 2015 happens again, we risk losing not just our beaches, but our local economy, way of life, and the natural beauty that defines our home. It's time to protect what we love before it's too late. Thank you.
Thank you. Maya Lynch, Ronan Castorino, Coral Castorino, and Jesse Brutoco.
Hi, my name is Maya Lynch, and I'm a 9th grader at Santa Barbara Middle School. I'm a surfer and an ocean lover. The ocean is a major part of my life and community in Santa Barbara. The ocean and beach are places that I spend and dedicate most of my time to, whether it be playing beach volleyball, surfing with my friends and family, swimming, or just about anything. The Sable Oil Project, which is projected to have an oil spill each year, will greatly affect these passions and activities for not just me, but for the whole community and our channel. I can think back to a time from when I was a little kid doing a summer camp. Our mornings started as normal until kids started coming out of the water coated in tar. This was from only a minor oil leakage. I was only 9, yet I remember so clearly the kids with tar on their faces, feet, hands, and even hair. In the heat of summer, we couldn't go in the water due to a small leakage. Now imagine if we had yearly oil spills bigger than this. We are so lucky to have the Santa Barbara Channel be as diverse as it is, and we don't want to change that. But yearly oil spills will. People always talk about how they want to make a bigger difference in our world. I support the staff recommendation. Thank you for your consideration.
Thank you. Ronan Castorino, Coral Castorino, Jesse Brutoco, and Wyatt Wagner.
Hello, my name is Ronan Castorino. I'm 15 years old and go to school at Santa Barbara Middle School. I was born and raised in Santa Barbara and have been near the ocean since before I can remember. I have since developed a love for all things related to the ocean. Whether I'm surfing or just at the beach with my family, the ocean has always been there for me, and no matter what, and now I'm here to support it. I hope to be able to pass my love for the ocean down to my children in clean waters. More oil spills would destroy our waters, and I witnessed the effects of the 2015 spill firsthand. The ocean matters to me and my community more than anything, and that's why I say no to Sable. Thank you.
Thank you. Coral Castorino, Jesse Brutoco, Wyatt Wagner, Dylan Diniselli. Dinselli.
Hi, my name is Coral Castorino, and I am from Santa Barbara Middle School, and I am 12 years old and in 7th grade. I don't think oil rigs should be put in Santa Barbara. Our beaches are beautiful, and putting oil rigs out there could ruin them. What if there's an oil spill? Sea animals could get hurt, and the water would be gross and dirty. People come here to surf, swim, and enjoy nature, not to see big metal machines in the ocean. I think we should protect the environment, not mess it up, just to make money. Please don't put oil rigs in our ocean. Thank you.
Thank you. Jesse Brutoco, Wyatt Wagner, Dylan Dinselli, and then our last speaker from the middle school that we have is Ethan Madej.
Hi, I'm Jesse Brutoco, and I'm here to tell you why offshore drilling is an unfair and unkind way to treat our environment. What's Santa Barbara known for? Its beaches. And if we allow offshore drilling, It will be destroying our beaches and our environment. Animals can and will be injured or die. But not only as a team, but as a community, we can make a difference. I've been going to the beach my whole life. Me and many others would be devastated to see these beaches that we hold so dear to us go. I'm speaking with the count of Santa Barbara Middle School, so let's make things happen. Thank you.
Thank you, Wyatt Wagner, Dylan Dencelli, and Ethan Madej.
Hi, I'm Wyatt Wagner. I attend Santa Barbara Middle School. I have grown up at the beach, diving into the ocean every day. Going to the beach every weekend, to the oceans. The ocean has provided so much for all of us. Food, exercise, and endless memories with friends. If Sable is enabled, this could all go away. Beneath the waves, where creatures play, an oil pipeline blocks their way. The ocean's blue, so deep and wide, hides wounds that flow where shadows hide. With every spill, a silent cry, as fragile life begins to die. The beauty lost, the balance swayed. In greed's pursuit, natural frayed. O Pacific vast, we must defend. Protect your shores, let this not end. For in your depths, life stories thrive. Let's choose a path that keeps them alive. We are all human. Let's preserve our oceans so our kids don't have to inherit this problem. I support the Coastal Commission.
Thank you. Dylan Dencelli, Ethan Madej, and then I'll start calling other names if we would like to do that. Yep. Go ahead.
Hi, my name is Dylan Dencelli, and I'm a 9th grader at Santa Barbara Middle School. I'm 15 years old, and I was born in Santa Barbara, and I've lived here my whole life. Some of my very first memories are at the Santa Barbara beaches, and I treasure the coast very dearly. I play volleyball at the beach, go there with my friends nearly every weekend, walk on the pier and by the seaside, and I swim and play and lay beside it all year round. So much of my daily life revolves around the coast, and many of my peers' lives do too, as evident gathered by the crowd here today. I am against Sable, because it is extremely likely that this oil project will cause serious damage to our cherished coast and the wildlife here. Statistically, there will be a regular oil spill every year and a major oil spill every 4 years, caused by the improper care of Sable that will be equal to or worse than the devastating 2015 spill. If this were to occur, it would not only deeply disrupt the animals and environment here, but also the family, friends, and neighbors who eat from our ocean, build their families and lives here, and depend on our coast for work. I urge you, please, do not let Sable begin drilling for oil. It will undoubtedly cause long-term damage and potentially irreversible harm to the coast that me and everyone in our maritime community needs and loves. Thank you.
Thank you. And then Ethan Madej.
Hi, I'm Ethan Madej. I am a 9th grader at Santa Barbara Middle School. First off, I wanted to thank you for all of the hard work that you are doing to protect our coastline. And thank you for hearing us today. That said, none of us should be here right now. We should all be at school. But we are here because we care. We're here with the blessing of our teachers and the support of our families and our friends who couldn't make it. We urge you, do not enable Sable. I understand that this is a permitting issue, and it's kind of limited to that scope. But we cannot let a permitting issue get in the way of our coastline. And we cannot listen to a permit that was made in the 1970s. That is just absolutely ridiculous that we're even considering that. We really, really need to be thinking about the long-term effects and the corporation itself that is being held, that should be held responsible. If they cannot ensure and protect our coastline in the event of a spill, then they cannot have these permits. And in this case, they are not listening to the California Coastal Commission. We cannot let corporations step and walk all over us. We need to stand up to Sable Oil, and we need to protect our coastline. Thank you for all of the work you are doing. Thank you.
Thank you. And I'd like to go to the chair really quick, just before I read off a bunch of names. How many do you think we should get through before we take a break for lunch?
How many speakers do we have left?
We still have over 80.
Over 80?
Yes.
Okay. So we, give me one sec. All right, so we're going to do the next 20 speakers, and then I think we'll probably need to take a break. What I'm going to try to recommend, as was exhibited by the middle school students, I think most of them were able to finish their comments within a minute. So we're going to give you 2 minutes, but we're just going to encourage the next suite of speakers. If you can try to keep it brief, get to the point, we can get through this a lot more quickly.
Okay, I've sectioned out the next 20 people. I'm going to list all your names, so if you don't hear your name, you might want to get a head start on lunch. Steve Balcom, Jeremy Willett, Lila Werland, Stephanie Caters, Elena Danielson, Connie Gillies, Sierra Ferrante, Janet Blevins, Albert Oaten, Jenna McGovern, Mary Bird, Jake Twomey, Spencer James, Dean Plaister, Bill Hickman, Molly Troop, David Quezada, Michael Lynch, Michael Torbenson, and Brady Bradshaw. Again, if you heard your name either in this room or in the overflow room, you can start making your way over. I'll call out the names again: Steve Balcom, Jeremy Willett, Lila Werland, Stephanie Caters, Elena Danielson, Connie Gillies, Sierra Ferrante, Janet Blevins, Albert Oaten, Jenna McGovern, Mary Bird, Jake Twomey, Spencer James, Dean Plaister, Bill Hickman, Molly Troop, David Quezada, Michael Lynch, Michael Torbenson, and Brady Bradshaw. So starting now, Steve Balcom, followed by Jeremy Willett and Lila Werland. Please go ahead.
Hello, everybody. Just my luck, I'd have to go over the sixth graders. I don't have anything prepared. I basically have been listening to all these conversations, and there are things that I pick up, and one of them is always the anomalies on the pipeline, and my God, this pipeline has 180 anomalies. My question to the committee, has everybody checked what's an average to a major pipeline over 10 years and the anomalies that these pipelines have? I don't know if anybody's done that background check, but they always go to this pipeline for 180 anomalies. Somebody's got to tell me, is that abnormal? I don't think it is. I've been doing this for 40 years, and I really think that this thing can accommodate both the community and the necessities of California. I don't understand how we can go through a carbon print, which is not talked about, to get oil from other countries. And I don't know if anybody's ever looked it up. These container ships and cargo ships, does anybody have any idea how many mammals are killed every year with these ships? Look it up. It's hundreds of thousands of mammals that are killed by these ships, but yet we don't talk about that. We have the resources right here in Southern California, and we can do something right to the public. And no disrespect to the senator, but she don't have a clue what she's talking about. And I get it. I mean, politicians, don't let the truth get in the way of your agenda. But the public hears this stuff and they believe it. And again, I've been doing this for 40 years. It's been a good living. I've been I was surfing. Started at 15 years old in Southern California. I was a judge for surfing contest for juniors. The ocean hasn't changed that much. Thank you.
Thank you. And, we're going to try to go till 1. So, because I've just noticed that there are some people whose names are getting called and they're not necessarily here and they're not coming up to comment. So we're going to try to get through as many people as we can until 1 o'clock. So we'll continue on with the names that you called, and then we'll just continue moving forward as efficiently as possible until we get to 1 o'clock.
All right, sounds good. Next, Jeremy Willett, Lila Werland, Stephanie Caters, Elena Danielson, Connie Gillies. If any of you have heard your name, please approach.
So if you heard your name, please approach the podium.
Any order. Just go ahead.
Alrighty. Hi, my name is Lila Werland. I'm a student at UCSB representing the Environmental Law Club and Stop Sable initiative. I strongly support the staff recommendations on penalty on Sable. First of all, thank you to the presenters, the staff presenters, on their thorough presentation on all the facts of the issue. Sable has violated several cease and desist orders, refused to provide an action plan, and relentlessly break rules, giving the staff the grounds to enforce penalty. Actions like these need adequate consequences. The pipeline would affect our local waters, and we need to take the voices of local residents more so than a company with no regard for rules and regulations. Thank you for continuing to protect our coastline.
Thank you. Jeremy Willett, Stephanie Caters, Elena Danielson, Connie Gillies, Sierra Ferrante, Janet Blevins. Go ahead.
Hi, my name is Connie Gillies, and I am a resident of Santa Barbara. I wanted to make everyone aware that there is a film as part of the Marjorie Luke Green film series on Sunday called Broke. And this film is exactly about what we're talking about right now, the broken Refugio pipeline. So that's at the Marjorie Luke Theater on Sunday at 4 o'clock. And the Marjorie Luke Theater is at the Santa Barbara Middle School. Actually, Santa Barbara Junior High. Sorry about that. I'm more nervous than these kids. I've been doing this for years. Anyway, in addition, I would like to say that we all understand the need to earn a living for our families. I taught kindergarten all week long and put on environmental kids concerts on the weekends to inspire kids to protect and save our earth. As I said, we all understand everyone's need to earn money for our families. But we all also have to understand that oil is the way of the past. The earth is telling us that clearly, and you heard this morning how Sable has already spent over a year disregarding environmental protections. Permits or no permits, who's paying attention to them or not, there has been a blatant disregard for environmental protections already, and I think everybody has seen that. And so instead of investing in a troubled past, we should be putting our efforts and investments into the future, which means clean, renewable energy, which will help to save the extremely precious Santa Barbara Channel from another disaster. I have spent the last month volunteering to pin locations of sick and dying sea lions, seals, and dolphins. I'm not kidding. Down at Henry's Beach, to the right of the boathouse, every 50 to 100 feet, there is a dead or dying sea lion or seal and dolphin. That's just from the algae blooms. And this is an incredibly precious Santa Barbara Channel with the largest mammal on Earth, the blue whale, orcas, etc.
Thank you.
So let's find them.
Thank you. Next, Jeremy Willett, Stephanie Caters, Elena Danielson, Sierra Ferrante, Janet Blevins. Go ahead.
I don't see Jeremy Willett, so I'm up. I'm Stephanie Caters. Hello, commissioners. I live in Santa Barbara. I have for decades raised my child here. I care about the oceans and the coastline. I also work for Sable. I know firsthand they're a conscientious company complying with dozens of regulators from federal to state to local levels. Repair and maintenance work on the pipeline was fully authorized by previously approved coastal development permits from Santa Barbara County and also the Commission. In February of this year, the county confirmed that repair work was authorized under existing permits. Ending oil and gas investment here only adds to dirtier production overseas, making global emissions soar, which is precisely what we don't want. And wherever that somewhere else is, does not have California's exceptional labor laws, stringent environmental protections. Sable will actually help contribute to our clean energy future. Individual layers and solar panels are made with petrochemicals. Solar panels become hazardous waste after their lifespan is up, but will you stop solar panels in coastal California due to that? I doubt it. We've got great sun here. We also have one of the largest natural petroleum seepages in the world right here in the Santa Barbara Channel. Oil production in our channel helps capture and reduce naturally occurring methane, organic gas, and liquid petroleum. Even if you got rid of gasoline for vehicles, petroleum products are used in thousands of everyday items, and you can't make wind farms or electric vehicles without it. Without petroleum, are you prepared to stop flying anywhere for vacation or to business meetings like this? Planes use petroleum not just for jet fuel, but in the manufacturing of wings and upholstery and cushions in those overhead panels. If you were to just simply walk, you're still on asphalt roads.
Thank you.
Thank you.
Thank you.
Next, Elena Danielson, Sierra Ferrante, Janet Blevins, Albert Oden, Jenna McGovern.
Hello, my name is Elena Danielson. I'm ashamed to see this propaganda act to bring all these children to speak and to read the scripts written by somebody else. I'm a grandmother. My grandchildren are 10, 12, 13, exactly that age, and involve children to bring. We love the ocean. We want the best for the coastal, and I'm a resident of Santa Barbara. The Coastal Commission years ago was started to protect the public access to the beaches, that everyone, to protect the residents, and now it became another political I don't know what to say, tool for to act. Look at what's happening. All the victims of the fires and Palisades, they need the permits, and instead of we're hearing something against Sable. Sable worked with all the permits, and you all know about that. Even you, I see you, Snowden, I see all of that. But they worked permitted. So the spill in 2015 was horrific, and we all know that, and we don't want it to happen. And that's exactly why Sable is doing that permitted work to do repairs. There is no replacement energy, solar panels or anything else. And Sable is one of the companies that puts millions of dollars into research. And then, of course, they would like to bring all this clean energy, jobs, and prosperity to the county of Santa Barbara and to the residents. And then bringing children or Julia Dreyfus to insult these hundreds of hardworking men and women who live here, who bring their family and their children, it's a disgrace. So be at least fair, stop being hypocritical. Thank you.
Thank you. Sierra Ferrante, Janet Blevins, Albert Oden, Jenna McGovern.
Hello, I'm Sierra Ferrante. I'm with CalPERG Students, a nonprofit representing over 28,000 student members across the state, and I think you can probably tell how I feel about oil. So I thank the agency staff and the commission for taking action on this issue, and I'm proud to live in a state that has a world-famous coastline and laws to protect it. I believe that we live in a country and a state where no one is above the law. Sable has violated the law, laws that were created by legislators in positions elected by the voters of California to represent our interests. And if my UCSB environmental law class has taught me anything, it's that this is just the type of situation that the Coastal Act, CEQA, and any other environmental law written by our representatives are intended to address. If Sable can blatantly defy multiple agency orders without penalty, what else can they or anyone else get away with? Sable claims that they should not receive penalty because they have supposedly minimized harm, and I obviously care deeply about the environment, but the question here is if they worked without a permit and violated cease and desist orders, which they did. You saw date mark videos proving this. And so by defying agency directives, they have violated the law. And so, the Commission has my gratitude as a young voting Californian for doing your civic duty by imposing lawfully sanctioned penalties. The rest of my statement I address not only to the Commission itself, but to all of my fellow voters present, as well as Governor Newsom and any other legislator with oversight on this Commission. And by reading into the public record that I personally, and on behalf of 28,000 student members, support the California Coastal Commission in taking strong action to penalize Sable to the full extent of the law, as well as conducting a full environmental review under CEQA for this project. This support we have shown to the Commission here and every day since, and I call on all of you to continue to show this support when we next cast our votes. So thank you, and thank all of you.
Thank you. Janet Blevins, Albert Oden, Jenna McGovern, Mary Bird, Jake Twomey. Go ahead.
Hi, I'm not Janet Blevins. Oh, she's not here. Okay, I'm Albert Oden. I just want to say one of the things that's sort of interesting, I'm not as smart as these people, I don't know enough details, but I do know a couple of details that things might be interesting to you. The only reason why staff is here and why you are here is because there was an oil spill in 1969 in Santa Barbara. That oil spill so outraged the UCSB community and the people that lived here, they said it lays bare the notion that businesses can self-regulate. It lays bare the notion that the agencies and governance we have along our coastline can regulate those businesses, that the asymmetric power between businesses and those small agencies and counties and things like that was not sufficient to protect the coastline. That's what gave rise to the California Commission, that you are all a part of today. So thank you for that. That is what gave rise to the staff that you are part of. It is your lane. It is the lane that you have to cover and protect the California coastline. That is your lane. Because what we showed in 1969 is that when we leave it to small municipalities and counties and all those things, they're all subject to power dynamics and asymmetric power that can be used to bully them. You are the agency that's not supposed to be bullied, so don't be bullied. Don't be bullied. So the last thing I would say is just this. I'm also a business person. It's annoying that I have to go through a big process with you to get an ADU approved on the coastline. It's really annoying. But I take comfort in the fact that my next door neighbor can't put in an oil well next to me, and it's because of you. It's annoying, but because of you, I know my property will retain its value. It's annoying that when I wanted to restore the kelp reefs in the Goleta Bay, we had to spend tons of money and years to get you to approve it. Had I known that we just need to have an explosive oil well and then we could just do it whatever we wanted, that might have been the way to go.
Thank you.
Don't be bullied.
Thank you. Please. Jenna McGovern.
Please hold your applause. We've been doing great thus far. Thank you.
Jenna McGovern, Mary Bird, Jake Twomey, Spencer James.
Good afternoon, Commissioners. My name is Jenna McGovern, and I'm with the UCSB Environmental Affairs Board and the Stop Sable Coalition. I first want to thank you for your work that you provide on our coast and protecting our resources, and for meeting us here in Santa Barbara. I could talk about the environmental implications and concerns from restarting these systems, but I think the middle schoolers had that covered. I do want to discuss Sable's integrity, ethics, and extensive history of noncompliance. It should be extremely concerning to everybody in this room that Sable has violated your cease and desist and entirely failed to communicate with the CCC after repeatedly seeking to settle matters in a civil manner. And it's not a complicated ask. It's simply to abide by the law the same way we all do every day. Frankly, this behavior is embarrassing, and we are tired of it. We've spent countless hours and days on this matter, and it's baffling that this level of disobedience is even up for debate. Sable believes they can rely on permits issued nearly 40 years ago, but these facilities haven't just stood still since then. Since 1986, they have changed ownership multiple times, corroded irreparably, and been decommissioned for the past 10 years. Sable is simultaneously stuck in the past and not learning from it. Their activity has already cost the state money, and that's without any oil even running through these pipelines. We've seen that Sable is capable of showing up and capable of communicating and attending these decision meetings, yet they've refused months of commission regulations. So I wonder why they're even here today. I urge you to be resolute and stand your ground against Sable. I am in full support of the commission. Thank you.
Hi, I'm Mary Bird, and I've lived here 30 years. We raised our kids here on the beaches, at the campgrounds, at the ocean. We all love our beautiful California coast. And so you, at the commission, you are our heroes. You're our heroes for protecting this beautiful coast. So thank you, thank you, thank you for trying to stop the invasive activities of the pipeline company. And we want you to continue. I support 8.1, 8.2, 8.3 on the agenda, and especially the idea that any coastal activities should have to have a coastal development permit. So yes, I do remember the spill in 10 years ago. It was devastating. It broke our hearts, and we can't have that happen again. So please stay strong. We need you to be our watchdog. We're counting on you. Thank you.
Jake Tawami, Spencer Jamies, Dean Plaister, Bill Hickman, Molly Trout, David Quezada, Michael Lynch, Michael Torbenson, and Brady Bradshaw.
Hi, Coastal Commission. My name is Jake Toomey. Really happy to be here. And I'm the chair of CalPERG Students, which is an organization that represents 28,000 dues-paying students from across the state of California, with hundreds of volunteers, many of which are here today skipping class because this is really important. I'm not going to tell you anything you don't already know. Sable is an irresponsible company. It's pretty new. It's from Texas. And they had a pattern of disregarding what's important for our environment. It seems to me that the only real asset that they can use are these hats, but otherwise they're betting big on making sure that they can use this pipeline. But we need to make sure that that doesn't happen. We know what it looks like when we're irresponsible with our coast. And I know that the Coastal Commission has done an amazing job in standing up strong and not letting yourself be bullied by big corporate interests who do not have the interests of Californians in mind. So I'll keep it short, and I just want to say, stick by your guns, and please take the enforcement staff's recommendation. Thank you.
Aku Spencer Gakti, Klekan Helu Siokton Hel Kapapanish Homoloch Hinachalamuhilimu. Hello, my name is Spencer, and I want to welcome the Commission to our territory, the Chumash territory, to Siokton in specific, where my family's been living here for thousands of years since our creation. I'm here speaking on behalf of Sacred Places Institute for Indigenous Peoples. I'm here to express our firm opposition to the restart of the Sable pipeline along the Gaviota coast within unceded Chumash territory. Our concern is deeply rooted in the potential environmental and cultural risk if the Sable offshore pipeline is allowed to restart. Again, we urge the California Coastal Commission to prioritize free, prior, and informed consent as directed by the United Nations Declaration of Rights of Indigenous Peoples, in addition to engaging in meaningful consultation with the Chumash peoples of all Chumash nations, as well as to consider the long-term cultural and spiritual impacts this project will have on our ancestral villages of Casio, Mikiu, and Aputi Waianamu. We support the Coastal Commission in issuing a mandatory restoration penalty towards Sable Offshore. We suggest that the Coastal Commission requires Sable Offshore to conduct meaningful consultation and hire Chumash peoples to conduct the restoration project to ensure native landscapes are restored properly and respectfully. We support the Coastal Commission in issuing Sable Offshore fines for the violations. Furthermore, we recommend that any amount of the appropriate fines that the Coastal Commission receives from Sable Offshore, a respectable amount of that be granted to Chumash tribal governments and Chumash nonprofits that support and uplift ocean and coastal stewardship and culture. Kakinalan, thank you.
Good morning, Commissioners. My name is David Casada. I've been a utility worker here in Southern California for 30 years. My family has lived in this great state for 4 generations. I work for the Doty brothers, a minority-owned business performing pipeline construction work in Southern California since 1935. We work with Sable Oil, and they have more than proven to be a trusted partner who understands the oil and gas industry and how to apply the most stringent safety protocols during the course of construction. I support Sable's repair and maintenance work on the San Ynez unit and Las Flores pipeline systems because I believe that Sable Oil has performed their due diligence, followed every procedure, and adhered to the process by operating under approved coastal development permits from Santa Barbara County and previously approved permits from the Commission. I don't want California to have to buy its oil from foreign countries, who in many cases don't even like America, and who have been known to burn our flag anytime they feel like it. We need jobs here in California. We need to drive our own oil prices down. I believe that we not only need to buy American, but we also need to buy Californian. I respectfully request that you reject the enforcement report and the proposed fine. Thank you.
Thank you. Next, Dean Plaister, Bill Hickman, Molly Troop, Michael Lynch.
Chairman and Commissioners, my name is Dean Plaister, and I'm a member of the Executive Committee of Surfrider Foundation Santa Barbara Chapter. I want to thank you for your efforts to maintain the quality of our coastline and for hearing this particular issue locally. I urge you to follow staff's recommendations on items 8.1, 8.2, and 8.3. Though many Sable employees have experience in the oil business, it is a new and unproven company, and apparently not much given to following regulatory directives. If the coast is going to again be put at risk with a restart of oil operations, we need the operator to be more accountable. Their unpermitted construction work should be halted, and a coastal development permit be required for any pipeline restart. That pipeline made a mess on May 19th, 2015, and I spent the next day scooping a small percentage of it into 5-gallon buckets while sea life around me drowned in oil. Nobody, whether environmentalist or oil worker, wants to see that happen again. Please support staff recommendations and hold Sable to all regulatory requirements. Thank you.
Thank you. Bill Hickman, Molly Troop, Michael Lynch, Michael Torbenson, and Brady Bradshaw.
Hello, my name is Bill Hickman, representing the Surfrider Foundation. Thank you for all of your hard work that you do to help protect the coast. The 2015 pipeline failure that spilled hundreds of thousands of oil should be referred to as the Plains All-American oil spill. It's important to identify oil spills by the companies that cause them rather than the communities that are affected. You have the opportunity to help prevent a future Sable oil spill by requiring them to go through all of the necessary steps for the proper permits and approvals, including what's in front of you today. Coastal oil spills are the worst kind of oil spills because they are tough to contain and they can spread quickly with devastating impacts to wildlife and tourism. The staff report today was incredible. We support items 8.1, 8.2, and 8.3 and ask you to approve all of the staff recommendations. We are counting on you and the California Attorney General to stop the unlawful construction work. We further urge you to require all activities in the coastal zone to be subject to a coastal development permit, including restart of the pipeline. Thank you very much for your time today.
Thank you. Molly Troop, Michael Lynch, Michael Torbenson, Brady Bradshaw, Maya Mejia.
Good afternoon, Chair Cummings and Commissioners. My name is Molly Troop, and I'm the Science and Program Manager at Santa Barbara Channel Keeper. Our organization is located here in Santa Barbara, and we work to protect and restore the Santa Barbara Channel and its watersheds from the Gaviota Coast to the Ventura River. On behalf of over 3,500 supporters, I would like to thank each of you for your work to protect our coast and to uphold the critical provisions of the California Coastal Act. I am here today to voice Channel Keeper's strong support for 3 orders before you this afternoon: the cease and desist order, the restoration order, and the administrative civil penalties. I'm urging the Commission to approve the staff recommendations provided in the staff report. Channel Keeper is extremely concerned about the extensive harm that Sable has already caused to our sensitive coastal habitats, including degraded water quality and impacts to marine resources that were described in detail in the staff report. We're exceptionally concerned about Sable's flagrant disregard of our state laws that exist to protect invaluable natural resources, despite the extraordinary efforts made by the Commission staff to work with Sable. We're counting on you and the California Attorney General to stop the unlawful work being conducted by Sable, and we urge you to determine that the restart of the pipeline be subject to a coastal development permit. Thank you.
Thank you. I'm going to call another small group of people just in case they're in the other overflow room so they can head over. Michael Lynch, Michael Torbenson, Brady Bradshaw, Maya Mejia, Michaela Suter, Sneha Nambudiri, Carol Kernaham, Nikki Talebi.
Chris, real quick. After that group, how many people are left on the list?
After that group, give me a second. After that group, there are 58.
Okay. Please, okay, go ahead.
My name is Michael Lynch. I am a resident of Santa Barbara. I'm here on my independently on my own, but I do want to point out we did have probably 10,000 people marching last weekend, and many of them are here today. I know, I recognize them, I see them. We are very concerned. And I want to point out, what I want to address is what was said about the jurisdiction. In Santa Barbara, our county did not stop Sable. That doesn't mean they didn't want to, and that doesn't mean that you shouldn't. The commission was created because we can't rely on politicians to be taking care of the coastline. The coastline is not one county. The coastline affects a huge portion of California, and that's why this is a California commission. I'm appealing to you to represent all of California and protect the coast. I also, just on a personal note, want to include, it's not just the people in California and the people in Santa Barbara. My kids can't live in California, well, at least not in Santa Barbara. But they come here, and when they come here, the only thing they do is they go to the beach. Please protect it. Thank you.
Thank you. Michael Torbenson, Brady Bradshaw, Maya Magia, Michaela Suter, Sneha Nambudiri.
Hi, commissioners. Sorry? Is this better? All right. Hi, commissioners. My name is Michael Torbenson. I am a student at UCSB, and I represent myself on behalf of CalPERG, a nonprofit student organization of 28,000 students and all environmentalists around California. To start out, I am in full support of items 8.1, 8.2, and 8.3, and ask the Commission to please vote to approve the staff recommendation. This campaign Sable launched, which they've intentionally kept quiet about, has continuously grown more and more attention over the last 6 months, starting out with local environmentalist groups to large gatherings of a diverse amount of individuals. We're all here to support the serene yet sensitive coastline and to protect our communities as well as the organisms, endangered or not, that live along with it. I want to convey my deepest gratitude to all of you for your dedication to protect our sacred coastal environment that we are so lucky to have and appreciate every day. Relaunching this operation has already caused many disasters that have come from its development activities, and there will be many more to come, including putting previously noted endangered species in deeper danger. More thorough environmental evaluations need to be put in place before Sable's equipment or before Sable continues any more developments. And in an environmental and even monetary sense, we cannot afford another spill. The fact that this has been the only case of an ignored cease and desist in the history of Coastal Commission's cases, in fact, 2 of them, as well as many more violations, clearly states the morals and integrity Sable Offshore Corporation has. Not only that, but California has a goal to work towards carbon neutrality by 2045. So really, shouldn't we be focusing on putting more energy and more money to exploring renewable energy resources? I ask all of you, are we really going to put profit in front of environmental protection? We are all entrusting you, the commissioners, and the California Attorney General to cease this unlawful construction work. Thank you.
Thank you. Brady Bradshaw, Maya Magia, Michaela Suter, Sneha Nambudiri, Carol Turnerham, and Nikki Talebi.
Hello, thank you for the opportunity to speak. My name is Brady Bradshaw, representing the Center for Biological Diversity, and we support all of staff's recommendations. Enforcement staff have provided a very detailed description of governing law, the past and ongoing violations of the Coastal Act, and their many efforts to work with Sable to resolve these violations. They have appropriately responded to a very challenging situation. California's coastline is a special and unique ecosystem home to numerous endangered and locally important species like the California red-legged frog, steelhead trout, tidewater goby, western pond turtle, and countless marine species that depend on a healthy marine environment. Like any proposed development in this sensitive coastal area, this project should have been preceded by a thorough explanation of the proposed work and an opportunity for you and for the public to have a transparent process with environmental and expert review. The orders today, if approved, would put in place common sense measures to prevent harm to coastal and marine life in coordination with qualified experts. They provide a clear timeline and even include options for streamlining the permit process and for reducing administrative penalties if certain conditions are met, which should be acceptable to any responsible applicant. They provide a clear framework for monitoring and restoring affected habitats while accounting for erosion, pollution risks, and other threats to endangered species and cultural resources. While we believe the Santa Ynez unit should be decommissioned immediately, these orders at least offer a pathway for the restart projects to undergo the proper environmental review. With public input and transparency, that is if Sable complies. Unfortunately, it's become crystal clear that Sable has not demonstrated willingness to cooperate with all state agencies. So it will be necessary for the Attorney General to step in as well. Please vote to adopt staff's recommendations and continue pursuing enforcement options with the Attorney General's office. Thank you.
Thank you. Maya Magia, Michaela Suter, Sneha Nambudiri, Carol Kernaham, Nikki Talebi.
Good afternoon. My name is Michaela Suter, and I'm a first year at UCSB. I am speaking in support of the Coastal Commission and staff recommendations because Sable must be stopped and held accountable. As many here have expressed, we need to protect both our ecosystems in land and water. But aside from the obvious environmental harm that Sable has caused and will continue to cause, the fact of the matter is Sable has declined to comply with the Coastal Act and has shown direct disregard for legal orders. Sable is relying on 40-year-old existing permits, and basing important projects on a permit from last century demonstrates severe ignorance and neglect of current information. Through time, we gain knowledge about dangers and effects of projects like these, so new permits and regulations must be created. We cannot be basing projects off permits neglecting 40 years of new data and research. I support these enforced items and urge you to stop Sable to protect our land and waters, as well as prevent problems like this in the future. Thank you for your time.
Thank you. Sneha Nambudiri, Carol Kernaham, Nikki Talebi.
Hi, thank you for hearing us today. Welcome to Santa Barbara. My name is Sneha Nambudiri, and I, like you, care deeply for our environment. Your actions and decisions policing our environment do not just affect the Gaviota Coast, but our state and ultimately our globe, because we share these oceans and our ecosystems. Everyone is watching. Everyone knows that Sable is dangerous and must be stopped. New oil projects only damage our sensitive coastlines. Sable has shown that they are childish and unable to adhere to your laws and the rules. Companies like this do not deserve the privilege of our oceans. Waiving compliance measures just removes the purpose of them in the first place. They don't have the needed cathodic protection measures or animal and vegetation protection measures to run a successful pipeline. If this pipeline had any value, it would be Exxon sitting here, not Sable, and that shows something. All of Sable's violations are clearly unpermitted. Use your power. Use your power to hold them accountable. It is not an overreach. It is your job to protect the oceans when we're facing such a threat. If this isn't your job, what is? If you don't protect us, who will? We need a thorough environmental review. We need Sable to be persecuted as far as they can be, because this is not right. I support the Coastal Commission and their efforts to protect our shared futures, and I will continue to support the Coastal Commission staff recommendations. Change has to start somewhere, and this sets a precedent with your decision. Thank you.
Thank you. I'm going to call a few more names to get us to 1 o'clock. Carol Kernaham, Nikki Talebi, Carol Millen, Sherry Holland, and Crystal Lewis. If you heard your name, please come into the meeting room. If you haven't been able to, or if you don't approach now, I will call your name after lunch, because I did prematurely say to go get lunch. But, all right. Carol Kernaham, Nikki Talebi, Carol Millen, Sherry Holland, Crystal Lewis. Go ahead.
Good afternoon, Commissioners. My name is Nikki Talebi. I'm with UCSB's Environmental Affairs Board. The claim that Sable's work is authorized under previous permits does not have substantial evidence. The current impact of their work and evidence that they have violated Commission orders are clear. We are not asking you to stop oil production. Your enforcement decision today can be made solely by looking at Sable's clear violations of authority. The community's support for staff recommendation is undeniable. I appreciate your work so far and support the staff's recommendation. Thank you.
Thank you. Another call for Maya Magia, Carol Kernaham, Carol Millen, Sherry Holland, Crystal Lewis. Go ahead.
Hi, good afternoon. My name is Carol Millar. I'm a member of 350 Santa Barbara and Fearless Grandmothers. I'm also a Santa Barbara native. I've never taken how special this area is for granted. As a kid, I was traumatized by the '69 oil spill. And in 2015, I had to watch my own kids go through the same trauma I had. For the sake of my kids and their whole generation, I support 8.1, 8.2, 8.3, and I really did read them. I'm not just saying that. I urge you to adopt all of your obviously fantastic staff's recommendations. I also think it's very, very important for companies to know that even as they act in the reckless and morally bankrupt way that's currently modeled and condoned by our federal leadership, that in California, we still believe in the sacred duty of our governmental institutions to protect people and the environment. Thank you for the hard work you do.
Thank you. I'm not seeing anyone else lined up behind the podium, so I'm going to list out a few more names to get us to 1 o'clock. Sherry Holland, Crystal Lewis, Mike Ockener, Ann Shaw, Ralph Lopez. If any of you have heard your name.
If you heard your name, please approach the podium.
A few more. All right, go ahead.
If not, continue reading
Okay.
names.
Dieter Umholtz, Hector Cardoval, Dwayne Mensch, Craig Landry, Iris Sensen, Flavia Hollinger,
Looks like we
Kristen
have a couple
Barros.
people.
Go ahead.
Good afternoon, Commissioners. My name is Craig Landry. I work for Sable Offshore Corp. Like one of the gentlemen said earlier, I've been in this business for 46 years, and in those 46 years, producing oil and gas, the goal has always been to produce it safely and compliantly. And the vast majority of our management team has been together for a long time, and we all feel the same way. Right now, California produces the cleanest oil in the country, and that is because of the regulations and the permits. Sable will go beyond the requirements, and we always have, from the well to the pipeline. We want to produce, but we want to produce safely and compliantly, and we have put in the production, the monitoring, and the safety systems to shut this line down. The pipeline will undergo 10 times the inspections that are required of any other pipeline. We'll have to do things every year that will let us know if there is any issues that occur. The control systems that we have put in, the people that we've brought on, the training that we are implementing right now will be monitoring this system 24 hours a day, 7 days a week. The numerous shutdown devices that we have put in place on this pipeline will close automatically if anything happens, and the push of a button by our control room operators that will be monitoring it. So what I'd just like to say is that there's a lot of worry about the pipeline and the safety of the pipeline. That is the most important thing that we're looking at, is the safety of that pipeline and compliance. So I respectfully request that you reject the enforcement of these fines. Thank you.
Thank you. What was your name again, by the just so I can make sure I cross out the right name?
Craig Landry.
Okay, thank you. I'm seeing no other names or no other people approaching. I'm going to call a few more. Go ahead. Go ahead.
My name is Mignon Bradley. I've lived in Santa Barbara really long time, since before the 60s. And I experienced the '69 oil devastation and the 2015. As I'm sitting here, first of all, I want to thank all of you so much for all of your wonderful work, and the staff's work and report was just phenomenal, just really fabulous. And my feeling is that when I hear Sable say that they're going to follow all these regulations and be careful, it just doesn't pass the smell test to me when they're ignoring the staff report. So I urge you to follow it because it's just right on. Thank you.
Thank you. We have time for 2 more people. I'm going to call Mia Di Costanzo, Carl Oshiruki, Michael Meredith, Ted Morton, Sharon Broberg, Vicky Bloom, Jasmine Bazin. I see a couple people standing, so you'll close out lunch, or before lunch.
I might be going out of order, but Chair Cummings and Commissioners, I am Ted Morton, and I'm Executive Director of the Santa Barbara Channel Keeper. We're a local organization. Our mission is to protect and restore the channel and its watersheds. Thank you for holding this hearing in Santa Barbara on such a consequential issue for the health and the future of the Santa Barbara Channel, the Gaviota Coast, and communities throughout the Central Coast. The channel is a truly special ecological place. It is where cold currents from the Gulf of Alaska mix with temperate currents from Baja. Cold water and warm water species are found offshore. Upwelling of nutrients support phytoplankton that feed thousands of whales. This place is often called the Galapagos of North America. I would like to commend staff on a thorough, compelling, and illuminating report. It and today's presentation provided significant details and shocking evidence about Sable's blatant resistance in seeking permits, abiding by agency directives to follow the law, and its damage to highly sensitive coastal resources. The report builds a solid, clear-cut case for the enforcement actions. I strongly urge you to vote for the 3 recommendations: a cease and desist order to prevent further development until it receives a coastal development permit, a restoration order to address harmful substantial impacts from the unpermitted work, and a civil administration penalty. Thank you.
Thank you. Next speaker.
And you'll be our last speaker before we break.
Hello, I'm Sharon Broberg, and I'm speaking for 350 Santa Barbara. I'm on the steering committee. We support items 8.1, 8.2, and 8.3, and ask the Commission to vote to approve the staff recommendations. We represent the voice of 1,200 people on our contact list. We've heard quite a bit this morning about the devastating oil spills. I thought maybe I'd bring up a little bit of the history of conservation of actually the land of the Gaviota Coast. As a personal note, Tahigas Ranch and Canyon are on the pipeline route. In the 1970s, I was part of Sunburst Community, a group of young people in Santa Barbara who purchased the 3,400-acre ranch. And this was possible because of the newly established Coastal Commission. The Coastal Commission nixed plans of a huge development financed by Hollywood actors. They could not do the development they had put the money in to do. Fast forward 50 years, Tahigas Ranch and Canyon is now preserved on the Gaviota Coast. I believe, I don't know where these photos were taken, but the pipeline runs through Tahigas Ranch and Tahigas Canyon, which is a pristine wildlife area. I just wanted to give this short personal story to illustrate the profound influence the Coastal Commission has had on our coast, and to give my appreciation. We are counting on you and the California Attorney General.
Thank you.
Thank you. I'll just note before we break, we have about 50 more people signed up.
Okay, so first I want to thank everybody for being here today. I want to thank you for all your engagement, for your respect for one another's comments, and for all the comments that you've made on this issue. I just want to point out we've had about 2.5 hours of public comment. We have many more items to get to on our agenda. So what I'm going to recommend is that we're going to go on break right now. We're going to go into closed session. We'll take about 45 minutes. We're going to end public comment because I think we've heard both sides and everything's getting really repetitive. I think we want to get to a point where we can take action and move on to the rest of our agenda. So when we come back from lunch, We're going to give the alleged violators their 20 minutes of additional time. We're going to take comments from staff, and then we're going to open up the deliberations with the commission. So we will be back at 1:45, and again, we'll start with the alleged violators for their rebuttal, and then we'll move it to staff, and then we'll take action. Thank you.
Thank you. And again, for closed session, we need everyone out of the room, so please leave the room.
We're ready to go. Okay, well, sorry about that. We went over a little bit. Closed session took longer than anticipated. I'd like to ask if there's anything to report out from closed session.
Yes, Chair, thank you. The Commission discussed, received litigation information and advice, and took action on Friends of Oceano Dunes versus State Parks and Friends of Oceano Dunes versus Coastal Commission. And that concludes my report.
Thank you very much. Okay. So we're going to resume item number 8, our enforcement item. And so I'd like to invite up the alleged violators for rebuttal. You will have 20 minutes.
Good afternoon, Commissioners. DJ Moore, again, of Latham & Watkins on behalf of Sable. I know it's been a long morning, so I just want to address a few points that were raised during public comment. First, several speakers suggested that this is a wholesale replacement project, and that's simply not the case. Less than 10% of the pipeline in the coastal zone has been repaired. All of those repairs do not involve cutting out the pipeline. They may involve recoating or resealing. This is by no means a wholesale replacement. Next, removing insulation does not conflict with the line's original configuration. Contrary to claims that have been made, removing insulation in areas where anomalies have been identified actually improves the cathodic protection, which still exists along the pipeline, the entirety of the pipeline. Next, staff has suggested that the existing permits would somehow need to specifically describe exactly the type of repairs that would be undertaken in order to be authorized. That's also not the case. The permits broadly allow for repairs on the pipeline that included replacing sections of pipe. Exactly how replaced sections of the pipeline relate to pipeline safety falls exclusively within the jurisdiction of the Office of the State Fire Marshal and is preempted. Excavation to repair a section of pipeline as authorized by the county's existing CDPs is exactly the same from a coastal resources perspective, regardless of the type of repair being undertaken on the pipeline itself. A comment from Ms. Crop from EDC referenced a study she said was prepared by the county that addressed the frequency of potential future spills from this pipeline. Her statements were incredibly misleading. The study she referred to was never approved by the county, and what she referenced was the spill risk that would occur if no improvements were made to the pipeline. It in no way addresses the pipeline with the repairs that Sable has undertaken. Ms. Crop also suggested that the county's silence should be interpreted that there is no authorization under existing permits. That's also not the case. In fact, as staff noted, the county submitted another letter to the commission just yesterday. I want to read from that letter so that it is in the record. It's authored by County Planning Development Director Lisa Plowman. Quote, Commission staff has all of the information that the county considered prior to concluding that the pipeline anomaly repair work identified in the February 12, 2025 letter is authorized by the existing permits and was analyzed in the prior environmental review. We understand the Coastal Commission has reached a different conclusion considering the provided documents, but the county continues to assert the dispute resolution process in section 13569 is not applicable here, because it only applies when 1, the local government determines a project is exempt or categorically excluded, or 2, a decision on whether a proposal would be appealable to the Coastal Commission. The county did not allow activity without a permit, nor did the county take an action on a permit or development application that may be appealable to the Coastal Commission. Finally, I just want to conclude by saying, as Mr. Rush said at the outset of this meeting, we have a fundamental disagreement with commission staff. Reasonable people are allowed to have a difference of opinion under the law. That's how democracy works. There is respect for this commission and its processes. We disagree with how they are being applied here, and we maintain that Sable's activities are consistent with prior permits. We thank you and the public on both sides of this issue for the time taken today to participate in the public process. Thank you very much.
Thank you. Okay, with that, we will turn to staff to see if staff has any comments to make in response to what has been discussed today.
We do, thank you. It's hard to remember back beginning of the day, but DJ did remind us of some of these things. I'm just going to say a few things. I note that Sable and a lot of the other speakers presented information about topics that aren't at issue here, and we're not responding to those. Just because of the lack of time. We're always happy to talk about other issues later. The vast majority of the issues, however, raised by Sable were addressed in our staff report, the addendum, and presentation today. We've had a lot of reiterations of the same issues, and we've responded over and over, and I refer folks to the record that is in the record. But just to reiterate a couple of them, we repeatedly addressed the issues that they raised regarding CCC enforcement authority under the Coastal Act in areas with LCPs. The statute's clear about when the Coastal Commission is a backup, and we followed all the procedural requirements of the Coastal Act on this. We wrote the county not once, but twice. In addition, I note that the offshore work is not even in the county's jurisdiction. We also addressed the issue of whether or not the work they did was somehow permitted under the old permits, and I noticed that Mr. Moore just raised that again. We've looked very carefully at those permits. We spent a phenomenal amount of time crawling through the record and the old documents, trying to find some justification for the position, and failed to do so. They also alleged that there were no harm to coastal resources, and especially in their rebuttal to the penalty section. We showed you photos and testimony that demonstrated that's not correct and discussed the nature of those impacts. They raised some of the same legal issues that have also been well addressed, such as preemption, and we've noted the law on preemption and note that we did not require actions inconsistent with federal regulations or law. They raised a number of issues regarding the assessment of penalties. They said that the valves installed and other work was done before they got the NOV from Commission staff, which I find particularly offensive. Doing violations that are undetected is simply not a defense. That makes it worse. It makes it harder for us to address and to limit the harms from those actions. The penalties under the Coastal Act run from the date of the violation, not from the date of detection. Our analysis in the staff report largely was conservative, and so we did run from the dates of our letters and other detections, but that is not the law. We were being generous on those points, and the fact that we didn't detect them earlier is irrelevant. If it were otherwise, there would be a strong motive to hide and evade actions. They also said that once the NOV was issued, they halted activities. But we note, and you saw in the photos today, that they restarted work and it continues today. They also said they took some remedial work, such as doing reseeding, but we would point out that this was done under a unilateral order issued to them by us, after many efforts to try to get them to do it voluntarily, and it was far from voluntary and doesn't mitigate any of the factors under 30820C. Sable and some of the other speakers also raised the issue of and importance of the quality of workers and their work. As we said in our presentation, this is not an issue of environment versus jobs. We respect their work and we respect their commitment to excellence. It is just an issue of complying with the law before doing the work. Our beef here is with the corporate entity and not with their employees. And lastly, Mr. Twomey raised some concerns on behalf of the Chumash, and just because we didn't have a chance to talk about this earlier, I just want to note that the order is attachment A to the staff report and on our website. It requires a cultural resources survey, outreach and consultation with the tribes, and use of cultural monitors. So we look forward to working with Mr. Twomey and his colleagues on matters as they unfold after the order, if the order is issued by the Commission. Now I'd like to turn it over just briefly to Cassie Teufel, who's going to say a couple of quick responses, and then to Alex Halpern for a couple of legal issues.
Sorry about that. Thank you, Ms. Hagee. Just a couple quick points on Sable alleged that the EIS from 1985 contemplated improved permanent impacts along the pipeline corridor. We disagree with that. While some impacts to oak woodland habitat were evaluated in these documents and mitigation provided, the recent and ongoing work far exceeds those impacts. Based on information Sable itself has provided, the work exceeds the pipeline right-of-way in no less than 29 separate sites, including on critical habitat for state and federal protected species on county and Santa Barbara County and Santa Barbara Land Trust property. No evaluation, authorization, or mitigation for these impacts is provided in the EIR or the 1986 county permit. I also wanted to respond to several points raised in Sable's presentation regarding the offshore work. Sable claims that the work is authorized by the Commission's 1988 Coastal Development Permit and points to permit conditions regarding the need for the pipeline to be kept in good operating condition as support for that claim, despite the fact that the work is not described or evaluated in that permit. It's important to note that the condition Sable refers to does not supersede the Coastal Act's requirement for development activities, even those needed to support the pipeline's use, to be appropriately permitted. Sable also claims that the State Lands Commission emailed approval to Sable to proceed with the work offshore and followed up with an official approval letter on December 4th. What Sable fails to note is that this approval letter from State Lands specifically states that Sable must also, quote, obtain all necessary permits and approvals from other federal, state, and local agencies having lawful authority and jurisdiction over the pipelines before commencing operations. Even without this requirement, the jurisdiction of one agency, the fact that one agency approved work for purposes of its requirements does not mean that Sable can unilaterally ignore other regulatory requirements, such as those in the Coastal Act. Sable also notes that in 2012, Exxon carried out similar work and also did not receive Coastal Act approval. While this information about past unpermitted development is notable, Sable's sole piece of evidence supporting this claim is that Coastal Act approval was not needed. Then is that the Coastal Commission staff was included on a CC line in a letter to a separate agency. Staff does not find merit in this argument. We have no evidence of having received this letter, and even if we had, being copied on a letter does not somehow provide a blanket repeal of the Coastal Act. That concludes my comments.
I just wanted to mention four things. One of the early speakers mentioned the recent ruling in an Oceano Dunes case, suggesting that the holding meant that the Commission has to defer to local governments after an LCP is submitted. I just wanted to clarify that decision was not a general ruling that the Commission has no jurisdiction after LCP certification, but that the particular LCP at issue in that case allowed the activities in dispute. The ruling was specific to the terms of that LCP, and we're asking you to do the same sort of case-specific, LCP-specific analysis here. And here, we're simply asking you to determine that the LCP doesn't allow development without a permit, and then separately the factual question of whether or not there is a permit. In terms of preemption, Mr. Moore noted that the settlement between, the settlement between the Commission and the county, in which the county agreed to settle litigation by agreeing that its jurisdiction was preempted. But just as on the merits, here too, we simply disagree with the county about the scope of preemption, and the fact that the county entered into a litigation settlement in which it made a concession about its jurisdiction doesn't change the law on preemption. The scope of preemption is based on the law, and it can't be altered through a contract or a settlement. I was going to mention a couple things about the offshore stuff, but Mr. Teufel actually covered most of it. I guess the only other thing I would say that I don't think he said was that Mr. Moore also noted that the federal agency known as Bessie had allowed the offshore work to proceed, but that only highlights that Sable was willing to seek confirmation of their position from the federal regulatory authority for the work in federal waters. That's exactly what we're asking them to do with respect to the state regulatory agency for the work in state waters, is to come to us and see if we give the same confirmation. And that's what they've refused to do. Finally, Mr. Moore concluded by stating that Sable has a fundamental disagreement with Commission staff and that reasonable people may differ. And that's all fine, but to the extent that Sable has such a legitimate disagreement, we've told them repeatedly that the way to resolve such disagreements would be to submit a permit application to you under protest, which would preserve their arguments and allow the Commission to weigh in. And if the Commission were to disagree, they could then seek judicial review. In other words, they had a straightforward option to avoid all of this and to resolve those differences, those allegedly good faith disagreements about the law. But instead, they refused to follow that legal process for resolving the issues and instead just charged forward. And that's the concern. Thank you. That concludes my comments.
Anything else from staff?
No, thank you.
Okay. We will, well, first of all, I just want to thank the the alleged violators, our staff, the community who's been so patient with us throughout this process. And with that, I'll bring it back to the commission, starting with Commissioner Harmon to begin us in deliberations.
Thank you, Chair Cummings. You know, truthfully, I don't have any questions, so I'm going to just jump in with my comments. And I want to first start by expressing my sincere gratitude for everyone who came out today on both sides of this issue. The engagement that we're seeing here in my home county really does us proud, so I do have to start there. But it is, to me, profoundly disappointing that we had to get to this point today. Our commission staff worked so hard in myriad ways to resolve this matter before it got to this point today. As they said when the hearing started this morning, protecting our coast requires that we work together. And since we've been made aware of this issue in early September, I think we said, our staff's worked tirelessly to do just that. And clearly, we haven't gotten a foothold. We've not gotten a foothold with Sable, and we've not gotten a foothold with Santa Barbara County either. So we are where we are. And because of this absolute failure of collaboration and Sable's, to be frank, absolute failure to follow the law, this hearing has become necessary. I want to thank our enforcement staff in particular, everyone involved in this matter, for their careful, measured, and incredibly thorough approach to what's before us. And I have to be honest, that's exactly what this has been. It's been careful, measured, and incredibly thorough, and I'm very grateful for your expertise and focus. You know, the representative from Sable started his comments this morning with a brief reference to his belief that this hearing would end up somehow a referendum on fossil fuels. And I want to be absolutely clear that my thoughts today and what I'm saying here in this hearing have nothing to do with how one feels about oil or how I feel about oil. It's really not relevant to my calculus, to what's before us today. And further, I can't say clearly or strongly enough, and Ms. Showghi said it in her comments, her closing comments, that today's hearing is also not about the hardworking people, those that are both in the hearing room today and out in the field. It's not about those folks who are doing their jobs as directed by Sable. That our local workers have been pitted against the Coastal Act in this way is neither necessary nor helpful. Coastal development permits make work safer. They make work safer not just for our environment, not just for ESHA, not just for our animals and for our ocean. They make work safer for the people who are doing the jobs. So I fundamentally reject this false dichotomy, and I really hope that you all do too. We can have good, well-paying jobs, and we can protect and preserve our coast. And I know we can have both because we and our staff sit up here month after month and do everything we can to facilitate both. We absolutely can. So with that said, I want to just address a couple of the substantive points that have been brought up today and share my view on them. First, I have to say with regard to the EIR, I think it's just simply not true that these repairs could have been or were contemplated by the life cycle assessment such that they'd fall under the EIR, anomaly repair framework. I think it said in our staff report, and I'm going to maybe butcher this a little bit, but it was well put. Individual projects certainly require review at the time that they're proposed. And even if there is an entitlement affirmatively requiring maintenance in perpetuity, that entitlement is not the same as authorizing each instance of work. Those separate instances of work do need review. Further, what we've seen occurring on the ground in the photos that were presented today, it's not small-scale maintenance and repair. I almost don't even want to address that because it's not de minimis, and the pictures tell the story. Now, perhaps more importantly, as to our jurisdiction, I think the case was made quite clearly that it's not true that the Coastal Commission has no authority to act here, either in connection with the orders themselves or with our ability to take up the matter when our legal, validly issued orders have been ignored, as they have been in this case. I agree with our counsel that preemption doesn't apply here. Santa Barbara County failed to act, and I have to go on record with my frustration about that. And I remain utterly confused. But even so, when the local jurisdiction doesn't act, the Coastal Act contemplates a mechanism for this body to do so. And that's what we've done. So fundamentally, I think what we have here is this. The Coastal Act is the law that has been said over and over today, put in place by a vote of the people. Our authority to step in on this matter is squarely within that law. Our orders were valid and legally issued, and Sable's refusal to comply is a refusal to follow the law. Their refusal, in a very real sense, is a subversion of the will of the people of the state of California. Every element, every factor in the 5-factor test that was laid out for us under 30821 and 30820 to issue penalties has been met. The orders were blatantly and baldly ignored. And I have to admit that I think our staff has frankly been quite conservative in their assessment of the penalties under that test. And if I sound frustrated here, I am. I'm extremely frustrated because we didn't need to be here today. I was born and raised in North County, here in Santa Barbara County. I'm acutely aware of the need for pipeline repair work. I want repairs to happen. I believe that repairs are necessary. We need them. I don't think anyone wants to stop repairs that are going to keep us safe. I certainly don't. But they have to be done in the right way. I sincerely hope that Sable pursues the consolidated CDP pathway that's been identified for our staff. I sincerely hope that upon following that path, they follow the framework that would be laid out in that CDP. The word collaborative has been thrown around a couple times today. Let's work collaboratively to do what needs to be done. But for today, in light of the failure of Santa Barbara County to act and Sable's utter disregard for the law, I'm left with no choice but to support the application of these penalties today, and I will be voting yes. Thank you.
Thank you. Any other commissioners with comments? Commissioner Escalante.
Thank you, Chair, and thank you so much, Commissioner Harmon, for your comments. I definitely, please add me to that, and I'll just make some brief comments that I put together during this hearing as I was listening to you all. And thanks to everyone who's come to speak up constructively and respectfully. This commission relishes robust public participation, which includes people of all ages, including minors, who care enough to add to their worries on their already full plate to share their thoughts on decisions that impact them directly. The kids on both sides of the aisle should be off limits from intimidation, and I rebuke one of the speakers targeting them in their comments today and encourage some self-reflection. Now to the regulatory matter before us. This actually has been one of the strongest and most thorough enforcement cases I've seen in my tenure here. I commend our enforcement and energy staff for all your hard work to get here today, in spite of the difficult circumstances. For the public who doesn't follow us every month, this commission regularly reviews and approves oil and gas pipeline upgrades and repair projects. We do so because we honor the section of the Coastal Act that allows for coastal-dependent industrial development, such as what Sable does, to continue their business. But we get involved to make sure that the damage that's caused to the environment, to the public trust, is mitigated. And this is in spite of that, all of us here know for a fact that these operations are driving an accelerated climate change. But this is what the law is, and we're following the law. Unfortunately, playing loosey-goosey with the law is now on the daily menu in this upside-down world order. So this commission is here by voter initiative and tested case law. So as long as we're standing in this republic, we will do our job. So no, we're not overstepping our authority. This is our only lane. Lastly, it's very sad, aside from the alleged violator who is responsible for this outrageous scoffing of the Coastal Act. It is very disappointing and alarming that Santa Barbara County, with its actions and inactions, has given the violator cover to do it. It is a bit of a dereliction of duty that no representative from the county was here to answer questions about their decision-making and lack thereof. And I really hope that, this is an inflection point for county to come to the table and work with the commission collaboratively instead of in such a adversarial way. So I appreciate the time, and I'm with staff on this one. Thank you.
Commissioner Bochco.
Yes, extremely briefly, I want to align myself with Commissioner Harmon and Commissioner Escalante. I feel like we saw no evidence today that these 40-year-old permits would include the extensive work, and it was extensive, whatever percentage they want to put on it. We saw the photographs, we saw the evidence. We saw that they were by oak trees. We saw that they were in riparian habitat. We saw, that these are areas of great sensitivity and are being treated as if they were building a highway. I was just shocked that the county didn't show today, that there was no one here to explain why they felt 40-year-old permits for such a large, sensitive project. And now I'm talking about sensitivity of the citizens of Santa Barbara. The people of Santa Barbara have been through so much in terms of oil spills, in terms of, people not really caring about their community and caring mostly about just more oil, more money, etc. And so I'm just shocked in a way that the county wasn't here to tell its own citizens why it wanted to let this go unreviewed, responded to. I've not seen that. I've been here 14 years on this commission. I have never seen a county behave this way. And someday somebody might be able to explain this to me, but at the moment they have not. So I am certainly voting with staff on this because of all the statements made by our prior commissioners, but also because of the overwhelming evidence in the record of the need for the standard CDPs that we give out every day to, companies that want to build on the coast. So we're here to protect you, and we're happy to protect you. And I'm actually, anyway, I'm done.
Commissioner Nada.
Yeah, thank you. I think, a lot of the work that the commission does relies on partnership with local governments. And so it's particularly distressing that local government is not here today. And I think that it's, as one of the students said, that we shouldn't be here today. If only the alleged violator would work with us and follow the rule of law. There is a path forward that's laid out in the staff report that I certainly would urge Sable to consider seriously going forward. But it's incumbent that we act today, so not only to remediate existing harm, but to deter further violation of this sort. So I will be supporting staff. Thank you.
Thank you very much. Are there any other commissioners who would like to comment on this item? Commissioner Wilson, Commissioner Kelly.
Thank you, Chair. Just a couple of comments. I think that the staff made a compelling case for what we have in front of us, and I think it was even the most compelling in relation to the offshore issue, for sure. I mean, that just kind of locks it in for me. As much as I probably align with the folks that here in that maybe had criticisms of Sable and in this situation, I do want to really commend the workforce of Sable in their comments here today. They were poignant, they were concise. I just want to, and they actually made some very good points, and one of which I align myself with, and is we forget sometimes how lucky we are in California, in the beauty of the coast that we have here, and especially the privilege that we have, and even having a place like Santa Barbara and the coastline here, and the luck that many of us have. I didn't grow up here, but I grew up in I'm going to say just as beautiful a part of coastal California. But and it is what the workers are saying. What I thought was really true is that even with all the issues that we have and associate with this extraction, it's still, we have to remember, even if it didn't exist here, we're still putting gas in the tanks. That gas comes from communities and places that also have children, that also have families that are being impacted by those issues as well. And it's true in California. We even if we're feeling like it's not restrictive enough, and you can put me in that camp, right? But I just want to remind myself that those resources, if we're not extracting them here, they're coming from somewhere else in general until we, have a complete realignment of how we do energy on this planet, and just be thankful that we have a place that we are so protective of, the coast of California, and I want us to really think about those places maybe that aren't as well protected, and families that aren't as well protected and don't have those opportunities as we move forward. So with that, I align with the legal arguments made by our staff today, and I will be voting yes. Thanks.
Commissioner Kelly.
Thank you, Chair. I had just some questions for staff regarding a couple of the things in our packet today that I don't believe we heard specifically from, and also just wanted to follow up on some of the comments that were made by Sable's representative today. First, I wanted to thank everyone who participated in today's hearing, both in person and online today. We really appreciate everyone's participation in this process. In our packet, there's a letter from the Central Coast Regional Water Quality Control Board that talks about the Water Quality Control Board's process and their communication with Sable with regard to some of the issues under their jurisdiction. And I know in Sable's representatives' comments, they talked about other agencies, state and federal agencies and regulators that in some cases they allege have given approval for some of these actions. And so I just wanted to get a better understanding regarding that letter from just a couple months ago in January. I don't know if we have a representative from the Regional Water Quality Control Board with us today, but just to get a sense of, it seems as though there is an enforcement program that has indicated that Sable is operating outside of the scope of what is allowable, and they were given a 45-day response window from that letter asking Sable to submit a report that detailed some of the work that they're doing and a description of and location of those actions. And so I wanted to find out, do we know if Sable did respond within that 45-day period, and if they're working with the Water Quality Control Board, and what the status of that enforcement action is?
Thank you, Commissioner Kelly. Unfortunately, we don't have a representative from the regional board here today, but we've been in close coordination with them along with a variety of other agencies. It's my understanding that Sable did provide a response. The water board reviewed it, found it deficient, and their investigation is still open.
Thank you. Yeah, I think, when we're dealing with such a multi-jurisdictional challenge here with onshore, offshore, county, water board, BLM, state parks, the alphabet soup of agencies, I think it's really critically important that the collaboration that was discussed, that not only are we being collaborative, but that people are acting in good faith. And I think from what we've, what we've observed here and seeing some of the lack of communication, lack of follow-up, and some of the statements that were made that seemingly are not necessarily patently false, I am concerned about I think the statement was made that reasonable parties can disagree, but I don't know if we're operating in partnership with a reasonable party here. And I do have concerns with, I believe staff's findings are valid. I want to align myself with the comments of Commissioner Harmon and others, and that this is a deeply troubling situation that we find ourselves in with a partner that for all intents and purposes, is new and operating this pipeline, and it's a vertically integrated pipeline. So not only are they going to be doing all aspects of this procedure, but that we have to put a lot of trust and faith in them as Californians that they're going to do it right from the ground to the pump. And from what we've seen thus far, and kind of lack of willingness to work in partnership with us, I have grave concerns, and therefore will be supporting staff's recommendation.
Could I just add one thing? And I'm sorry, I cannot get my computer to let me open it. But the Regional Water Board has issued a staff report, and they are having a hearing on their enforcement action on April 17th. So they are taking action. And the action that they, and again, I'm just paraphrasing because I can't get it to open, but they are adopting a resolution to ask the attorneys general to take action against Sable.
I just had a follow-up question. Given that and potentially other agencies that we may not know of at this moment about their processes of enforcement, I know you had stated earlier that we are assessing penalties in a conservative manner, and I'm just curious why.
It's a fair question. We try to we want everything that the commission does and that the staff recommends the commission do be defensible, and so we took a conservative position. Always when things come to the commission, it's for your discretion to do what you wish. This is just our suggestion. We wanted to make a penalty that was high enough to create a deterrent effect and to reflect the situation on the ground, but one that was reasonable and defensible under the statute. We did, we walked through it in some detail, and we'd be happy to talk about it more if you have an appetite for it, but we tried to be very fair, and we told the penalties for periods of time when we thought they were in compliance with some portions of the orders, and we also made some penalties subject to a higher daily penalty than others, but there's discretion in the Coastal Act about the amount that actually is assessed. It's up to $11,250 a day, and so we recommended $7,000 a day for some and $11,250 for others. And then we put that discount factor in to try to figure out a way to inspire collaboration going forward. If we could get the county and Sable to work with us, it would be faster for Sable. They would have one hearing as opposed to three, which would be one to the commission for our jurisdiction, two for the county's jurisdiction, and then three for the appeals of the county decision. So this way we could have one hearing and one permit and have it all faster, and it would also get all the restoration and stuff underway more quickly. So, but those factors are up to the commission's discretion, and we want to be clear about that those are just our recommendations. We were trying to find a middle ground that made sense.
All right, any other questions or comments from commissioners? Okay, seeing none, I'm going to make it I have two questions. The first of which is, given the current infrastructure and the historic infrastructure that's there, I'm wondering if you could just speak briefly, just to remind folks on what our authority is around the activities and what we can and can't approve in terms of its use and in terms of the replacement of pipeline. So I'm wondering if you could just speak to that real quick.
I'll answer what I think you're asking. Okay. We have, and this is one reason why we were suggesting the consolidated permit, because that would obviate any questions about jurisdiction or confusion about those matters, and it would just moot them out, because everything, and this is a section that was added to the Coastal Act, I don't know, several years ago, that just for situations like this where there's overlapping or adjacent jurisdiction, to allow one hearing and one permit for all the work. for the enforcement matters that are before you today, you have absolute authority over all of them because the enforcement jurisdiction under the Coastal Act is broader than the permit jurisdiction, and it includes all the coastal zone if the local government is asked and fails to take action, which happened here. So the enforcement actions would require submission of CDPs to the appropriate entity. It would require them to stop work until such permits were obtained and to conduct restoration. And our orders have the legal sufficiency of a CDP, so they could do the restoration work under the orders without having to get a permit to do those. And then the administrative penalty is clearly within your jurisdiction.
Thanks. That's kind of what I was getting to, but maybe not 100%.
Oh, sorry.
So I'll make it more clear. There were a number of people up here who were talking about, stopping the drilling from occurring and stopping the pipeline, stopping the activities in general. And I'm just wondering if you could speak to our authority around that, because I just want to set clear expectations around the fact that while there's a lot of, interest globally around, stopping offshore oil production, like that's not our purview. And so I'm just wondering if you could speak to that to help clarify what role we play in this whole scenario.
We've had a lot of discussions internally, and we're going to continue to do so. We don't have a firm position about whether or not we have jurisdiction over the restart. There certainly have been very good arguments made that we do, but that's not before us today. And I don't know if you would like to speak more fully, Cassidy?
Regarding the activities in federal waters and the platforms themselves, drilling new wells, expanding operations, those kinds of things, we'll continue to coordinate closely with the federal agencies that oversee that work to understand the role the commission may have there too.
Okay, thank you. So with that, I guess what's really before us today is a compliance issue around, this corporation Sable coming out and conducting this work without permits. And I think the staff made it pretty clear that there was a need for them to come forward and get those permits to do that work, which ultimately for us, and I think when I say us, I mean us as a community as a whole, is really intended on making sure that the work that they do provides the greatest protections to our environment. And I think we can all agree, and even the workers from Sable, they want to do the best job that they can to make sure that their work is done with integrity. They want to make sure that they're going to try to make sure that there's no leaks and that the pipeline isn't going to break. But we want to be a part of that conversation because we have our concerns as well, because we want to make sure that it's going to be done properly. And there's a failure for Sable, the corporation, to work with our staff in that regard. And not only did they not work with us, but it was the response was egregious and flagrant in their dismissal of our cease and desist orders and their dismissal of attempting to work with our staff. And so I agree with everything that's been said, so I don't want to belabor us in that. But I do have another question. So, and I think you alluded to it a little bit. There was the mention of an efficiency discount. And so I'm just wondering if you can explain that a little bit further.
Sorry, again, since the penalty is up to the discretion of the commission and it's up to the statutory maximum amount that I mentioned, you have discretion over how much of that you assess. And we suggested, and it's a creative thing, we've never done this before, and it's certainly not in a unilateral order, but we suggested the propriety of a 10% discount if they go through the consolidated permit process. And we were suggesting that to you for all the reasons we outlined before. And so but admittedly, the 10% was, it's a discretionary amount. You could make it more or less or whatever you believe is appropriate.
Thank you. Well, with that being said, I would like the board to consider amending under motion number 3 the penalty amount, which is currently at $14,987,250, amending that to the maximum amount of $18,022,500 with a potential efficiency discount to the recommended penalty amount of $14,987,250 should Sable pursue and comply with the consolidated CDP pathway. I think that we really need to send a message to folks in the state that they need to come work with us. And I think it's something that we've been saying over and over again. If you come work with us and you want to you work with us in collaboration, you will get through the process much more quickly. But if you want to go out and try to supersede the people of the state of California, we're going to stand up for ourselves. And I believe that this action will demonstrate to folks that we take these matters extremely seriously. And so I'm going to end my comments. I can't make a motion, but I'd like to entertain that as a friendly amendment when the time's appropriate. And so seeing no further questions or comments, the motion, there's 3 motions. The first motion can be found on page 16. I'm going to turn to Commissioner Harmon to make the motion on this item.
Thank you, Mr. Chair. I move that the Commission issue cease and desist order number CCC-25-CD-01 to Sable Offshore Corporation pursuant to the staff recommendation, and I'm asking for a yes vote.
Second.
We have a motion by Commissioner Harmon, seconded by Commissioner Escalante. The maker of the motion is asking for a yes vote. Is there any opposition to? We're about to right now.
Oh, I'm sorry.
Wait.
I think the first vote has to be of the day.
Okay, do we have to do roll call vote for the first vote of the day, or can we do unanimous consent?
I'm sorry, yes, Alex Halpern has left the building. Yeah, no, you can do a roll call vote. You can do a
Unanimous consent.
I'm sorry, unanimous consent, because nobody's on Zoom.
Okay,
Yeah,
it's
you're
been a
right.
long day. I
Yeah,
get it.
sorry.
All right, so does any commissioner object to unanimous consent on the motion that's on the floor? Seeing none, that motion passes. We'll move on to the second motion.
I move that the Commission issue restoration order number CCC-25-RO-01 to Sable Offshore Corporation pursuant to the staff recommendation, and I'm asking for a yes vote.
Second.
Okay, so we have a motion by Commissioner Harmon, seconded by Commissioner Escalante. The makers of the motion are asking for a yes vote. Is there any opposition to unanimous consent? Seeing none, that passes unanimously. And we'll move on to the third motion that's up before us.
All right, and you'll tell me if this works, because I'm going to incorporate Chair Cummings' suggestion. I move that the Commission find that the various actions and failure to act by Sable Offshore Corporation, as described in the Commission's findings, are in violation of the resource protection provisions of the Coastal Act, and the Commission impose upon them an administrative penalty in the amount described by Chair Cummings in his comments, with the efficiency discount down to $14,987,250 if they pursue the development path as laid out in the staff report.
Point of order. Point of order.
Yep.
Is this okay to do in the main motion, or do we need an amended motion?
Yeah, we were just discussing that.
It would be better to have the main motion be per the staff recommendation and then to amend it.
Okay.
Happy to do it that way. Okay, I'll rescind that motion.
Yeah.
Save it. So the new motion. I move that the Commission find the various actions and failure to act by Sable Offshore Corporation, as described in the Commission's findings, are in violation of the resource protection provisions of the Coastal Act, and the Commission impose upon them an administrative penalty in the amount of $14,987,250. I'm asking for a yes vote.
Second.
Is there amending motion?
Wait, who made the second? Sorry. Yeah. And,
Sorry.
Just for clarification, that it's $14,987,250. Correct?
Yes.
Okay, just to be clear. All right, so we have a motion by Commissioner Harmon, seconded by Commissioner Kelly. Is there any opposition to unanimous consent?
No. They want to do an amending motion,
Oh,
so that needs to
sorry,
happen first.
go ahead. All right.
I'd like to amend that motion, and I move that the commission find that the various actions and failure to act by Sable Offshore Corp, as described in the commission's findings, are in violation of the resource protection provisions of the Coastal Act, and that the commission impose upon them an administrative penalty in the amount of $18,022,500.
Second.
Can we have comment on that? Can we talk about it? Okay. I'm wholly opposed to that. I think the $14 million that penalty is fine. I'm going to vote no on that amendment.
Can I make a comment? I think part of what was attempted here is that, and I think that was failed to add, was the potential efficiency discount to the amount of $14,987,250 should Sable pursue and comply with the consolidated CDP pathway. I think the intent here is to get Sable to work with the commission staff, and the commission staff had an efficiency discount provided, and so the goal is to get them down to the $14 million amount rather than have them pay the $18 million.
Thank
So
you, Chair. I'd like to incorporate the language you just suggested into my motion, that the efficiency cap be included.
I would suggest that you just include the discount in the amending motion, and then, okay.
Yes.
Thank you.
Yeah. Okay. So we're good?
Can somebody explain what the motion is now, please?
I can help explain. So the amendment would increase the penalty to $18,022,500 with the potential efficiency discount to the amount of $14,987,250 should Sable pursue and comply with the consolidated coastal development permit pathway. So the idea is that if they're not going to go through the process, they'd have to pay the full $18 million. If they go through the consolidated permit pathway process, then we'll reduce the fine to the $14 million that's recommended in the staff report.
As opposed to the original, which was a 10% discount?
From 14 now.
Correct.
Now it's 18.
That's correct.
I'm not voting.
We should check on the time frame.
What's the time frame that was associated with the efficiency discount?
Well, it's interesting because it's sort of in their control. It depends how quickly they apply. There's a time frame in the order for how soon they have to pay for the penalty, and it would be the full amount unless they'd applied for a consolidated permit in the interim.
Okay, thank you. So there's time frame within the permit process already?
Yes.
Okay, great. Okay, so we have a motion by an amendment to the motion made by Commissioner Kelly, seconded by Commissioner Escalante. It sounds like there may be opposition, so we'll do a roll call vote on this item.
Commissioner Bochco?
Yes.
Bochco, yes. Commissioner Escalante?
Yes.
Escalante, yes. Commissioner Harmon?
Yes.
Harmon, yes. Commissioner Hart?
Yes.
Hart, yes. Commissioner Kelly?
Yes.
Kelly, yes. Commissioner Lowenberg?
No.
Lowenberg, no. Commissioner Notoff?
Aye.
Notoff, yes. Commissioner Turnbull Sanders?
No.
Turnbull Sanders, no. Commissioner Uranga?
Aye.
Uranga, yes. Commissioner Wilson?
No.
Wilson, no.
Aye.
Chair Cummings?
Aye.
Cummings, yes. The vote is 8 yes, 3 no.
Okay, thank you very much, everyone, for your patience on this
Chair
item.
Cummings,
Oh.
you still need to vote on the main motion. Now the main motion is, it's to go with the staff recommendation, but with a higher amount.
Got it. Okay. Okay, so I'm trying to remember who made that motion. Okay, motion was amended, and so the motion that's on the floor was made by Commissioner Harmon, seconded by Commissioner Kelly. Oh,
But what is the
Escalante.
motion, though? What is the motion?
It's the,
we voted to amend the motion, the staff recommendation. Motion was amended, and so now we're voting on the amended motion. Okay, so Ms. Miller, if you can please call the roll.
Commissioner Escalante?
Yes.
Escalante, yes. Commissioner Harmon?
Yes.
Harmon, yes. Commissioner Hart?
Yes.
Hart, yes. Commissioner Kelly?
Yes.
Kelly, yes. Commissioner Lowenberg?
Although I am in favor of a fine, I'm now forced to vote no on this. So I'm not happy with my colleagues. I'm voting no.
Lowenberg, no. Commissioner Notoff?
Aye.
Notoff, yes. Commissioner Turnbull Sanders?
Similarly, I was in favor of the 14 million penalty, but not the escalator, so I'm voting no. We're at the 14, I would be voting yes.
Turnbull Sanders, no. Commissioner Uranga?
Aye.
Uranga, yes. Commissioner Wilson?
Yes.
Wilson, yes. Commissioner Bochco?
Yes.
Bochco, yes. Chair Cummings?
Aye.
Cummings, yes. The vote is 9 yes, 2 no.
Okay, well, with that, that concludes this item. Thank you all very much for your patience. Thank you all for making us aware of this situation, and we will continue to monitor it over time. And so we'll take a 5-minute break just to allow people who need to leave to exit the chambers, and so we will be back at at 3:25. Okay, let's go ahead and get started. So if commissioners can take their seats and people can quiet down. Move on to the next item on our agenda. If folks can please wrap up the conversations, we want to get rolling. It's been a long day. Okay, so the next item on our agenda, South Central Coast District Deputy Director's Report. I'll turn to the staff for the report on this item.
Thank you. That brings us to item 9. Item 9 is the Deputy Director's Report for the South Central Coast District, which includes 3 permit waivers, 3 permit extensions, and 1 certification review. In regard to the certification review being reported, it is for an LCP amendment by Santa Barbara County to add new regulations relating to supportive housing, state density bonus law, design standards for multiple unit and mixed-use housing, and permit procedures. The amendment was approved by this commission at its December meeting, and the executive director has determined that the local government's subsequent action accepting all of the commission's suggested modifications pursuant to a resolution is legally adequate, and that this amendment will become certified upon being reported today to the commission. This matter is being reported pursuant to our regulations and doesn't itself require any additional action or concurrence by the commission. Staff is not aware of opposition to any of the other items that are being reported today, and we're asking whether 3 or more commissioners object to any of those items in the Deputy Director's report. Staff is available for questions.
Thank you very much. Are there any ex partes on this item? Seeing none, are there any members of the public signed up to speak on this item?
No, we just have 1 available for questions.
Okay, so the question is, do 3 or more commissioners object to the staff's recommendation? Seeing none, commission concurs. That moves us on to our next item, item number 12, notice of impending development. University of California, Santa Barbara, notice of impending development number UCS-NOID-0001-25 San Benito project. I'll turn to staff for the presentation on that item.
Thank you. And it does bring us to items 11A and 12A, which will have a combined presentation by Sam Fearer, a coastal program analyst in our South Central Coast District. We do have a PowerPoint presentation for this, please, if we could pull that up. And Sam, take it away.
Thank you. Good afternoon, Commissioners. Next on the agenda is a combined presentation for items 11A and 12A, for which the University of California, Santa Barbara, or UCSB, is requesting the approval of an amendment to the Certified Long-Range Development Plan and a Notice of Impending Development for the construction of the San Benito Student Housing Project. The proposed amendment is project-driven, and both the proposed amendment and the proposed Notice of Impending Development are evaluated in the combined staff report. Next slide, please. Development for the proposed San Benito Student Housing Project would include the construction of a new dormitory complex at the northwestern corner of the university's main campus, along with changes to existing roadways, parking, and drainage infrastructure nearby. The project would also include development at the adjacent East Stork Wetlands area for the construction of a new project-serving stormwater retention basin, and at the West Campus Mesa for mitigation tree planting. This slide depicts the general locations of proposed project areas. The proposed housing site is indicated by the red star, the proposed retention basin by the blue star, and the proposed mitigation tree planting area by the green star. Next slide, please. The proposed housing site would be located within the approximately 6-acre southern portion of the university's former facilities management site at the corner of Mesa Road and Stadium Road. The site is a roughly circular depression with vegetated slopes up to 20 feet in height wrapping around the southern end. Following commission approval of a separate notice of impending development last year, all structures on site were demolished, and the site is currently fenced and vacant. Proposed development at the housing project site would include the construction of 6 new dorms with roof lines up to 81 feet in height, 1 new student support building, and a central utility plant to provide heated water for use at the dorms. The proposed project would include 2,224 beds to house a mix of new and current undergraduate students, and would also include 14 beds for staff. The proposed dorm site would be supported through a new bus route extension and roadway and drainage improvements along Stadium Road. the construction of new bicycle parking south of the site, and the construction of new multi-use paths which would connect the dorms to existing bicycle routes across main campus. Due to the spatial constraints of the project site, the university is proposing to meet stormwater retention requirements for the project through the construction of an off-site stormwater retention basin, which would be located at the East Stork Wetlands area, northwest of the proposed housing site. The East Stork Wetlands area was determined to be the most suitable location for required stormwater retention, as it does not have any infrastructure constraints and would also provide an opportunity to restore an environmentally sensitive habitat area that currently exists in a degraded state. No new development is proposed at the northern portion of the facilities management site, north of Mesa Road, which currently holds the university's public safety building. Next slide, please. The proposed housing site contains significant biological resources, including an on-site wetland and oak woodland habitat designated in the LRDP as environmentally sensitive habitat area, or ESHA. While the LRDP generally requires a 100-foot buffer for new development adjacent to ESHA and wetland areas, in this case, the LRDP allows a reduced buffer of 50 feet along the north side of wetlands at the subject site in order to accommodate future site build-out. The proposed development footprint at the housing site was designed following a May 2024 wetland delineation conducted by the university. Although a revised wetland delineation that revealed additional wetland area was later completed in September 2024, the university had already finalized the proposed plans by that time and was unable to shift the proposed development footprint in a manner that would uphold the 50-foot buffer requirement across the entire site. As proposed, development at the subject site would result in a buffer encroachment of approximately 448 square feet, which is less than 1% of the total buffer area on site. And the proposed amendment would modify existing site-specific policy language to allow for the same. The proposed encroachment, shown here on this slide, would not result in a significant disruption to habitat value at the adjacent wetland and oak woodland, and the university is proposing habitat restoration within both habitat areas and associated buffers that would include planting of native vegetation, removal of non-native species, and restorative grading to enhance wetland function. However, to ensure that sensitive species on and near the project site are protected to the maximum extent possible during construction activities, staff is recommending Special Condition 5, which requires a biological monitor to be present during all site preparation and grading activities within ESHA, wetland, and buffer areas throughout the proposed project. Additionally, Special Conditions 10 and 11 would ensure that impacts to adjacent habitat due to reflective glare and light spillover from the proposed buildings are minimized to the maximum extent feasible through the use of bird-safe glass and permanent window shading features. Next slide, please. The East Stork wetland site, where the proposed retention basin would be located, is also designated as ESHA in the LRDP. Construction of the basin would support restoration of a historic wetland area at the site, which currently exists in a degraded state with limited habitat value. Proposed restoration at the East Stork wetland site would restore multiple wetland and upland habitat types across approximately 1.5 acres. Although stormwater retention basins and managed flood control facilities are not uses typically allowed in wetlands and ESHA, in this case, the stormwater retention basin has been designed to function as a vegetated wetland without the need for any future grading, management, or cleanout operations, and will enhance the wetland and habitat function on site. The university is also proposing mitigation tree plantings for 167 proposed tree removals, which would be planted primarily at the West Campus Mesa, with the remainder distributed across the housing site and East Stork wetland site as well. Suggested modification 2 would allow the replacement of 8 voluntarily planted oak trees at the housing site to be replaced at a reduced mitigation ratio of 1:1. Although the university has submitted restoration and planting plans for all proposed project restoration and planting areas, staff is recommending Special Conditions 2 and 3 to ensure that all required details and mitigation measures are incorporated into final habitat final habitat restoration, monitoring, and management, and final tree mitigation and monitoring programs for each of the proposed restoration and tree planting sites. Next slide, please. The majority of the facilities management site, both north and south of Mesa Road, is designated as housing in the certified LRDP. The proposed amendment would convert a portion of existing open space at the southwestern corner of the project site to a housing designation and would convert a portion of existing recreation designation at the southeastern end of the project site to academic and support in order to accommodate the proposed development as designed. All proposed housing development would occur south of Mesa Road. The proposed amendment would include a height increase at the proposed housing site, increasing the maximum roofline height from 65 feet to 81 feet. And would thus enable the university to concentrate all proposed new development and to abandon the potential for future build-out at the northern portion of the site, while still meeting university housing goals for the project. However, as the proposed amendment lacks clarity regarding the proposed height of specific buildings and does not address future removal of existing facilities north of Mesa Road, staff is recommending suggested modifications 1 through 3 to prohibit further height increases at the proposed housing site and to allow for future demolition activities at the northern site as may be necessary for adaptive management. Although the proposed dormitory buildings would be situated such that shorter buildings are located closest to the perimeter of campus, visual analyses submitted by the university confirmed that the proposed height increase and white coloration of the proposed dorms would result in greater visibility from nearby public viewpoints. And while visual resources may not be impacted by proposed height alone, daytime reflectance and nighttime illumination of the structures may have a significant impact on visual resources, especially at upper floors, where the proposed dorms will be the most visible. To minimize impacts to visual resources associated with the proposed development, staff recommend Special Condition 11 to require that all building exteriors shall be limited to coloration compatible with the surrounding environment, consisting of medium shade earth tones, and to require that all windows located on perimeter facades over 65 feet in height shall incorporate non-glare glass and permanent shading features. Next slide, please. Throughout the application process, staff have coordinated extensively with university staff while completing the review of the proposed amendment and notice of impending development on an expedited timeline. The university has expressed their agreement with all suggested modifications and special conditions recommended by staff and included in the staff report. 2 public comment letters were received for these items, including one received after the comment submittal deadline. Neither of the letters raise new issues regarding the project that were not previously addressed in the findings of the staff report. Staff is recommending suggested modifications 1 through 3 and special conditions 1 through 17 to ensure that the proposed activities will be conducted in a manner protective of coastal resources. As modified and conditioned, staff believes that the proposed project is consistent with the Chapter 3 policies of the Coastal Act and the university's certified LRDP. The motion to approve the proposed amendment and notice of impending development can be found on page 12 of the staff report. This concludes staff's presentation. Staff is available for questions.
All right, thank you very much. Are there any ex partes on this item? Seeing none, is the applicant here present?
Yes, we have one sign up from Jean Lucas. They should be here in person.
And then how much time will the applicant need? Very little. All right, thanks.
I'm
We'll
Gene
give you 2
Lucas. I'm
minutes.
the former executive vice chancellor for UC Santa Barbara and currently the co-chair for the building committee for San Benito. When I was executive vice chancellor, we put in place today the long-range development plan, and we're really looking forward to closing the gap between what we wanted to build and what we have built so far. So we wanted to build 5,000 more beds for the campus. We've only built 1,500, or 3,500 to go. San Benito is phase 1 of a 2-phase project to close that gap. As their staff indicated, a little over 2,200 beds in this facility. So we're very excited to get started, and I just want to thank Coastal Commission staff for working with our staff, with Sherry Hammond, and her staff to work out the details to make this proposal to the Coastal Commission today. Thank you very much.
Thank you. Are there any other members of the public signed up to speak on this item?
Yes, we have 2 other speakers, one in person and one on Zoom. In person, we have Susan Jordan. On Zoom, we have Susan Kirks. Susan Jordan.
God, that's a horrible noise. Susan Jordan, Executive Director of the California Coastal Protection Network. Well, I really want to highlight that this is a long-range development plan. And we just heard, I believe, a representative of the university talk about how great it is to be moving forward with this. What I want to point out to the commission is that the bill that was discussed with you yesterday, AB 357, by Assemblymember David Alvarez, would take away this long-range development plan. It would no longer exist. Therefore, there would be no collaboration between the university and the Coastal Commission and the staff. And that is why I think that bill is so dangerous. It's yet another exemption from the Coastal Act proposed by Assemblymember Alvarez, and it feels like we get one a year. But this one is almost inexplicable to me, broad-ranging, affects the entire any university, higher education institution in the coastal zone, and others, public and private, and not just housing units, but also any other ancillary structures, you know, whatever it's going to be. And so I think it's extremely ill-advised, and this is why LRDPs are so important. Living in this community, I know that they are considered a pact between the university and the surrounding community. It's a mutual respect. People know what to expect, and that's why they're so important. So I just wanted to highlight that for you. I'm glad to hear that representative say what they did, and I hope that feeling will be communicated to the assembly member. Thank you.
Thank you. Now moving to Zoom, Susan Kirks, you should be able to unmute. Susan Kirks, you're in as a panelist. You should be able to unmute and turn your camera on. There you go. I see you're unmuted now.
Thank you. I'll be leaving my camera off. Good afternoon, commissioners.
Hold on a second. There's a lot of warping in the sound. Try speaking again.
How about now?
It's still really bad.
Shall I try one more time?
Okay, there we go. You sound great now. So.
Thank you. Thanks for that help. Good afternoon, commissioners, Chair Cummings, and staff. I'm Susan Kirks. I'm speaking as a conservationist today. Having reviewed this agenda item in detail, I have a few questions and a few expressions of concern. I'm wondering what the maturity level is of the 167 trees scheduled to be removed, and what is the trunk diameter of these trees, and have any nesting surveys been conducted to discern the level of nesting activity during migratory bird nesting season in these trees that will be removed? Migratory bird nesting season, I think, needs to be described in the plan. The dates are February 15th through August 31st. That's generally understood in California and throughout the nation. And these tiny winged creatures fly thousands and thousands of miles to reach their preferred nesting locations. In the case of this particular development, there's no doubt in my mind that there will be collisions with the building from birds flying in, planning to fly into a familiar territory that will no longer be familiar. And also, there will be injuries and deaths from this, which is, of course, deeply concerning. In addition, the Migratory Bird Treaty Act, which is a federal regulatory act, protects all nesting birds, not just listed species, all but in California, generally 3 species are not protected, but all other birds are protected, as are their nests. So I feel concerned that we need to call out the Migratory Bird Treaty Act and the state code that are required to be complied with when there's any development that may be occurring. And I had a few more concerns, but thank you for the opportunity to speak.
Thank you. And we just had other people available for questions.
All right, thank you very much. I'd like to bring it back to staff to see if there's any comments on anything that was shared during public comment.
Yeah, with regards to the comment about the trees, all of the trees that will be removed are the 167 trees to be mitigated are mature. I don't have the numbers of the diameters, but they are all considered mature. As far as the bird monitoring, there are special conditions that would require nesting bird surveys prior to construction. And then with regards to the buildings, there are also conditions that require bird-safe glass and bird-safe building designs to be into the design of the buildings.
Great, thank you very much. Okay, are there any questions or comments from commissioners? Seeing none. I'll just make one comment. I just want to thank UCSB for working collaboratively with our commission staff on this project. I think it really does demonstrate our ability to not only work together, but to bring forward housing that is extremely needed, especially for students on college campuses across our state. And so with that, I'll turn it to Commissioner Harmon for the motion on this item.
Thank you, Mr. Chair. I echo all of your comments. So first motion is I move that the Commission certify the University of California at Santa Barbara Long Range Development Plan Amendment number LRDP-4-UCS-25-001-1 as submitted, and I'm asking for a no vote.
Second. Okay, so we have a motion by Commissioner Harmon, seconded by Commissioner Wilson. The makers of the motion are asking for a no vote. Is there any objection to unanimous consent or unanimous approval? Seeing no objection, the commission approves the motion. Oh, disapproves, sorry. Vote no, yeah.
The next motion, I move that the Commission certify the University of California at Santa Barbara Long Range Development Plan Amendment number LRDP-4-UCS-25-001-1 if modified as suggested in the staff report, and on this I am asking for a yes vote.
Second.
So motion by Commissioner Harmon, seconded by Commissioner Wilson. The makers of the motion are asking for a yes vote, and I'd like to ask if there's any objection to unanimous approval. Seeing no objection, that passes unanimously.
One more. I move that the Commission determine that the development described in the Notice of Impending Development number UCS-NOID-001-0001-25 San Benito project as conditioned is consistent with the certified University of California at Santa Barbara Long Range Development Plan, and I'm asking for a yes vote.
Second.
So we have a motion by Commissioner Harmon, seconded by Commissioner Wilson. The makers of the motion are asking for a yes vote. I'd like to look to my colleagues to see if there's any objection to unanimous approval. Seeing none, that passes unanimously. And that brings us to the end of that item, so thank you all very much. And with that, we'll move on to the next item on our agenda, which is item number 13, new appeals. Appeal 13A. Item 13A, appeal number A-4-SBC-24-0054, Garden Street Hotel. And I'll turn it to the staff for the presentation on this item.
All right, thank you. And item 13A will be presented by Tyler Liddell, a coastal program analyst in our South Central Coast District. If we could pull up the PowerPoint, please. And Tyler, take it away.
Good afternoon, Commissioners. Item 13A is the substantial issue hearing for an appeal of a coastal development permit approved by the City of Santa Barbara to construct a 250-unit hotel. The applicant is the Wright family, and the project was appealed by the nonprofit group Keep the Funk and by Stephen Johnson. Next slide, please. As can be seen on this slide, the subject site is located approximately 700 feet from the beach in Santa Barbara, inland of the waterfront, and just east of the area of the city known as the Funk Zone, which is characterized by an eclectic mix of light industry, warehouses, and visitor-serving uses, including retail, and restaurants. Next slide, please. The existing site is used as a storage yard, is used primarily as a storage yard, and the approved project includes construction of a new 250-unit select service and extended stay hotel with typical hotel amenities such as fitness rooms, courtyards, and a pool. The project also includes testing and remediation of the site's contaminated soil and groundwater, construction of a 238-space subterranean parking garage, and restoration of an on-site drainage feature. Next slide, please. The appellants contend that the project would spread the on-site contamination, risk damage from flooding and sea level rise, negatively affect the character of the funk zone, and impact the on-site wetland. The appellant's primary grounds for appeal is that the project risks mobilizing harmful contaminants beneath the site and spreading them to nearby coastal resources. While several contaminants like heavy metals and petroleum hydrocarbons are known to be present in the site's soil and groundwater, the appeal specifically suggests that there could be a condensed plume of chlorinated solvents below the site's groundwater. The appellant's concern is that the excavating and dewatering the approved parking garage will draw the plume upwards into the soil and flowing groundwater, as shown in the diagram on screen. If this transpired, the flowing groundwater could then spread the contaminants to nearby coastal resources, causing substantial negative impacts to public health and biological productivity. The appellant further asserts that future flooding and sea level rise could also risk mobilizing the contaminants. However, the city fully evaluated this issue and found that there is little evidence to suggest the presence of a condensed plume beneath the site. The applicant has already conducted several assessments of the site's soil and groundwater, including borings and vapor probes. Among other tests, the applicant measured the concentration of chlorinated solvents in groundwater samples obtained from 15 separate boring locations. To date, all of the observed sample concentrations of chlorinated solvents at the site are orders of magnitude below levels that would indicate that a plume may be present. This conclusion is the same one reached by Santa Barbara County Environmental Health Services. Nonetheless, to ensure that any potential adverse impacts to storm and groundwater quality are avoided, the city's approval of the project requires full compliance with the site assessment plan and that the applicant complete additional soil borings and vapor probes and install a network of up to 9 groundwater monitoring wells on and around the site after the existing development is removed. Based on the results of these assessments, the applicant must obtain approval from County Environmental Health Services for and carry out a remedial action plan for the site's soil contamination and, if necessary, groundwater contamination as well. Any risk of flooding and sea level rise mobilizing these contaminants is better mitigated by these remediation efforts than by the no project alternative. For these reasons, Commission staff concurs with the city's findings that the project has been adequately designed and conditioned to avoid adverse impacts to groundwater and stormwater quality, and that the appellant's contentions related to soil and groundwater contamination pose no substantial issue regarding the project's consistency with the subject LCP. Next slide, please. The appellant also claims that the approved project is inconsistent with the flood hazard mitigation policies of the city's LCP, and that this is evidenced by a supposed lack of conformity with national flood mitigation standards. However, FEMA's guidance documents and a project-specific letter from the agency both refute this claim. Furthermore, the applicant's consultant prepared a comprehensive review of the site's vulnerability to flooding and sea level rise using the Commission's sea level rise policy guidance and best available science. The study concludes that the approved grading plan will elevate the first floor of the hotel and much of the site above any tidal flooding expected within the project lifetime, and that storm events can be addressed through the use of temporary flood barriers. Finally, flooding is an area-wide issue that must be addressed by the city programmatically as required by the LCP. Thus, staff concurs with the city's findings that the project has been designed and conditioned to minimize hazards from flooding and sea level rise consistent with the applicable policies of the LCP, and that these contentions do not rise to the level of a substantial issue. Next slide, please. The appeal does not directly raise issue with the city's determination that the hotel will be a moderate cost overnight accommodation, although it does assert that the LCP gives a higher priority to public recreation, like a park, than to visitor serving use such as a hotel. Staff does not agree that such a priority is required by the LCP, but it does provide for lower cost recreational opportunities. Staff analyzed the lower cost issue in any case, in accordance with the approach that the Commission has preferred in past CDP actions, whereby a room is considered to be moderate cost if its daily rate falls between 75% and 125% of the statewide peak season average rate. Because the statewide rate is based on a standard two-person room, the Commission has adjusted this number upwards by 10% for each additional occupant the room can accommodate. All of the unit prices proposed by the applicant fall within the range of moderate cost accommodations using this formula and the 2023 statewide rate of $201. While low-cost accommodations are preferred, the Commission has recognized that moderate-cost rooms are also important and typically requires mitigation only for high-cost rooms. Thus, the appeal presents no substantial issue related to low-cost accommodations. Next slide, please. The appellants also contend that the project is incompatible with the character of the nearby funk zone. However, the project site is already dissimilar to the majority of the funk zone. The lots to the west of 101 Garden Street extend to pedestrian-friendly streets and are designed for coastal and are designated for coastal-oriented commercial development. By contrast, Garden Street is wider and far less walkable, and the LUP specifically designates the project site for hotel and related commerce uses, such as the approved project. Rather than be located within the funk zone, the hotel would facilitate visitation to the nearby funk zone. Nearby hotels are more appropriate for means of comparison, and the project is aesthetically similar to these. Thus, no substantial issue is raised related to community compatibility. Next slide, please. The appellants also contend that the project is inconsistent with the LCP because the approved driveway and sidewalk encroach into the drainage feature's wetland buffer. This encroachment, however, is allowed under the LCP because it was necessary to provide site access from the public street and did not disrupt the habitat value of the wetland. Thus, the approved project is compliant with the minimum buffer policies of the LCP. Next slide, please. The appellants made several other contentions, which staff does not have time to analyze in this oral presentation, including that the city did not analyze the project for bird-safe design elements or for impacts to parking and coastal recreation, and that the project alters natural land features, replaces existing coastal dependent uses, and requires future sewer line upgrades for which potential impacts were not considered. These assertions are further discussed and analyzed in the staff report, and staff recommends that none of these constitute a substantial issue with respect to the project's consistency with the City of Santa Barbara's LCP. Next slide, please. In conclusion, staff recommends that the Commission find that no substantial issue exists with regard to the approved project's consistency with the policies and provisions of the city's certified LCP. The motion to accomplish this recommendation can be found on page 6 of the staff report, and this concludes staff's presentation. Staff is available for questions. Thank you.
All right, thank you very much. Are there any ex partes on this item? Commissioner Uranga.
Thank you. On Wednesday, April 2nd, I had a virtual meeting with Yoda Breslau, representing United Here, Araceli King, and United Here, Jordan Sison, United Year Council. The meeting basically discussed the other case that they disagree with, and the record is on file.
Thank you very much. Any other ex partes? So I have an ex parte to report. On April 4th at 2:30 p.m. via Zoom, I met with Jonah Breslau with Unite Here. The communication was made on his behalf, and I met with Jonah Breslau, Unite Here Local 11 research analyst, Hector Azapuqueta, Unite Here Local 19, and my staff member Trina Barton was also present. Several key issues were highlighted by Unite Here concerning its development and the implications of the current proposal. First, the hotel project presents challenges related to public access and low-cost accommodations. The reasons provided for not including affordable housing is that the hotel is classified as, low-cost accommodation is that the hotel is classified as moderate cost, but at rates of $240 to $300 per night, workers in the area, including Unite Here members, can't afford these prices. Another significant concern is the absence of a feasibility analysis for providing low-cost facilities. Additionally, the potential precedent for this project could set for future developments has raised alarms, as it might encourage a less rigorous approach in other cities where cost analyses could be more lenient and based solely on local figures. Several other counterexamples were mentioned to highlight the contrasting approaches taken by other developments to meet lower cost accommodation requirements, such as the Dana Point Harbor Hotel replacement, the Magnolia Tank Farm, and the Tin Cannery project, which has managed to incorporate some of the on-site affordable low-cost accommodation. The Ocean Ave and Camden projects were also discussed, including another Dana Point initiative as examples of a more balanced solution. I will note that I wasn't able to send this out on Monday before I came to the meeting, so we'll be submitting this, but I wanted to make sure that everybody was aware of the ex parte that I had. And so with that, I'd like to ask if the appellants are in the room. If so, please approach the podium. You will have 3 minutes.
Yes, we have Mark Titilo in the room, and we have Steve Johnson as well on Zoom.
Good afternoon, Mr. Chair, members of the Commission. I'm Mark Titilo. I'm here on behalf of Keep the Funk. Brittany Zajac, the president of Keep the Funk, is here with me, and Stephen Johnson and I have discussed our collective interests and everything. Is there a timer here?
Yep, it's on the screen.
I could only see it. Okay, thank you. Staff has done an admirable job of identifying and relating the issues of concern, but unfortunately narrowed one of the primary issues that we have, which is respect to chemical contamination of the groundwater and the soil under the site. It's not just denaples, which are concentrated plumes of fuels and contaminants, but actually the ongoing plumes that are inherent throughout Santa Barbara's waterfront and east side area that are going to be impacted by the project. And we're concerned and believe that the project raises a substantial issue under LCP policies 5.1-20, which requires minimization of the effects of high geological hazards, including high groundwater, which the site has, and chemical contaminants, as well as policy 5.1-28, which calls for minimization of the high flood hazard area and the exposure of both property and individuals to those risks. Those issues remain significant issues at this point, and with the promulgation of the staff report, it was disclosed that there was substantial additional information that was made available by the applicant and by agencies that refused to communicate with the appellants, with the public, as we tried to develop an understanding of the project's description and the all-important remediation. Understand that this project does not include any remediation whatsoever at this point. There has only been preliminary assessment of the chemical contamination in the shallow areas on site. And based on that, they've concluded that they're not going to dig deep enough to get into any potential other areas of contamination. Well, our concern is that the groundwater is not going to respond to that, and that in fact, we submitted substantial evidence into the record to the city establishing that there is the potential for migration of contaminants to into the surface. We received new information in terms of the project description in the staff report that referenced floodproofing, dewatering, the treatment of dewatering, and pre-construction plans that hadn't been disclosed at the city level. So our request of the Commission today is that you defer action on this substantial issue determination for 1 to 3 months to allow us to analyze that new information. We submitted a Public Records Act request to staff. I received some of the information just today And so we can't rebut the concerns that are coming from undisclosed sources. And we think that in the interest of fairness and full public involvement and engagement, we should have that opportunity. Thank you.
Thank you.
Thank you.
Okay, so is there a representative from the applicants?
Did we also want to hear from the Steve Johnson, the other appellant, or is it supposed to be joint?
It's typically 3 minutes per side. I don't know
Right.
if they're same appellant.
That was my understanding as well.
Okay.
Correct. So that concludes the statements from the appellants, and so we'll hear from the applicant. You'll have 3 minutes as well.
Thank you. Good afternoon, Chair Cummins and Commissioners. I'm Sean Gilbert, and we're the developer of the project in front of you today. We'd like to first thank Commission staff for the hard work in analyzing the appeals and preparing the staff report. We agree with the staff recommendation that the appeals do not raise any substantial issues. The city has planned for this 250-room hotel on this site for over 40 years. We look forward to revitalizing the site by replacing the dilapidated, contaminated storage yard with 250 rooms of select service and extended stay accommodations. We worked hard to design a project of high architectural quality that would be respectful of and compatible with the built environment in the lower state area of Santa Barbara. We are pleased that the Commission staff concluded that we accomplished that. It should be noted that we and the city staff consulted with Coastal Commission staff early in the city process to ensure our proposal would be embraced by the Commission as moderate cost. We have substantial experience developing and operating select service hotels, and we are committed to serving that market. The project will also include 6 affordable housing units for project employees, as well as a $1 million contribution to the city's Affordable Housing Trust Fund. And more importantly, we will be cleaning up the site, remediating long-standing soil and groundwater contamination as well as part of the project. Each of the issues raised by the appellants was thoroughly vetted during the city process and comprehensively analyzed by your staff. The city's floodplain administrator interpreting the city's floodplain management ordinance and FEMA interpreting its own regulations each determined that a subterranean parking structure is permitted on this site as part of the project. And your staff, performing an independent analysis, concurred with that conclusion. The project's remediation program is subject to a work plan reviewed and approved by the Santa Barbara County Environmental Health Services, which will also oversee the site's cleanup. Commission staff thoroughly reviewed the proposed remediation program and determined that there is no evidence to suggest its implementation would impact coastal resources. In fact, it would provide a benefit compared to its existing conditions. Commission staff, applying the Commission's standard methodologies and precedents, has determined that the project qualifies as a moderate cost hotel and that the city appropriately conditioned the project. We respectfully request that the Commission adopt the staff recommendation of no substantial issue. Thank you for your time.
Good afternoon, David Goldberg, AGD Law Firm. With my remaining 25 seconds, I'd just like to respond to Mr. Shatillo's comments that each of those were raised in written submission that he made, which your staff responded to thoroughly in an addendum. There was no new information. All of the information was included in the city's administrative record with consultation with Santa Barbara County Environmental Health Services. I don't see the clock. Thank you.
Thank you. And then I do just want to acknowledge and realize that there were 2 appellants, and so I do want to provide Steve Johnson with 3 minutes as well. So if Steve Johnson's on the line, why don't we bring him into the meeting?
Okay, give us a second to bring him back in as a panelist. Moving in right now. When you're able to, please unmute yourself and begin.
Can you hear me?
Yes, we can hear you.
Thank you very much for this opportunity. The critical issue: should the proposed hotel be treated as a residential? If it's residential, it can't be over a basement. The city has a simple standard to determine if it's residential. If more than 75% of a building's floor area is residential, the building is residential. The basement area is excluded in that calculation. That simple standard was confirmed December 10th, 2024 at a council review of a similar project. Using that standard and the city's own calculations, the 101 Garden Building is residential. At the October 1 appeal that the city heard, the city never heard of its own calculations. Staff withheld those calculations from the city so it was unable to make a sound determination. A de novo hearing will confirm the facts just stated and promote a correct standard for other jurisdictions. Thank you for your time.
Thank you very much. Is there a representative from local government here who wishes to speak?
Yes, we have 3 people signed up as individuals with the city. Kathleen Kennedy, Tava Ostringer, and Julia Pujo.
Okay, you'll have 2 minutes.
Yes, thank you. I'm Kathleen Kennedy, the case planner for the hotel project from the city. I am here with Tava Ostringer, Assistant City Attorney, and Julia Pujo, our environmental analyst. We appreciate the thorough staff report that accurately reflects the significant time and effort that the city put forth to evaluate the project and to ensure that it complies with the city's local coastal plan, general plan, and the specific plan policies and regulations. We agree with the recommendation of no substantial issue, and specifically, no substantial issue related to the site contamination and water quality, biological resources, flood hazards and sea level rise, community compatibility, or public access and recreation. As previously noted, the City and Coastal Commission staff consulted early on to determine what conditions of approval should be placed on the project to ensure that it qualified as a moderate cost visitor serving accommodation. Both the Planning Commission and the City Council on appeal approved the project. We're available for any questions that you may have about the process and our review of the project. Thank you.
Thank you. Okay. Are there any others signed up to speak who oppose the project at the local level who are eligible to speak?
We have 2 eligible speakers, Gareth Kelly and Jordan Sisson, both in person.
Okay, so if you're here, please approach the podium.
Gareth Kelly and Jordan Sisson.
Good afternoon, Commissioners. Do I get a timer? How long? Yep.
Yeah,
I don't need one if you don't want me to give me one.
No, we'll give you 2 minutes.
Okay, good afternoon, Commissioners. Thank you for your time. My name is Gareth Kelly. I'm a local filmmaker and accidental activist. I made a film recently called Keep the Funk. It's available on YouTube, and I'd like to read a quick review of the film by local film critic Joe Woodard. Civic government dubiousness is also an underlying subject of Gareth Kelly's fast, cheap, and just enough in control guerrilla-style documentary, Keep the Funk. Count me as a veteran Santa Barbara and perturbed as the unscrubbed artistic and atmospheric splendors of the so-called funk zone become displaced by overblown and overpriced developments and tourist baiting schemes. Kelly's film chronicles the rising opposition of the Santa Barbara community to a horrific monstrosity of the 101 Garden Hotel proposal, replacing 6 acres of historic and yes, funkified property suitable for housing. The film serves as both an affectionate tour of the zone in its purest state and a passionate account of the uproar and oppositional voices at city council meetings. Also in the mix is a city council meeting which Kelly says essentially shows officials taking a $500,000 bribe. The story and the funk zone continues. A sequel may be in order. I was at the meeting in question. The developers kept saying they didn't have the money for this project to pencil out if it changed. However, when they couldn't get 2 votes, they found $500,000 and the Planning Commission suddenly voted for them. It looked to me like a bribe. I was in that meeting. I saw it with my own eyes. As to the affordability of the housing, the city at all levels has acknowledged that they have zero power whatsoever to enforce any kind of affordability of hotel rooms. So the idea the developer's going to have affordable hotel rooms could be seen as propaganda because there's nothing to stop them raising these hotel rooms to $500 a night, and the city has no power whatsoever to enforce it. So please uphold the appeal for Keep the Funk. Thank you for your time.
Thank you.
Good afternoon, Honorable Chair and Commissioners. My name is Jordan Sisson. I'm a land use attorney speaking here for Local 11. We first want to say how much respect we have for this commission and staff. We do. We respectfully disagree with the staff report that does not find a substantial issue here. We really want to focus on one key issue, lower cost accommodations. This body knows very well what your well-established policy is. It's 25% on high cost, and even on potentially on the higher end of your moderate costs. That's what it seems like with Harbor Hotel. That's what it seems like in Dana Point. We've given you numerous situations where that has been the policy. Here, this did not happen. A lot of live questions happens with this lower cost accommodations analysis. They say it's moderate costs, but if you look at their exhibits, why are standard one bedrooms counted for 4 guests? Normally it's 2. Why are 1 bedrooms counting for 4 people when normally it's 2? That is something we can't answer. We've yet to see a case that has allowed for that. Furthermore, in terms of what they're proposing at the local level is a qualitative approach. They're going to say, these are the things that we feel as if are higher costs. Right? If it doesn't have a valet, it's not higher cost. It'll be moderate. Unfortunately, my clients know all too well how qualitative standards play out. It's the Shore Hotel, Santa Monica. There, that was a situation where it was promised, hey, this does not have any high-cost amenities. That didn't come to fruition. So again, here, there's a lot of live questions of why there is no lower cost accommodations on this development. Qualitatively, it contains many of the features that are listed in the city's qualitative moderate cost hotel. And here, we believe there is substantial evidence. Please find so. Thank you so much for your time.
Thank you.
Thank you. No other speakers.
Okay, I'd like to close the public hearing and bring it back to staff for any comments that you'd like to make in response to what's been said today.
Hi, thank you. Staff would like to respond to keep the appellant's request for a delay of the hearing and extension. The majority of the information that appeared in the staff report was made available to the appellant in a March 12th meeting that took place with staff and the appellant, during which emails were forwarded. I believe there was one email which described a minimal detail regarding the underground parking garage that the appellant did not receive at that meeting. That email, the full details in that email appeared in the staff report. And so staff does not believe that more time and more information would either change our recommendation or allow the appellant to reach a different conclusion. Thank you. And, oh, sorry. And Mr. Hudson would like to add something.
Thank you. I'd just like to add that our analysis, of course, is based on the city's records and the information that was used by the city in their decision. And in this case, we concur with the city that they had adequate information to support their determination that the project was consistent with their certified local coastal program. And in our review, we do not believe it will result in significant adverse impacts and represents a net benefit toward cleaning up this contaminated site. And so for those reasons, we do continue to recommend that the commission take action on this matter today. And I would just like to respond to one additional point with the speaker from Unite here. And they had asserted that the commission has required mitigation for low cost to provide for low cost for both moderate and higher cost hotel projects. And I would just like to clarify that while they are correct that the commission has typically required that 25% of rooms for new high cost projects be either low cost or provide equivalent in lieu fees, we have typically not required mitigation for moderate cost hotels, considering that to be sort of a wash. It's moderate. We have required conditions that locked in those accommodations to remain moderate for the life of the development. Now, this one was a little bit different because it was a decision by the local government. And we did reach out to the local government many months ago when we worked with the applicant and the local government to revise and develop some of their conditions to provide some of those protections for moderate cost on site and ensure that this hotel remains a moderate cost. Now, some of the condition language is not exactly the same as what our staff would recommend, but we do believe that it's adequate. So I just wanted to note that for the record and note that we're available for any questions.
Thank you very much. before I take it to the rest of the commission, I do just have a follow-up question on this, because just reading the staff report, my understanding is that the grounds on which this appeal was filed was related to the soil and groundwater contamination and sea level rise. And so my question is, in terms of us addressing this and finding substantial issue or no substantial issue, it's really based on those two items that were appealed. Like, we can't find substantial issue on something that's not on appeal currently, right? Because the low-cost accommodation piece was not something that was appealed to us. Is that correct?
That's correct. The commission is limited to finding substantial issue based on the grounds that were raised. In our review, we did not believe that any of the appellants raised low-cost overnight accommodations per se, but they did raise public access in more general, so we did include that analysis of that issue.
Okay. With that, I'll bring it back to the commission for any questions, comments. Commissioner Turnbull-Sanders.
Thank you, Chair Cummings. I had a question on page 14 of the staff report, and I think Attorneys for Unite here mentioned this. There was a question about a timely appeal and whether an appeal would be accepted based on the low-cost visitor serving accommodations. Just wanted to find out more about that and how that appeal was received. Was it timely received? Was it denied based on some other information? Trying to get to the bottom of that.
The appeal was received within the appealable window. However, the appellant did not appeal the project at the local level, and for this reason was not considered an aggrieved party by Coastal Act standards.
So procedurally, for members of the public, can you explain that part, the exhaustion of the local remedy before you appeal to the Coastal Commission?
Yes, appeals to the Coastal Commission. In order for an individual to appeal a project to the Coastal Commission, they must have first exhausted their local appeals, meaning they must have gone through the local process and appealed it at each level available to them, unless charged a fee or other kinds of obstructions, I believe.
Thank you. And through the chair, just a follow-up, just because the public access was included in the analysis, and I think staff said that lower cost accommodations was through that window also a consideration. I had a question about the distinguishing between the low-cost visitor serving and the moderate cost visitor serving. And there was also public testimony about the number of room occupants per unit, which would make a difference, I think, in terms of the overall calculation of whether it's affordable on a low-cost basis or a moderate-cost basis.
Yeah. So those occupancy numbers come from the applicant's study on low-cost or moderate-cost accommodations. I believe the rooms are slightly larger than the typical two occupant rooms, but I would defer to the applicant to answer that question.
Thank you.
You can approach the podium.
Thank you, Chair.
Yeah, I think just to answer that question, I mean, these are extended stay rooms. The goal is to host families. So in addition to, what you'll see as double queen beds, you'll also have sofa bed pullouts, right? So I think what we were accomplishing in the numbers was essentially that, an extended stay room could, accommodate a family of 6, right?
So how does that configuration work in a one room to accommodate a family of 6?
2 queen beds and then a sofa pullout.
So 2 people per whatever aperture.
Or some of the rooms in the 1 bedrooms are bigger, right, where you could have 2 queen beds, a queen bed, and a sofa pullout. So, But yeah, I mean, the goal is to obviously accommodate more people per room on the extended stay side.
Thank you.
Yep.
And Chair, I think that concludes my comments. I think it's very important that we still focus on low-cost accommodations. Moderate costs are still very out of reach for most Californians, and so thinking about how we do that on a going forward basis is important, and keeping that in our analysis with these kinds of projects something that we continue to do. I guess just going back to the question of lower cost and moderate cost, is it that based on the staff presentation, if there is a moderate cost application, the lower cost is typically not assessed because moderate is almost there? I want to just think about that for future decisions.
Yes, through the chair, happy to respond. That's essentially our analysis. We've looked at the lost opportunity for low cost when we review what's considered the higher cost projects. And so we've required mitigation for those higher cost projects. Moderate being that sort of middle ground. The commission in the past has not required mitigation for moderate costs. We've found that that doesn't have a significant adverse impact in the same manner as a new high-cost hotel. It offers a different price point than low cost, so it is not the same, but we haven't made a determination in the past that moderate cost in and of itself drives the need for mitigation or results in a significant impact requiring such mitigation as the provision of low cost. And so we wanted to differentiate between high cost and moderate and when is mitigation required.
It's a very complicated analysis. I think the bottom line is we need to do better as Californians to help provide lower cost accommodations. The calculus is very, I mean, it's a lot of mental gymnastics to get around it, but I appreciate the fact that there is at least a moderate cost option, but continuing to go forward, having a focus as a commission on lower cost options, is moderate cost is still out of reach for most people. Thank you.
Commissioner Hart.
Yeah, I just want to follow up on that because would it be possible to bring up that chart again that showed that there were no 2 occupant rooms and the rooms, you know which one I mean?
Can we bring up the staff presentation again?
Slide 6.
If we could pull up slide 6, please.
That one. Because when I saw this, it was confusing to me, and now after this discussion, I'm concerned because, so basically, can you just describe a little more, or maybe we need the applicant to come up. What is the actual cost per night proposed for their rooms?
Sorry, yes, that is in the last column on the right.
But is that total, so total price of a room, which they're saying they're proposing it is for 4 people, is from $224 to $260. That's the cost of the room.
Those are different units that give us that range. There's different types of units with different prices. Each unit has one price, but yes, those are the average daily costs of the rooms proposed in the study.
And Mr. Hudson, just to be clear, your moderate cost analysis is based on dividing that by 4, or is it just the total price, cost per night?
I want to make sure I understand that question. You said the moderate cost is derived from...
So they're saying, let's just average this and say the cost of the room is $250 per night, and they're proposing that 4 people, that the rooms are all set up for a minimum of 4 people, that there's no 2-person rooms. All of the rooms they're proposing are 4 or more.
Yes, it is, but my understanding is that price range is the total cost of the room. So regardless of the number of people staying there, the price is the $240 to $300. Our analysis was simply that the $300 fits within the range of the $210 to $350, which is the range for moderate.
Okay, so regardless, even if it was just for 2 people, you would feel that so let's just average say it's $250 per night is moderate for this area?
Correct.
Okay, that answers my question. Thank you.
Any other questions from commissioners? Commissioner Ranga.
Okay, now I can understand that low cost and moderate cost are dependent on the area. Is that correct? They weren't location, not one size fits all.
Yes.
Sorry, actually, these numbers come from the statewide peak season average daily rate.
It was a statewide formula
Correct, yes.
they are using. Thank you.
Any other questions or comments from commissioners? Commissioner Harmon.
Thank you, Mr. Chair. Well, I'll make a few comments as the local representative and member of the Santa Barbara City Council here. I just want to start by saying that here in Santa Barbara, and I think this is happening everywhere across coastal California, we're really facing some existential questions about what our little beach town is and what it's going to be, and who it's for, and who we want it to be for. And there was a lot of conflict about this hotel on that basis, and I think that conflict really demonstrates some of those questions that we're grappling with week after week after week on a local level. As I said when I was on the city council dais when this matter came before us, you know, I, on a personal level, was pretty conflicted about this project. I am, it's true. And by the way, I absolutely agree with the comments made by Commissioner Turnbull Sanders that we need to be thinking very critically about affordability and what affordability really means and what it should mean for coastal visitors. But our work today, and I think it's important we keep it in the front of our minds, our work today is to look at the proposed project on the valid appeal grounds that were raised, and to specifically look at those valid appeal grounds through the lens of the Coastal Act vis-a-vis Santa Barbara's approved and certified LCP. So it really is a narrow consideration that we have before us, and I think our staff here at the Coastal Commission have done a very thorough analysis on those specific grounds, and I agree with their assessment that the project is in compliance with the approved LCP. Thank you.
Okay, any further questions or comments from commissioners? Seeing none, I'm just going to mention, well, first of all, I just want to thank everybody for being here, for all the comments that were made, for the appellants and the applicants, and the actions that were taken by the city of Santa Barbara. I'm going to say that I share the same concerns that have been brought up by Commissioner Turnbull Sanders and others regarding low-cost accommodations. I mean, personally, I would rather see a mix of units with higher-end rooms and lower-end rooms rather than just moderate, because this is still not affordable. I mean, like, these rates, I was just checking online, reflect the Dream Inn in Santa Cruz, which is one of our highest-end hotels. And so to have rates that are comparable to some very high-end hotels just makes me think that this isn't moderate for most working-class people and absolutely not accessible for lower-class people. That being said, the other conflict I have is that when I read this report, my understanding was that the appeal was based on sea level rise and soil contamination, which I think you all did a great job of explaining, and that's the direction I'm going to go in is based on what was on the appeal. I feel like oftentimes, and I really want to applaud Unite here for all of their hard work in trying to get us to have low-cost accommodations built on site and rooms for their hotel workers, because I think it's really critical that people are able to live near where they work and that the people who work in these facilities can actually go there with their families. But that's not the grounds upon which this was appealed, and which we've seen in the past. I mean, we had the Cruise Hotel a couple months ago, and low-cost accommodations was the grounds upon which that appeal had been made. And that's not the case today. It's vague, and I don't, and because it's so vague, I'm not comfortable finding substantial issue and having it go back, because it was clear in the staff report to me that the grounds upon which the appeal was filed was sea level rise and soil contamination. I think that's been addressed. So I'm happy to move forward. I do want to encourage my brothers and sisters with Unite here that if there are hotel projects, please appeal them on low-cost accommodation grounds, so it's very clear to us, so that way we can take up substantial issue, and that goes for anybody else who really wants to see us build low-cost accommodations in the coastal zone. But with that, I'm going to end my comments, and I'm happy to. I'm actually not happy to move forward, but I will reluctantly support the staff recommendation today. Commissioner Hart will make the motion.
I move that the commission determine that appeal number A-4-SBC-24-0054 raises no substantial issue with respect to the grounds on which the appeal has been filed under section 30603 of the Coastal Act, and I ask for a yes vote.
Second.
Okay, so we have a motion by Commissioner Hart, second by Commissioner Kelly. The makers of the motion are asking for a yes vote, and I want to see if there's unanimous consent to approve this item. Okay, there's unanimous consent, so that passes unanimously. Are there any other motions for consideration on that item? No, I don't believe so. Okay, seeing none, we will move on. So I want to thank you all very much for being here on this item, but that concludes the Garden Street Hotel. The next item before us is item 13B, appeal number A-4-STB-24-0055, Miramar Acquisition, LLC. I'll turn that to staff for a presentation on this item.
Thank you. And item 13B will be presented by Denise Gonzalez, a planning supervisor in our South Central Coast District. We do have a presentation for this. If we could pull up the PowerPoint, please. And Denise, it's all yours.
Thanks, Steve. Good afternoon, Commissioners. Item 13B is a substantial issue hearing for an appeal of a CDP approved by the County of Santa Barbara to construct 54,768 square feet of mixed-use development consisting of 26 housing employee units, 8 market rate units, and 17,100 square feet of commercial space, which will be comprised of up to 12 resort retail shops and a resort cafe at the existing Rosewood Miramar Beach Resort. The applicant is Miramar Acquisitions Co. LLC, and the appellants are Heal the Ocean and Unite Here Local 11. The project was processed under the Housing Accountability Act and also utilized the state density bonus law. Additionally, the affordable housing employee units will remain affordable for the life of the development. Next slide, please. The project site is located, The project site is located on a 16-acre property zoned resort/visitor serving commercial located at 1759 South Jamison Lane and 96 Eucalyptus Lane within the Montecito community in unincorporated Santa Barbara County. As seen here, the resort is south of US Highway 101 and north of Miramar Beach and is primarily surrounded by single-family residential properties and a church along Eucalyptus Lane. The site does not contain any environmentally sensitive habitat areas. The resort is currently developed with 154 hotel guest rooms, resort shops, 4 affordable employee housing units, a restaurant, spa facility, and on-site parking spaces. As seen here, the residential and commercial development will be located in the existing northwest and northeast parking lots. No construction will occur on the remaining 13 acres of the resort property. Next slide, please. The approved development in the northwest parking lot features 2 new mixed-use buildings, referred to as buildings A and B, as shown here. Each building will include 4 market-rate apartments on the 2nd floor with commercial retail space on the 1st floor. Additionally, there will be a subterranean parking garage situated between both buildings, providing a total of 79 parking spaces. In the northeast parking lot, a single new residential building, shown here as Building C, is proposed. The building will be comprised of all 26 affordable employee housing units. Furthermore, the site will also have a reconfigured parking area with 350 parking spaces located south of the residential building. The 2 appeals in this case contend that the current resort generates excessive traffic and lacks sufficient parking, leading to overflow onto nearby streets and public parking areas. The appellants also argue that the approved project will further increase the demand for parking, which could adversely affect surrounding public parking and in turn hinder access to the beach and other coastal resources. To support their claims regarding the project's parking and traffic issues, the appellants have provided personal observations, photographs, and videos. Staff recognizes that when private development lacks adequate on-site parking, the parking spaces typically available to the public for coastal access may be occupied by the private development. As a result, coastal visitors may find it difficult to park near coastal amenities. The county's LCP emphasizes the need to enhance public access to the coast by requiring adequate off-street parking to be provided for new development. Next slide. The resort is located next to Miramar Beach, which is accessible via the public stairway at the end of Eucalyptus Lane and 3 public pedestrian access easements that run across the resort. The resort currently provides 435 on-street parking spaces. Additionally, there are 87 public parking spaces along South Jamison Lane, Eucalyptus Lane, and Miramar Avenue, which can be used for beach parking. These 87 public parking spaces were provided as mitigation to offset the loss of public parking spaces from the redevelopment of the resort. In this case, the project requires a total of 83 parking spaces under the county's LCP. However, the county granted a parking modification to reduce the required off-street parking spaces from 83 to 44. As a result, the total parking supply at the resort will be 840 spaces, which will be distributed throughout the resort property. These 480 spaces are highlighted in yellow on this slide. The LCP allows for modifications to parking requirements and encourages the efficient use of commercial parking spaces by allowing the total parking requirements for mixed-use developments to be based on the number of spaces needed to accommodate the various individual uses during peak parking periods. The county approved the parking modification based on the findings of a peer-reviewed parking analysis that utilized a shared parking model. This parking model assessed the peak parking demands of the existing resort and the new development during periods when the hotel, restaurants, and beach club would be busiest. The peak parking demand was estimated to be 462 spaces, which is lower than the approved parking total of 480 spaces. Moreover, the county's Department of Public Works reviewed and approved the project's submitted traffic and parking studies. The county conditioned the CDP to include several measures and protocols, such as a transportation demand management program, a designated traffic coordinator to inspect the public parking spaces, parking signage, a parking decal program, and annual compliance reports to ensure that resort guests and employees do not utilize the nearby public parking. Moreover, the county has indicated that the currently required parking plan and transportation demand management program have been effective based on the 5 years of reporting, and that there are no current violations on the property. As a result, the county determined that the project would not significantly impact parking and traffic in the area and would not adversely impact public access to nearby beaches. The county's findings are supported by evidence, and as conditioned, the approved CDP is consistent with the Coastal Act and LCP policies. Thus, the appellant's contentions regarding public access do not raise a substantial issue. Next slide, please. The appeals allege that the approved development is located in areas that are at risk for flooding and mudslides and fall within a FEMA-designated flood zone. They further argue that given sea level rise cannot be accurately predicted, the potential impacts of the project have likely been underestimated. Further, the appellants argue that the project violates the Commission's environmental justice policy because the affordable housing units are located within a flood zone. The approved affordable employee housing building, shown here in yellow, is located outside any floodways. However, as seen on the map to the left, the building is within a designated FEMA flood zone with a 1% annual chance of flooding of less than 1 foot under the current applicable FEMA flood maps. The area with a 1% annual chance of flooding is shown as light blue. It's also worth noting that the current FEMA flood maps are set to expire and will be replaced with a preliminary FEMA flood map estimated to be adopted in 2026 by FEMA. The pending preliminary FEMA flood map, shown here on the right, shows that the affordable housing as being within a 0.02% annual chance of flooding, thereby showing a lower risk of flooding. The area depicting the 0.2% annual flooding risk is shown here as orange. Although the affordable housing project is situated in a FEMA flood hazard zone, the project's lowest finished floor elevation has been designed to be at least 2 feet above the base flood. This design aims to reduce the risk of potential flooding during storm events and to ensure the safety of its occupants. Additionally, the development is entirely outside the 50-foot esh buffer of Oak Creek, which lies to the west of the property. Next slide. Additionally, the county considered the impact of projected sea level rise on the proposed development. The project's sea level rise flood hazard report concluded that the affordable housing building, which is located approximately 425 feet from the ocean, would not be affected by a 100-year storm with a projected sea level rise of 4.5 feet. As can be seen on this slide, the Cosmos output shows that the affordable housing project is not at risk of flooding, even with a sea level rise of up to 4.9 feet. The report concluded that the approved project would be safe from coastal hazards, including flooding and erosion, throughout its design life. Lastly, the project has been reviewed for compliance with flood standards and conceptually approved by the county's flood control district. The appellants also assert that the affordable housing units would be vulnerable to mudslides, referencing a storm impact consideration map from the Montecito Fire Department. However, this map specifically states that its purpose is to inform properties about potential evacuation in the event of a severe rainstorm, and it is not intended to assess potential mudslide risks on individual properties. Additionally, only a small portion of the northeast lot falls within the map's depicted storm impact zone, and the approved footprint of the affordable housing building is situated outside the zone. The approved affordable employee housing units will also help address the pressing need for affordable housing in the coastal zone, especially for low-income workers. Additionally, these units promote equitable access, which is in line with the Commission's adopted environmental justice policy. The Commission's action included ample findings and evidence determining that the approved project would minimize risks from coastal hazards in compliance with the Coastal Act hazard policies of, with the coastal hazard policies of the county's LCP. As such, the Commission finds that the appeal contentions regarding conformance with the coastal hazard provisions and policies of the LCP do not raise a substantial issue. Lastly, the county also found that no significant coastal resources would be affected by the project. The project site is an infill lot adjacent to existing single-family residences and commercial uses, and is located in a developed urban area of the county. There are no significant coastal resources and no environmentally sensitive habitat areas on the site that would be negatively affected by the project, and the project will be compatible with the surrounding area and will have no adverse impact on visual resources or public access. To conclude, the county's action included findings and evidence supporting its conclusion that the approved development is consistent with the relevant policies and provisions of the county's LCP. Therefore, staff is recommending that the Commission find that no substantial issue exists with respect to the grounds on which the appeals were filed regarding the project's consistency with the LCP. There is an addendum for this item, which includes and addresses correspondence received since the publication of the staff report. Notably, a correspondence letter from Jordan Sisson, representing the appellant, Unite Here Local 11, claims that staff is inappropriately applying a different sea level rise scenario and risk aversion approach in our analysis of potential sea level rise impacts on the subject project compared to the analysis conducted in the Magnolia Tank Farm project, which was before this Commission. In response, staff disagrees with Sisson's allegation that staff is inappropriately applying a different risk approach to the two projects. When evaluating the impacts of sea level rise on development, the Commission uses the best available scientific information to determine locally relevant sea level rise scenarios. Currently, the best available science on sea level rise projections is provided in OPC's 2024 sea level rise guidance, which is reflected in the Commission's sea level rise policy guidance. This guidance offers recommendations for selecting projections based on the project type and risk aversion level. A medium-high risk aversion scenario is recommended for residential projects, as it accounts for higher potential sea level rise. Staff confirmed that the projections used in the project's analysis included a 4.5-foot rise by 2100 is consistent with the Commission's sea level rise policy guidance. In the Magnolia Tank Farm case, Mr. Sisson alleges that staff evaluated a higher level of sea level rise, specifically 7 feet, in contrast to the subject property, which only assumed a rise of 4.5 feet. However, the commission did not base its risk analysis solely on the 7-foot sea level rise assumption in the Magnolia Tank Farm case. Instead, it considered various scenarios for sea level rise to assess different risks, including groundwater flooding and flooding from storm conveyance channels. This case also involved a larger community redevelopment project through a local coastal program amendment. It is acceptable for projects of different scale and in different locations to use somewhat different risk analysis, so long as they rely on the best available science. The risk analysis conducted in this instance was appropriate. The addendum also included correspondence from Assemblymember Greg Hart, the California Department of Housing and Community Development, and members of the public supporting the staff recommendation. In addition, letters opposing the staff recommendation were also submitted by the appellant's representatives and other members of the public. No new issues were raised in those letters which were not already addressed in the staff report findings. The motion for this can be found starting on page 8 of the staff report. Now I'll turn it back over to Steve, who would like to add some brief comments.
Thank you, Denise. And I don't have any additional comments. I'll just note the staff will be available when you're ready for questions.
Thank you very much for that presentation. So I'll bring it back to the commission to see if there's any ex partes on this item. Commissioner Aranga.
I have 2 ex partes, one from the applicant, another from the appellant. On April 2nd, at approximately 2:30 p.m., I had a meeting with Jonah Breslau, President King, George Sasson, my staff, regarding their position in opposition of this project. They made some comparisons about Magnolia Tank Farm, and also feel that the normal hearing should be held. On the same date, at 1:45, I had a meeting with Ann Blanker, Bryce Ross, Katie Mangan, and Susan McCabe regarding the project, and they are in agreement with the staff report. And these are on file.
Thank you very much. Any other ex partes? Commissioner Harmon.
Thank you, Mr. Chair. I do have did two ex partes on this matter, and they're both on file. Just flagging that.
Okay. Any ex partes on this end? Okay. Seeing none. I do have 2 ex partes. These were submitted on Monday, so I'm going to report them out. The first was, well, actually, I'll go in reverse order. My first ex parte, Miramar acquisition, April 3rd at 4:08 p.m. via Zoom with Hector Axel-Pulqueta and Josh Breslau from Unite Here, Local 19 and Local 11, and my staff member, Trina Barton, joined me in that ex parte. So on April 3rd, 2025, I and my staff member met with the representatives from Unite Here, Local 19 and Local 11 to discuss the Miramar Hotel project on the upcoming agenda. The representatives from Unite Here want the commission to find substantial issue on the appeal. Their biggest concerns were that the affordable housing was going to be built in the flood zone. And they thought the affordable housing should be co-located with the market rate housing, which will be built outside of the flood zone. They also expressed concerns regarding parking availability and the need to have those issues addressed. They think that the developer should conduct a sea level rise analysis of 7 feet rather than 4 feet. My next ex parte communication was on April 4th at 2:30 p.m. The person initiating the ex parte was Ann Blemker, and the people in the communication was Ann Blemker, Susan McCabe, Kate Margin, Bryce Ross, myself, and my staff member, Trina Barton. So on April 4th, 2025, I and my staff member met with the Caruso team to discuss the Miramar Hotel project. The developers provided a presentation of the project and emphasized that the project will provide 26 units of affordable housing for their workers, which will result in 76% of the project being affordable housing. They emphasized that they receive unanimous support from their Planning Commission and the County Board of Supervisors. They conducted a parking analysis which suggested that they will have excess parking and intend to monitor the parking to ensure that there continues to be public access. I asked the developer team if they had met with Unite Here, to which they said no, but had received emails from that group. They also highlighted that Unite Here is not in Santa Barbara currently, but they may be trying to establish in Santa Barbara. I also expressed to them that for future projects, they should reach out to unions to try to address the concerns that they may have. They did express that they had the support from the local labor carpenters union for the project. They also expressed the importance of having affordable housing. The percentage of affordable housing units goes beyond what will be required, and they see this as a benefit for their workers so that they don't have to drive long distances to get to work. And I'll also note that they had done extensive community outreach, and that was mentioned in our conversation as well. That concludes my ex parte. And seeing no other ex partes, I guess at this point in time, I would like to invite up the appellants. And so Chris or Simone are the appellants present?
Yes, we have, as I understand, 2 groups of appellants, and we have 4 people signed up. Marco Gonzalez from the Coastal Law Group, and then in person, Noah Boland, Hillary Hauser, and Jordan Sisson.
Okay, so each group will get 3 minutes. And so if you can invite up the representative from the first group.
First, we had Marco Gonzalez from the Coastal Law Group, and they are on Zoom.
Okay.
And they are in, and we see you. Go ahead.
Thank you. My name is Marco Gonzalez with Coast Law Group. I'm here representing Heal the Ocean, a group with a long history of efforts to protect the Santa Barbara coastline and its natural resources, including from overdevelopment and water pollution impacts. Simply put, we disagree with staff's recommendation that it find no substantial issue, and we urge you to bring the matter forward in a de novo hearing where we can go more thoroughly through a number of the issues that have been raised on appeal. At the outset, I want to be very clear. Heal the Ocean absolutely supports the construction of affordable housing in the coastal zone, especially in wealthy communities like Montecito. We agree more must be done to provide housing for the workforce that is critical to the quality of life we value in a community like this. However, it is clear from the record that the provision of this housing in this particular location is offered merely as pretext. What I mean is, it is no secret to anyone that the applicant's driving desire is to create a new commercial center at the edge of the property. Their goal is to bring significant additional day-use customers to the ultra-luxury resort, tapping into tourists and others who are not currently guests of the resort. Again, put simply, the applicant is using the purported benevolence of providing affordable housing to take focus away from the severe public access issues that have already been created by the resort, not to mention those everyone knows will be exacerbated in the area. Heal the Ocean, in its written comments, disclosed numerous uncertainties associated with siting the affordable housing in the southeast lot, including that it is within the 1% annual flood chance zone and within a storm impact zone, as staff recounted. The applicant and staff dismissed these concerns as unfounded or unworthy of deeper attention, but Heal the Ocean believes they warrant particular scrutiny given both the intersection of multiple identified hazards and the simple fact that there are other more appropriate locations on site for the housing. I would also note that at the state level, there has been expressed displeasure with projects that would take the affordable units and separate them into unique buildings away from the market rate units. In essence, this is seen as a segregation of less economically advantaged communities, which is exactly what's happening here. So while Heal the Ocean strongly supports construction of affordable workforce housing, we do not agree with the hubris of the applicant, namely that it claims to comply with the Commission's broad environmental justice policies, when in reality what they are doing is placing vulnerable populations in a location that is next to vulnerable environmental hazards and the freeway. Looked at through this lens, this is exactly why you have those EJ policies in the first place. Simply put, better alternatives exist and the housing should go in the northeast lot. That being said, there's substantial evidence in the record of public impacts, public access impacts, and we think they've been given short shrift by both the applicant and the staff, and we think a deeper dive could be had at a de novo hearing, and so we encourage you to reject staff's recommendation. Thank you.
Thank you. And then the other group, Unite Here at Local 11.
Thank you, Chair, Honorable Commission. Jordan Sisson, attorney for Local 11. To start, we have, again, great respect for this commission and for staff, and there's no one that is suggesting that staff doesn't take their job very seriously. However, we do respectfully disagree. on the staff report's conclusions. Again, to be clear, Local 11 supports affordable housing. And here it seeks to have the project add what we seem to believe are prudent design changes and feasible mitigation that would minimize risks, ensure public access, and address environmental justice issues. And there's three main issues we would like to discuss. On the sea level rise, we agree with Heal the Ocean. You have two feasible sites. There seems to be a very simple solution. You swap the location of the retail and housing. This is an environmental justice issue, like Magnolia Tank Farm. The question before you, is 4.9 feet of sea level rise enough? Is that all that is required when it's feasible to provide even more precautions? Here, you have to ask yourself, is it feasible to have this reasonable project design change? We believe it is. Second, on spillover impacts regarding the parking, you have videos, you have photos, you have ample evidence showing an existing jammed resort that is impacting the public parking. Like the Pacific Edge project, that could be fixed. You can have special conditions that tighten up the parking plan to ensure that the county, subject of an earlier hearing today, not only they enforce it, but that the county can enforce it. You have to ask yourself, is it feasible to have strengthen the TDM measures? Can this have a mandatory TDM program? Is there feasible mitigation? We're not asking for denial, we're asking for feasible mitigation. Third, on the lower cost accommodations. It's undeniable that this project is luxury hotel or luxury shopping at the most high cost resort in Santa Barbara. It provides no lower cost rooms where there was once more than 200 rooms on this site, including rooms that are on the location where there's the proposed retail. According to that 2023 survey of hotel offerings in Santa Barbara, there's only 1 out of 58 room hotels that provide lower cost. The status quo doesn't seem like it's doing enough. So we ask, why is it feasible in Dana Point, Magnolia Tank Farm, American Tin Cannery, the Santa Cruz Hotel? It was feasible to provide a really creative public benefits package that provided lower cost access. And where you have a hotel that provides no overnight accommodations, having greater day access does matter. So in sum, every case is unique. But here, we respectfully believe that there is a substantial issue. We're asking for feasible mitigation. It's available. Please find substantial issue. Thank you so much, and thank you, staff.
All right. Is the applicant present?
Yes, we have someone signed up as in person, Katie Manglin.
Okay. Just a point of clarification. There were two groups for appellants, correct?
Yeah, Heal the Ocean, and we heard from
So we heard from both?
Yes, you've
Okay.
heard from them both.
All right, so now we're up to the applicant. So if the applicant wants to step forward, you'll have 3 minutes.
Good afternoon, Chair Cummings and Commissioners. I'm Katie Mangan. Thank you to Ms. Gonzalez and staff for the incredibly thorough and comprehensive staff report. As underscored by staff, our project is consistent with the policies and provisions of the county's LCP. This is an important housing project supported by a dozen shops. 2/3 of the plan is residential, and of that, 76% is affordable housing for our employees. We worked hard to craft a plan that blends seamlessly with the existing hotel and surrounding community, protects coastal resources and public access to the coast, and is designed for the safety of our employees, residents, guests, and community. As shown in the staff report, we met these goals in a manner that is both consistent with and advances the policies and provisions of the county's LCP. The appeals and form emails generated by Unite Here's text campaign across Los Angeles perpetuate misinformation and mischaracterization of the facts. This plan, we find it confusing that the appellants are obstructing this plan, which will bring 26 much-needed affordable apartments for hotel workers in Santa Barbara County when they purport workforce housing to be one of their top priorities. This plan began with our understanding of the challenges our employees face finding affordable housing in Santa Barbara, and was shaped by literally hundreds of community meetings, workshops, and conversations over the course of 2 years. We're proud to have earned the support of hundreds of neighbors and members of the community who are here today and care deeply about the future of Montecito. We've also earned the support of the 90,000 members of the Western States Regional Council of Carpenters and the 2,700 local LIUNA labor unions. This, as staff mentioned, the State Housing and Community Development Agency, as well as our Assembly Member Greg Hart. We thank the community for their time and participation in this process. This plan is the only affordable housing proposed in Montecito. It complies with state laws intended to facilitate mandated housing in high barrier to entry communities like Montecito, including the Housing Accountability Act and the Housing Crisis Act. And the importance of these laws is quite clear, as this is the first affordable housing project in Montecito in nearly 3 decades. This plan does not require rezoning. It implements the county's state certified housing element commitment to work with the Miramar on the development of employee housing. It earned the unanimous approval of both the County Planning Commission and the County Board of Supervisors. We have the best team in hospitality, some of whom unfortunately face daily multi-hour commutes. This plan provides them access to affordable housing that does not exist today. Your staff has diligently reviewed the appeals, and we respectfully request that you uphold staff's recommendation, find no substantial issue, and uphold the County Board of Supervisors' unanimous approval. We're available to answer any questions. Thank you.
Thank you very much. Is there a representative from the county here who wishes to speak?
Yes, we have on Zoom Joe Dargle.
Yeah.
Joe, go ahead.
Yeah. Yes, thank you, Mr. Chair and commissioners. I'm Joe Darrow with the County of Santa Barbara Planning and Development Department. And as the county, we wanted to highlight that this project is an important piece to the county's overall housing numbers that were evaluated in the recent housing element update. In total, the county is required to provide nearly 6,000 new units as part of our RENA numbers, with over 4,100 of those units being in South County. So this project represents the only low-income project in the Montecito area, and it was conceived of during the housing element preparation. It was included in the housing element unit numbers and will help us meet our total unit as well as our low-income obligations. We also have Willow Brown online. If you guys have any questions for us, we're available. Thank you.
Thank you very much. And let your CAO know that we were disappointed that no one from the county could be here for our enforcement item today. With that, are there any qualified commenters for this item?
We have 5 people signed up. It appears only 1 is qualified, and that would be Paige Robinson in person.
Okay.
Paige Robinson.
Ms. Robinson.
Hey, wake up. Thank you so much for being here. I'm really tired, so I can imagine you are. My name is Paige Robinson. I live directly across the street from Caruso's newest planned development. I didn't know I was going to speak today, so forgive me if this is a little garbled. The county staff approval was based on, the Coastal Commission's approval was based on the county's approval with developer-provided parking plans and analysis. The peer review was also developer-provided. So how do we know if that information is true? This project is based on 100% valet, based on 100 employees. I don't know if that's true or not, but that's what the assumption is. The only 2 groups that are conditioned for parking are overnight guests and employees. So I ask you, where will the following park? Shoppers, diners, club members, part-time employees, contract employees, 61 new retail employees, vendors associated with events, photographers, musicians. All I have to do is walk out my front door and see the photographer with his equipment scurrying over to the Miramar. So I love the question, who is this beach town for? It's a great one. What's coastal access for? Right now, the county is subsidizing private enterprise by offering up free coastal parking, blocking the regular average Joe who can't afford a hamburger, let alone a sweater in one of these shops. And we say there's 3 lines of coastal access, but what good is that if it's full of people that are going to the Miramar Club and shopping at the Miramar? I walk my dog, I see it all the time. I don't take photos anymore, I'm too tired of it. All we're asking for is de novo to have a closer look with a parking plan, I have no idea, with conditions.
Thank you. And I just want to reiterate that we did have 4 other people sign up, but they don't appear to be qualified to speak.
Okay. And then I was made aware that apparently the executive director from Hilda Ocean is here. I just wanted to mention that there was a representative for you who took the full 3 minutes. I don't know if you all hadn't had any coordination, but I can give you a minute just to, out of the sake of.
Excuse me, Hillary Hauser, Hilda Ocean. I was confused. Do I get to speak or not?
Your representative spoke for the full 3 minutes.
Okay,
so.
fine. Just, I heard my name and I just wanted to make sure.
Okay, thank you. Appreciate it. Okay, so with that, we will bring it back to staff. We'll close the public hearing. We'll bring it back to staff for any comments on what was discussed here today.
Thank you. So the first comment that I'd like to address is regarding the flooding concerns. Although, as previously mentioned, the site is located within a FEMA flood zone, the site has been appropriately designed to be 2 feet above the 2 feet above the base flood elevation, and the county's flood control district approved and reviewed the project. Regarding the concerns regarding the project not including any additional overnight accommodations, the project before us does not include the redevelopment or addition of any new hotel rooms. The mitigation for having demolished the existing low-cost rooms, that was provided through an in lieu fee under the previous CDP that was approved by the county. It was a local CDP that was approved by the county. And in that CDP, the county required an in lieu fee to provide for 25% of the higher cost rooms. And that was provided as, if I recall, it was to provide for affordable cabins at the Halama Beach, County Beach. The other concern regarding parking, the project does include additional parking to accommodate for the new development. The county's LCP allows for a modification to reduce that for mixed uses, and we believe that that provides sufficient parking for this site. I'll go ahead and pass it over to Steve.
Thank you, Denise. That covers our responses. I just wanted to provide a quick overarching observation. And that was one to thank the applicant for working with our staff before the county acted on this as well. We did work with them to become familiar with it. We did ask for some changes, including one change, which was in my opinion, I was pleased that this was 24 units of affordable housing, and this is a true affordable housing project. There are 8 market rate units, but the majority of these are affordable housing. And I have seen enough of these projects now where the affordable housing seems to be tacked on at the end of a large market rate, and that's not the case here. This is an affordable housing project. It wasn't a requirement. They came to the county and proposed this. We did ask them to make a change and propose to the county to ensure that these rooms remain affordable for the life of the development, not just the number of years. I believe that was 60-something years. That was the original requirement, and they agreed, and that was part of their proposal. So that was the project approved by the county. So we were pleased that this will provide these 24 affordable units for the life of the hotel. For the reasons Denise mentioned, we do believe that we've addressed these issues of flooding, parking, and we believe those are adequately addressed. So we do continue to recommend the commission find no substantial issue, but I'll just end our comments and note that we're available for questions.
All right, thank you very much. Before I open it to the commission, I do just want to remind ourselves that, what was seen in the staff report, the basis on which the appeal was filed was related to the parking and parking as it relates to public access. And so I'm just wanting to reiterate that because there's a lot of discussion around affordable housing and all these other issues, which really isn't what's before us today. It's really the parking issue. And so with that, I'll look to my commissioners to see if there's any questions or comments. Seeing none on this side, Commissioner Wilson.
Thanks, and I agree with that. I will say that, as everybody in this commission knows, my general feeling around parking is that it's subservient to housing. We're in a housing crisis, a parking inconvenience, and I think that's something that we're going to have to plan for and do better on. The other part about this that I think is interesting is the reference to affordable housing and how it meets affordable housing criteria, but what it doesn't meet is the Fair Housing Act, and that's okay. I mean, the thing is that only applies if you're getting funding from federal sources under that, because under that, employment discrimination is something that you can't do, except if you're a teacher or a farm worker. So I would ask that people consider, petitioning the federal government to expand workforce housing exemptions to the Fair Housing Act, so that we can have things for, visitor serving workforce, or for our medical facilities, or for other things that we need in our communities that we need to get more funding for these workforce housing. So that's my comments on this. I support this finding of no substantial issue based on the report here.
Commissioner Harmon.
Thank you, Mr. Chair. A lot of Santa Barbara items today. Just want to make a couple of comments. First, to start, I want to acknowledge Hillary Hauser and Heal the Ocean and the work that they do in our community, particularly for the watchdog role that they play. It's absolutely critical to bring up these important issues as we move through the project process. So I want to express my gratitude to her and her team. And they have raised important questions, and I appreciate the opportunity for our staff to weigh in. So my gratitude on that. Also, thank you to Unite Here. Again, I couldn't agree more about the need for affordability and visitor serving accommodations, but as our chair articulated to begin, I don't think that's what's before us today, and it's not specifically appropriate here to be talking about those considerations. And the fact is, there are affordable housing units that are coming in with this project. And to me, that's very, very important. And I know that's very important to us as a commission. The parking issue, an important one to consider, but staff's analysis has it absolutely right, in my view. There's been a peer-reviewed study. There's already in existence a parking plan that has been monitored over the years and will continue to be monitored. I think that issue is has been sufficiently dispensed with, and I think this will be a good project, and I support it moving forward, so I will second the motion that Commissioner Wilson makes when the time is appropriate.
All right. Seeing no further questions or comments from our commissioners, I just want to thank staff for all their work. I want to thank the appellants for bringing this to our attention, and I also want to thank the developers as well for bringing this project actually coming to us. 76% affordable housing in a project is almost unheard of outside of 100% affordable projects. And looking at these maps and the flood and hazard mitigation that's before us, if we start getting into a situation where those properties are going to be under threat, there'll be a lot of conversations that are going to be had around managed retreat and how we're going to deal with this. I think the fact that the housing is going to be 2 feet off the ground is one way to try to get at some of these flood issues. But again, what's before us today is really the issue around parking, and the fact that there's going to be 480 parking spaces just seems like that's probably enough for your day-to-day, unless there's overlapping weddings at the same time at the site, which may bring a lot more people. But in general, I think one of the things that this commission has really been supportive of is affordable housing and trying to get hotels to build housing for their workers. That's what we constantly hear from Unite Here, and it's something that we're supportive of. And so I couldn't see us today rejecting an affordable housing project like this, where the developers actually went above and beyond what was required in this instance to build affordable housing for their workers. But again, the grounds on which we're making our decision today is on parking, and I do believe that staff has demonstrated that there is sufficient parking to provide public access and to provide parking for the hotel. So I'm supportive of the staff recommendation. And so given that we need to move on to a couple more items, if there's a commissioner who'd like to move this item, oh wait, are there any more questions or comments, actually? No? Okay. So a commissioner want to move the item?
I'll do. I move that the commission determine that appeal number A-4-STB-24-0055 raises no substantial issue, with respect to the grounds on which the appeal has been filed under section 30603 of the Coastal Act. I'm recommending a yes vote.
Second.
So motion by Commissioner Wilson, seconded by Commissioner Harmon. The makers of the motion asking for a yes vote. I'd like to see if there's unanimous approval to support the recommended actions. Seeing no objection, that passes unanimously. So thank you all for your time. Thank you for being here today. And with that, we have two more items before us. We have South Coast District, Los Angeles County, item number 16. We'll give it a minute for people to leave the room. What are you doing later? Are you gonna chill out? Yeah. Go for it. All right. We got a couple more items, so let's try to get through these pretty quickly. Next is item number 16, Deputy Director's Report for Los Angeles County. I'll turn it to staff for a presentation on this item.
Thank you. Item 16 is the Deputy Director's Report for the South Coast District. This month it includes 4 waivers, 1 immaterial permit amendment, and 1 emergency permit. In regard to that emergency permit, I would just note it was issued to the City of Long Beach to relocate and replace a ruptured 12-inch water main at Alamitos Bay Landing. And that was to maintain potable water quality and restore water supply for fire protection of the surrounding residential and commercial areas. In addition, we have 1 change to the items in the Deputy Director's Report, application 5-24-1051-W. That's the waiver application by Fa Fong Vo is postponed to address a noticing issue. And that waiver is thus removed from this month's report. And we intend to reschedule that at an upcoming hearing, most likely our May meeting. Staff is not aware of any opposition to any of the remaining items being reported today, and we're asking whether 3 or more commissioners object to any of the items in the Deputy Director's Report. Staff is available for questions.
Thank you very much. Are there any ex partes on this item? Seeing none, are there any members of the public signed up to speak on this item?
We only had one Thong Vo who is signed up, and we aren't seeing them in the Zoom meeting. There are no other speakers.
Okay. We'll bring it back to the commission. Any questions, comments? Seeing none, do 3 or more commissioners object to the staff recommendation? Seeing none, commission concurs. That'll move us to our last item, item number 17A, appeal number A-5-VEN-24-0053, Showghi, Venice, and I'll turn it to staff for the presentation.
Thank you. Item 17A will be presented by Seth Villanueva, a coastal program analyst in our South Coast District. I would like to note that this will be Seth's first presentation to the Commission. We do have a PowerPoint, and Seth, take it away.
Welcome.
All right. Good afternoon, now evening, Commissioners. Item 17A is the substantial issue hearing of an appeal of a local CDP approved by the City of Los Angeles for the demolition of a 1-story, 1,497 square foot single-family home on 2 lots, and the construction of a new 2-story, 25-foot high, 11,045 square foot 4-unit apartment building with rooftop decks and a subterranean level containing 9 parking spaces and 4 recreation rooms. Next slide, please. The project site is located in the Venice community of the City of Los Angeles, approximately a half mile from the beach. Next slide. As can be seen in this aerial image of the subject site and its surrounding area, the Oakwood neighborhood of Venice and the subject block are characterized primarily by a mix of 1- and 2-story single and multifamily homes, as well as commercial and mixed-use buildings in close proximity, all of varying sizes and architectural styles. The subject lots are designated for multifamily residential use by the Certified Venice LUP. The site is located at the end of a residential block with an alleyway between it and adjacent residential and commercial structures on one side, and another alley between it and other residential development at the rear. Vehicular access to the site is obtained from the side alley. Next slide. At 25 feet high, the new city-approved home would be 2 stories consistent with the height allowed by the LUP. The apartment building would be set back 15 feet from the sidewalk along 6th Avenue on the first floor, with additional second-level step backs of up to 24 feet. The side yard setbacks would be 5 feet and the rear yard setback 15 feet. The project observes all setbacks, open space, and height requirements of both the City of Los Angeles Uncertified Zoning Code and the Certified Venice LUP. Next slide. A primary assertion made by the appellant is that the proposed development is incompatible with the mass, scale, and character of the surrounding area and does not protect the special coastal community of Venice. The appellant also raises concerns related to the city's methods of analyzing size, scale, mass, and bulk of the project and cumulative effects of the proposed project on future development in this area of Venice. While the subject block consists of mostly older 1-story single-family residences, there are several larger multifamily and 2-story structures in the neighborhood and along this block, including the 6,299 square foot 2-story 4-unit apartment building located on the adjacent property and a 6,122 square foot commercial building across the street. Next slide. The city's findings utilized a survey of 16 properties in the immediate neighborhood vicinity and identified the site as being unique because of the relatively large size of the joined lots the project would be built across, and it being adjacent to a relatively large multi-unit building along Rose Avenue, and concluded that the development would serve as a quote-unquote transitional lot between the development along Rose Avenue, including the large multifamily development located on the adjacent property previously described and shown here on this slide, and relatively smaller and older homes in the rest of the neighborhood. Staff concur with the city's findings that the unique characteristics of this site would not result in cumulative impacts to the character of the surrounding community, as the development would provide a transition between smaller homes and a larger structure that exists along Rose for passers-by. Additionally, the multifamily apartment complex conforms with the LUP low-medium multifamily land use designation for the lots, concentrates development in an appropriate area, and is consistent with the handful of other similarly sized multifamily structures in the area that contribute to the neighborhood character. Further, although the city-approved project is larger in terms of square footage compared to the single-family homes on this block, it would be of comparable scale and density to the multifamily structure located next door. Moreover, the new structure would incorporate design elements intended to reduce the massing and visual impacts of the project from the street, including the 15-foot setback from the sidewalk, which would be landscaped with trees and other plants, stepped back second floor, articulation and plane breaks in the facade, and a lower height of 23 feet at the front half of the structure. Based on these design aspects and the uniqueness of the site in terms of its adjacency to the larger development fronting Rose Avenue, staff concurs with the city's findings that the proposed development is consistent with the surrounding character of development. There is an addendum for this item which responds to 7 letters received from the appellant and neighboring property owners objecting to the project. The issues raised by the appellant and opponents are substantively similar to the arguments made by the appellant in their appeal, and which have already been fully addressed in the staff report and addendum for this item. Next slide, please. In closing, staff believes that the city provided adequate legal support for its decision to approve the subject project and concurs with the city's findings that the proposed development would not adversely impact the character of the community. Staff therefore recommends that the commission find no substantial issue with regards to the contentions on which the appeal has been filed. The motion to accomplish this can be found on page 5 of the staff report. This concludes the staff presentation. Staff is available for questions. Thank you.
Thank you very much. Okay, are there any ex partes on this item? Seeing none, is the appellant present?
Yes,
Chris
we have Maureen
Fay?
Whalen and Chris Fay in person.
Okay, you all have collectively 3 minutes.
Thank you. May I ask a procedural question? Is everyone here?
Yes, we have quorum.
Okay.
We, as long as we have quorum, 7 out of 12, then we can.
Understood. Okay. Am I going? Ready? Okay. The proposal is grossly out of character with the surrounding neighborhood and raises multiple very substantial issues that warrant a closer examination in a de novo hearing. The staff report cites buildings for comparison to the proposal that are not valid with respect to both size and location. This proposal is 9 to 10 times larger than almost every building on the street. 9 to 10 times larger. It almost seems like the conversation should stop there. It's out of character with the neighborhood, therefore it's not in compliance with the Venice Land Use Plan and by extension not in compliance with the Coastal Act. The staff report cherry picks isolated aspects of buildings and claims that they are reasonable comparisons, the most blatant example being the citing of two-story structures on the block and makes them comparable. Those two-story structures are several hundred square feet. This is 11,000 square feet. Those are the only two buildings cited in the report on the same block. The buildings cited on the parallel blocks of Ruth and Dimmock to the west and east of 6th Avenue are also nowhere near the size of the proposal under consideration. The proposal is roughly 3.5 to 4 times the size of of those buildings in an absolute sense, and to acknowledge it's on a double lot, it is still about twice the size of any other large building anywhere near the proposal in a lot size to building size ratio sense. An interesting note about the buildings on Dimmock. Although they do not establish conformity, they would be a good example of what would fit on the lot and be compatible with the neighborhood. There could be 2 buildings there. It would break up the huge behemoth. The only buildings cited in the staff reports that even come close to the size of the proposals are across the Rose Avenue commercial corridor, significantly smaller, and outside of the north of Rose Avenue neighborhood that has been recognized previously by the Coastal Commission. I cite those instances in my previously submitted written comments. The idea of a transitional lot doesn't exist. There's no such wording or definition or basis of analysis anywhere in the Venice LUP or Coastal Act. All these raise substantial issues, and I urge you to find that there are substantial issues that warrant consideration in a de novo hearing. Larger buildings over time, yes. A 10,000% increase in one jump, no.
Basically, there's one issue here. What is the appropriate geographical area for comparison of bulk, mass, size, and scale? Since 2004, that has been the definition of the Noro neighborhood, north of Rose. The city has changed that dramatically and compares this project in our neighborhood with commercially zoned Rose Avenue and major apartment buildings south of Rose Avenue. The substantial issue is, what is the right area? The city is wrong. It shouldn't have done it. And there is no input on this. This is dramatic change.
Thank you so much. Thank you. Do we have the applicants here?
We have one on Zoom. They're available for questions.
Okay. Are there any members of the public who are signed up who are qualified to speak on this item?
Yes, we have 3 people signed up to speak. Carolyn Famatiga-Fay, who is in person, followed by Robin Rudisil on Zoom and Inga Mueller on Zoom. Carolyn Famatiga-Fay.
Hi, my name is Caroline Famatiga-Fay. I live at 234 6th Avenue.
Can you please step a little bit closer and bring the mic to your mouth? Thank you.
My name is Caroline Famatiga-Fay. I live at 234 6th Avenue, 3 doors north of the subject site. The proposal is over 11,000 square feet, and I believe it raises substantial issues. The proposal is not compatible with the character of our neighborhood. It's not in compliance with the Venice Land Use Plan, not in compliance with the Coastal Act. At 11,000 square feet, this proposal definitely raises many issues. I urge you to find these are that there are substantial issues to examine in a de novo hearing. Thank you.
Thank you.
Thank you. Robin Rudisil on Zoom.
Robin Rudisil here.
NSI for an over 11,000 square foot, 72 foot by 82 foot mass with giant roof deck with 4 roof access structures in a special low scale neighborhood that has been protected by the commission for decades? This is wrong. In case after case, your character analysis uses the 1 to 2 block streetscape. Here, structures outside the immediate area were cherry picked to support a compatibility conclusion, including those in the commercial zone. Also, historically, the Commission has treated north of Rose as a unique neighborhood and not as part of the larger Oakwood subarea south of Rose, which has a very different character, mass, and scale. The LUP speaks of Venice as a group of identifiable, special, and unique neighborhoods and is clear that such neighborhoods are found within the subareas, and thus it is the character of those smaller, identifiable neighborhoods like this one that Coastal Act 3253 states you shall protect. This is not a unique property. The map with our letter shows that several hundred properties, all available for consolidation, are adjacent to commercial zoning in Venice and would be impacted by this decision, as such lots have not been considered transitional in the past. The Commission has been clear that it does not want to fill up the coastal zone with large market rate luxury units adding no affordable housing. LUP 1E3 states the neighborhood scale and massing are to be maintained. To increase density with a structure that is 9 to 10 times bigger than almost every residence on the block violates the certified LUP and Coastal Act Section 3253 and clearly prejudices the LCP. This project degrades and does not enhance community character, a coastal resource that must be protected. Please declare substantial issue and ask for a meaningful reduction in the size of the units so they can break up the mass into 2, 3, or 4 structures that such density would still be increased, but this north of Rose neighborhood special character would be protected. A win-win. Thank you.
Thank you.
And then Majid Nile with the applicant is raising or was raising their hand now in the Zoom meeting. If you would allow them to speak, or
Sure.
okay, Majid Nile from the applicant.
They'll have 3 minutes.
Majid Nile.
Hello?
Hi, I see that you're unmuted now. Go ahead.
Can you hear me?
Yes.
Yeah. I hear the question that the square footage is around 12,000 square feet. But what we have is around 7,300 square feet. That's less than 2,000 per unit for this type of project, which is not unusual. We have only 4 units. And what the other square footage is we have rec rooms in the basement, which are not, you cannot see it. It's underground in the basement. So we have some rec rooms, which they count in as a square footage for the massing. So because we are talking about the massing of the project. So basically, it's less than 2,000 square feet each unit for this type of project. We could not do more than 4 units because it's an R2 lot, but we would have loved to do more units and maybe less square footage. But because it's R2, but it's a double lot, we can do only 2 units per lot. And the square footage is less than 2,000 per unit, which is not too big for standards of today. So basically, and we did take care of the neighbor side. Basically, we reduced the windows on the neighbor side, and then we have alleys on 2 sides, and then we have the street, and we have the commercial on the other side. And we reduced the front setback. We enlarged the front setback on the neighbor side by another 7-8 feet. And we moved the rooftop deck back. Instead of being 5 feet, is now, I don't have it exactly in front of me. I think it's like 12 feet back instead of 5 feet back from the perimeter of the building on the rooftop. So it's all set back from the neighbor side, around, I think it's like 10 or 11 feet setback on the neighbor side. And then we broke up the building in the front and on the side. If you look at the, I'm not sure if you have before and after, we broke up the front so it looks like a 2 building in the front, and on the alley side, we kind of scooped out some square footage by going through several different renditions. So we kind of made it more, broke it up in the front and in the side. So, and then we reduced the rooftop deck stair. We made it slope rooftop, the stair that goes to the rooftop instead of being flat. So we kind of took care of that. And then the front setback, the half of it is 2 feet less height than before. I think it's 23 feet instead of 25 feet. So these are some of the things we did. And
Thank you.
Thank you. Thank you very much.
We are only looking for Inga Mueller as well, but we aren't able to see them. There are no other speakers.
All right, I'll bring it
Thank
back
you.
to the commission and see if commission staff has any response to some of the comments that were made.
All right, thank you. I would like to respond to one of the comments made by the first speaker. He had noted that in his thinking the structure would be 9 to 10 times larger than other structures in the area. And of course, that's the main basis of the appeal, is that this is a very large structure and that their concern is it would be out of character of the area. Now, as noted in the staff report, staff agrees the structure will be larger than the surrounding structures. And we agree 11,000 square feet is large for a structure. However, there's some mitigating circumstances in this case. And we believe with those mitigating circumstances, we do believe this new building will be consistent with the general character of the area, which is a mix of multifamily, single family, and commercial development. It's also important to note that the speaker was discussing single family residences on individual lots. And if those were 1,000 square feet in size, then sure, this building would be 9 to 10 times larger. But this project is for a 4-unit multifamily structure, and it won't be located on one site. It's spread over 2 separate legal lots. So this project is fundamentally different. And I would note that these units, the 4 units, are not exceptionally large. They will be approximately 2,500 square feet in size, which in our opinion is not out of scale with the sizes of units in the surrounding area. We do believe that that's consistent with the sizes of homes, the sizes of apartments, and given the eclectic nature of this area consisting of those businesses that we saw, the commercial buildings, which were also very large, the other multifamily homes, while we agree with the appellant's observations that the structure will be large, we do believe that it is generally consistent with that character of the area. And thus we continue to recommend that the commission find no substantial issue in this case.
Thank you. Okay, I'll bring it back to the commission for questions, comments, and action. Commissioner Boschko, then Commissioner Naldoff.
Yeah, I just have a comment, and I understand how upsetting it must be to have lived in a place for a long time that had a certain quality to it. But we're living in very different times. This is a state that is so underhoused that the legislature has taken a very strong stance in making sure that affordable housing in general, is being produced in ways that perhaps we wouldn't have done in the past. So I'm very supportive of this because I think this is the future. I think we're going to have to figure out ways to do some increase in the density of housing and hopefully still have the character of the community at least reflected in it, which I think in this particular area, because of the industrialization on one side, it's not out of the ken of what it could be. But I just know it's difficult. I want you to understand that it isn't that we don't hear you. Just the times are changing for all of us. Thank you.
Commissioner Naldoff.
Yeah, it's a difficult trade-off. It's a great area, Rose Cafe, near and dear to my heart. Close, okay. Spent a lot of good time there, though, before it closed. And I think that, while I'd like to see some more affordability built into this, I think that's my main concern there. We do need
you know, we have a housing crisis, and you know, this wouldn't, probably wouldn't have designed it this way. It strikes a balance that I understand, that the no substantial issue recommendation. So you know, I do think the staff has made the right call here, but I also think it must be hard to live down the street. But it might not, you know, hopefully it might not be so bad. They might be nice neighbors.
All right, any additional comments? Happy to make a motion. Seeing none, no, we're done with public comment, sorry. I'll just say that I think Commissioner Bochco really summed it up, which is that the state is really putting a lot of pressure on us now. They're removing local authority around land use, and they're really pushing for dense housing in communities. And I mean, we're lucky we still have some authority around housing, because if the state had it their way, they would completely strip us of our authority around housing, and you'd probably get something much more massive and much less compatible with the community. And so what's before us today, I think the staff's done a great job of trying to weigh in as best they can on this project. It could be worse, it could be better, but I think what's before us today is something that we're going to see forward. So with that, I'll turn it to Commissioner Hart for the motion.
Thanks so much. I mean, I think there were changes made at the city level to reduce the size, is my understanding. So, I mean, I think by the time this has gone through the whole city process, they've weighed in. By the time it gets to us, I think, you know, personally, I like the project. I appreciate the comments of my colleagues and the concern, but I think, personally, I think it's a good project. So I'll move that the commission determine that appeal number A-5-VEN-24-0053 raises no substantial issue, excuse me, with respect to the grounds on which the appeal has been filed under Section 30603 of the Coastal Act. I ask for a yes vote.
Second.
So we have a motion by Commissioner Hart, seconded by Commissioner Lowenberg. I'd like to see if there's any commissioner who opposes unanimous approval. Seeing none, this passes unanimously. And with that, we are done for today at 5:46 p.m. I just want to thank everybody for their patience and for being here. I want to thank Billy and the team for always making sure that we are connecting with folks, and we'll see you all tomorrow.